ನನಗೆ ತುಂಬಾ ತೊಂದರೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದಕ್ಕೋಸ್ಕರ ನೀವು ಸಿಕ್ಕಿಲ್ಲ ಅಂದ್ರೆ ಸರ್ ನಾನು ಹೋಗೇ ಬಿಡ್ತೇನೆ. ಈವರೆಗೂ ಬರ್ಲಿಕ್ಕಾಗಲ್ಲ. ತುಂಬಾ ಜನಕ್ಕೆಲ್ಲ ದುಡ್ಡು ಖರ್ಚು ಮಾಡಿದ್ದಾರೆ. ಕಂಪ್ನಿ ಇದೆ ಅಂತ ಕೆಲಸ ಮಾಡಿ 13 ವರ್ಷ ಹೋಗೋದಲ್ಲ.
ನೀವೇನಾದ್ರೂ 15ಕ್ಕೆ ಕ್ಲೋಸ್ ಮಾಡಿದ್ರೆ ತಯಾರಾಗಿದ್ದೀರಾ?
ಸ್ವಲ್ಪ ಫೈಟ್ ಮಾಡೋಣ, ಕೆಲಸ ಕೊಡ್ತೀನಿ ಅಂತಾನೆ ಫೈಟ್ ಮಾಡೋಣ. ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ ತಾಯಿ ಬೆಡ್ಡಿದ್ದಾರೆ, ಹಸ್ಬೆಂಡ್ ಅಂತ ಹೇಳ್ಕೊಡೋ ತರ ಕೆಲಸ ಇಲ್ಲ. ನಾನು ಸ್ವಲ್ಪ ಕೆಲಸ ಮಾಡ್ಕೊಂಡು ಜೀವನ.
Milords, may I kindly instruct the court to unmute, Milords. The court is not audible. Please, Milords.
ಪ್ರಶ್ನೆಗಳು ಮತ್ತೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ರೆಡಿ ಮಾಡಿ ಕೊಡಿ. ಏನೇನು ಅವರಿಗೆ ತೋರಿಸಬೇಕು?
ಅಡ್ಮಿಷನ್ ಏನು? ಇಸ್ ಇಟ್ ಫಾರ್ ಹೊಸ ಮ್ಯಾಟ್ರ್ ಕೊಡಿ, ಹೊಸ ಮ್ಯಾಟ್ರ್. All hand over all new matters. You need not mention for that. Sir, why do you, for what stage you want the matter to be listed? Is it for preliminary? Which year? Kodi. Huh? Notice is issued. Kodi. Kodi adin. Consideration of interim prayer anta hakamadu. Madam, consideration of interim prayer, e matter. E memo.
Will it reach?
ಆಯ್ತು, ಯಾವತ್ತು ಬಿ ಗ್ರೂಪ್ 2023 ಆಯ್ತು ತೋಳು. ಎಸ್ ತೋಳಿ, ಯಾವ್ದು ಡೇಟ್ ಕೊಡಿ. ಬಿ ಗ್ರೂಪ್. ಐ ಡೋಂಟ್ ನೋ. ವಿಚ್ ಇಯರ್? ಕೊಡಿ, ಅದು ಯಾವ್ದು ಬೇಕು. ನೋಟಿಸ್ ಆಗಿದ್ಯಾ? ಐ ಹೋಪ್ ಯು ಹ್ಯಾವ್ ಚೇಂಜ್ಡ್. ಹೋದ ರೋಸ್ಟಲ್ಲಿ ಹೆಂಗಿದ್ರು ಇದೇ ತರ ಹಂಗೆ ಇಲ್ಲ ತಾನೆ. ಈ ಸತಿನು ಸ್ವಲ್ಪ ಚೇಂಜ್ ಆಗಿದ್ದೀರಾ ನೀವು? ಡೋಂಟ್ ಬಿ ಅಡಮೆಂಟ್, ಪ್ಲೀಸ್ ಚೇಂಜ್ ಯುವರ್ ಸೆಲ್ಫ್. ಆಯ್ತು ತಗೊಳ್ಳಿ, ಮತ್ತೇನು ತಗೊಳ್ಳಿ, ಯಾವತ್ತೊಂದು ಡೇಟ್ ಕೊಡಿ. ಕೊಡಿ ತಗೊಳ್ಳಿ. ಬಿ ಗ್ರೂಪ್ 19 ತಗೊಳ್ಳಿ. ಆಯ್ತು 17th ಅಂತ ತಗೊಳ್ಳಿ. 2017. ಏನು ಆಯ್ತು, ಮೆಮೊ ಏನಿದ್ರೆ ಕೊಡಿ. ನಾಳೆ ಡೇಟ್ ಆಗಿದೆ, ಇವತ್ತು ಬಂದು ಹೇಳ್ತಿದ್ದೀರಾ? ನಾಳೆ ಬರುತ್ತಲ್ವಾ? ನಾಳೆ ಬಂದು ಇವತ್ತೇನು ಹೇಳ್ತಿದ್ದೀರಾ? ಓ ಹಂಗೆ ನಾಳೆ ತಗೊಳಲ್ಲ ಬಿಡಿ. ನಾಳೆ ಬರೋದು ಇವತ್ತು ಯಾಕ್ರಿ ಹೇಳ್ತೀರಾ? ನಾಳೆ ಬರೋದು ನಾಳೆ ಹೇಳಪ್ಪ. ವಿಚ್ ಇಯರ್? ಲೆಟ್ ಇಟ್ ಕಮ್. ಎಸ್. Which year? Let it come. Give us some time. It's just 24. There are other people waiting in the queue. Give us some time. Which year? It will come. Yes. Fresh matter, you hand it over. Yes. Kodappa memo kodi. Yes. What is your case? Fresh matter kodi. Yes. It will come tomorrow, mister. It will come tomorrow. Fresh matter. It will come tomorrow. B group. B group. No, sorry. ಆಯ್ತು ತಗೊಳ್ಳಿ. Which year? Bias 22. Told. Please wait. Why? Let it come with ಬಂದಿರೋದು ಮುಗಿಸ್ಕೊಳ್ಳಿ regularization. Huh? Regularization ಅಲ್ವೇನ್ರಿ ಇದು? My dear friend, is it regularization of Anganwadi helpers? But very true, but why you are not listening to what the court says? Is it not a case of regularization? Then why are you arguing when I asked you something? No matter, we can deal with this today. Issue notice issue ಮಾಡಬಹುದಲ್ವಾ? Then ಇಪ್ಪತ್ತಿರ್ಲಿ, ಇವತ್ತು ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಬಹುದಲ್ಲ? Can we dispose of at the preliminary stage? We can't. We have to issue notice to the government. Why are you coming in the way at the adjournment ತಕೊಂಡು? Yes. Yes, I told you which. Take whatever date you want. Very it. Adjournments. Ah.
My lords,
Yes.
seal 48, my lords, I appear for the petitioner in this matter.
2015 matter.
My lords, arguing counsel, my lords, he has a medical appointment, my lords, therefore he is unable to attend. My lords, any short date may be given, my lords.
2015, sorry, no adjournment.
Please, my lords,
Yes.
he has a
You have a
medical.
battery of lawyers in your office, mister.
My lords, arguing counsel, Pradeep is not my lords, he
Go on,
wants
please.
to review the matter himself, my lords. He has a medical appointment, my lords, may kindly take it any date next week, my lords.
Learn counsel for the respondent number 2 and 3 CX time. List on.
Serial number 40, my lord. Serial number 40, Mr. Leela Krishna, who was appearing for respondent number 2, is no more. I will inform Mr. His colleague whether he could able to file wakalat or not.
Hopefully they learned,
I'll get time, kindly go back.
we learn counsel for the respondent number 2. Is no more. Issue emergent notice to, issue court notice to the respondent number 2 to make suitable arrangements for his appearance. Full stop. Yes, next.
My lords, serial number 52 and 53 as well, my lords.
So at least argue in one matter, mister. At least one matter.
Lords,
At
Senior-
least one.
Lord Senior himself wanted to appear for the matter, my lords, therefore he has a medical emergency, so he had to.
Learn counsel for the respondent number 2 and 3. 6 time. See number 52, 53 number.
Please, my lords.
Yes. Learn counsel for the petitioner 6 time. One week time is 1 ವಾರ ಸಾಕ ನಿಮಗೆ? 2 weeks time is granted to do the needful. Do whatever you want. Tyagaraja. 2 weeks, 1 week. 2 weeks. 2 weeks. 1 week. Oh, no, 2 weeks. 1 week time is granted to do the need. 2 weeks. Two weeks time is granted to do the need. ಸರ್ವಾಗಿದೆಯಾ? Issue court notice to the petitioners. to make appropriate arrangements for their appearance. Next. Same order, same order. Notice issue ಮಾಡಿದಾರಾ? The memo of retirement filed by the advocate for petitioner is perused. The learned counsel has issued, the notice of retirement issued to the petitioner is duly served on the petitioner. Hence, the memo of retirement is accepted. Office is directed to show the name of the petitioner after deleting the name of the learned counsel for the petitioner. Same order. The letter dated so and so, addressed by the letter dated 18/1/2025, addressed by the District and Sessions Judge Mysuru is perused. The time for disposal of OS number 641 of 2010 is extended by 6 months from the date of receipt of 4 months, 4 months from the date of receipt of a copy of this order. Madila. Yes, the acknowledgement is not filed. Notice of retirement, is it served on the respondent? Who are you? What is your name? You are R.V. Naik. The memo of retirement filed by Mr. B.S. Pramod for R1 and R2 is accepted. Hence, office is directed to delete the name of Mr. B.S. Pramod and continue the name of Mr. R.V. Naik for R1 and R2. Suyog Herale. A memo of retirement is filed by the learned counsel for the petition. Sarvagidya. Since there is no proof of service of notice to the petitioner, the memo of retirement is rejected. Narayan Bhatt, Appaya, P.B. Appaya. There is no representation for the petitioner and respondent, number 1. 1 week time is granted to comply the office objections. Shakti Deepak, 2022, first time. 1 week time is granted to do the needful, failing which the petition against the respondent shall stand dismissed. Same order. MP Srikanth, non-filing of amended petition. 1 week time is granted to do the needful. A.V. Muralidhar, yes. Now, why do you want the petition to be disposed of? We have to hear the other side. We have to hear the other side. Yes. You're ready? Yeah. Yes, are you ready? What is sought for in the petition?
Supreme Court finally held that they are also entitled to order. And the acknowledgement do not have this one. This acknowledgement connection break do not be connected Similar acknowledgement has been filed for disposal of court.
Yes, can it be disposed of on the same terms? The petitioners have sought for a writ in the nature of certiorari to quash the endorsement bearing number so and so dated 22/2/2017 issued by the respondent number 3. In the endorsement bearing number so and so dated 25/2/2017 issued by the respondent number 2. They also sought for a writ in the nature of mandamus to direct the respondents to extend the revised UGC pay scales of 1996 to the petitioners by fixing their pay at rupees 14,940 as and when they have completed 5 years of service as selection grade physical education directors as per the Government of India dated 6/11/1998 and as per the judgment of this court in WP number 5855 of 2008, and to grant consequential monetary benefits such as arrears of salary and retirement benefits, etc. Full stop. Next para. The petitioners contend that the Government of India, vide its letter bearing number F-1-21/87 UI dated 22/7/1988, had informed all education secretaries in the country to sanction UGC pay scales with effect from 1/1/86 to the teachers, librarians, and physical education instructors in universities and colleges in the country. It had prescribed a similar pay scales for teachers, librarians, and physical education instructors. Full stop. It was stated in Appendix 2 to the said letter that librarian and physical education personnel of a college who had put in 8 years of service would be placed in senior scale, and a librarian and physical education personnel who had put in more than 8 years and who did not possess PhD would be placed in scale of selection grade. Similar provision had also been made in case of teachers. It is contended that following the above, the state government had issued an order in the year 1990 and 1991 extending the revised UGC pay scale with effect from 1/1/1986 to the teachers, librarians, and physical education instructors in government and aided colleges under the control of the Department of Collegiate Education. Full stop. The petitioners contend that physical education instructors and librarians are also performing duties similar to that of teachers and were drawing salaries similar to teachers. Full stop. They contend that on the directions of the UGC, the respondent number 1 passed orders dated 17/11/97 and 27/6/1998, treating physical education instructors and librarians on par with teachers. Full stop. Petitioners contend that the revision of pay scale was to be given effect with effect from 1/1/1996. Accordingly, the Government of India addressed a letter bearing number F-1-21/87 UI dated 27/7/1998 to all education secretaries sanctioning the UGC pay scales of teachers in universities and colleges. Full stop. The petitioners contend that though the librarians and physical education personnel were treated as teachers by the Government of India, UGC, and the state of Karnataka in terms of the orders referred above, the pay revision letter dated 27/7/1998 had also referred to them as double and comma revision of pay scale of teachers, which included librarians and physical education instructors. However, in the latest revision, it was stated that a lecturer of a college who had put in 6 years of service would be placed in senior scale, and a lecturer who had put in 5 years of service and who does not possess PhD would be placed in scale of selection grade. Likewise, provision was made in case of physical education directors and librarians also. Full stop. It was mentioned in the letter dated 27/7/1998, referred supra, that the revised scales of pay would given prospective effect from the date of issuance of the letter. This was followed by letter addressed by the Government of India on 22/9/1998, clarifying that the allowances other than DA would be admissible with effect from 1/8/1997. Full stop. It is contended that in supersession of the above letter dated 22/9/1998, and the Government of India addressed a letter bearing number F.1-22/97/U.I dated 6/11/1998, stating therein, page 23 in copy, madam, red line. It is therefore contended that full stop. It is contended that the UGC had issued a notification dated 24/12/1998 applying the above communications. Full stop. Again, your writ petition doesn't seem to end. It goes on and on and on and on. Bande, please wait. Full stop. The petitioners contended that in the letter dated 6/11/1998 addressed by the Government of India, it was provided that the fixation of pay of lecturers (selection grade) (readers) in the pre-revised scale of rupees 3700-125-4950-150-5700 were selected strictly in accordance with the rules and regulations framed by the UGC, and who were working as lecturers (selection grade) readers as on 1/1/1996 would be made in a manner that they would get their pay fixed at the minimum of rupees 14,940 in the revised scale of rupees 12,000-420-1800 as and when they complete 5 years in the grade. Full stop. The petitioners contend that the only criterion for fixation of pay at rupees 14,940 was that a lecturer/librarian physical education person should be in the selection grade prior to 1/1/1996. Full stop. Next paragraph. The state government issued a government order dated 15/11/1999 following the communications addressed to it by the Government of India, extending the revised UGC pay scales with effect from 1/1/1996 to the teachers, librarians, and physical education instructors in government and aided colleges. Full stop. Full stop. Contrarily, the the pay scale of librarians and physical education personnel who had completed 5 years of service in that grade as on 1/1/1996 were fixed at rupees 14,940 with effect from 1/1/1996, and also as and when they had completed 5 years of service in selection grade. However, in some areas, they were denied the fixation of pay scale at rupees 14,940, stating that the fixation has been provided only for lecturers. Full stop. It is contended that the issue of denial of pay scale at rupees 14,940 with effect from 1/1/1996 came up for consideration before a coordinate bench of this court in WP number 5855/2008. Full stop. The coordinate bench referred to the judgments of the Supreme Court and the High Court and held that the petitioner therein was entitled to for fixation of pay at rupees 14,940 with effect from 1/1/1996. Full stop. This judgment was challenged in Writ Appeal 3750 of 2009. Full stop. The division bench, after considering the contentions urged therein, rejected the contention of the state government and held that the government order should not be read in isolation, but should be read in conjunction, giving weightage for the persons who had put in longer period of service, which was more than 5 years. It is contended that the judgment of the following the judgment of the division bench, the state government refixed the pay scale of the petitioner in WP number 5855 of 2008, subject to the outcome of the special leave petition that may be filed. Full stop. The judgment of the division bench was then challenged in WP number SLP Civil 8211/2011. Full stop. The Honorable Supreme Court dismissed the special leave petition on 12/5/2011. The petitioners contend that following the judgment of the division bench, which was upheld by the apex court, this another coordinate bench of this court in WP number 65861-62 of 2012 was pleased to grant the reliefs. Following the above, the respondents are stated to have implemented the order and have granted pay scale and have fixed the pay scale at rupees 14,940 with effect from 1/1/1996. Full stop. The petitioners therefore contend that they are also entitled to be treated similarly, and their pay scale is also liable to be revised, and they are entitled for revision of their pay scales. They are also entitled for revision of their pay scales and to be fixed at rupees 14,940 with effect from 1/1/1996. So, in support of these contentions, the learned counsel for the petitioner relied upon the judgment of a coordinate bench of this court in WP number 3271/2020 and contended that in similar circumstances, this court has granted the relief, and therefore the petitioners will also be treated on par. Next para. The learned GA, government advocate or government advocate for the respondents, submits that the issue is squarely covered on all fours by the judgment of the division bench of this court, which was upheld by the Honorable Supreme Court. Full stop. In that way of the matter, this writ petition also deserves to be disposed of on similar terms Consequently, the following order is passed. Writ petition is allowed. The impugned endorsements issued to the petitioners bearing number so and so, dated so and so, are quashed. The petitioners are entitled for refixation of their pay scale at rupees 14,940 with effect from 1/1/1996. Full stop. This shall be complied within a period of 3 months. It is needless to mention that the petitioner shall be entitled to all consequential benefits. This shall be complied within 3 months from the date of receipt of a copy of this order. Please sit down. Please sit down. We are at 19. What makes you think you can breach the queue, mister? We are at serial number 19. If you have anything to say about 19, you can say.
No, my lords, in serial number.
Don't go back. Wait for your turn.
Appearing for petition, my lordship, we are not pressing the interim prayer, my lordship.
A non-compliance office objections.
The interim prayer as well as main prayer is one and the same, my
The
lordship.
learned counsel for the petitioner submits that the petitioners would not would not press the interim prayer. In that way of the matter, office objection is overruled. In case any other.
But
Huh? Take notice. AG is directed to accept notice for the respondents. Yes.
Filed an application for an early hearing.
One
Date
of
may be fixed.
24 is for early hearing. Petition admit agilwala.
Right, notice was ordered.
Has
Thereafter,
it
Lords,
been
I have
admitted?
filed the synopsis and all in the matter, Lords,
But I-
matter requires.
Petition is not admitted, hence IA 1 of 24 is rejected. List the petition for preliminary hearing in B group on.
Any day. 14th, Lord.
14th,
No, not on 14th, Lord. 18th. Lord.
18th March.
Please, Milords.
Petition.
Yeah, condonation. Barcode IA 1 of 25 is filed for condonation of delay in filing the application to recall the order dated so and so by which the petition was dismissed for non-constitution. The cause shown for the delay is produced. The petitioner has claimed that she could not contact her advocate due to a medical condition and due to her financial stringency, she could not come to Bangalore for filing necessary application for recalling. The cause shown is accepted. Consequently, the delay in filing the application is condoned. In view of the order passed on IA 1 of 25, IA 2 of 25 is also allowed and the order dated so and so is recalled. Finally, 1 week's time is granted to comply.
2 weeks.
2 weeks' time is granted to comply the office objections, failing which the petition shall again stand dismissed.
Please.
The 2019 petition, Victor. Subramanya Bhatt. Notice ಹೋಗಿದ್ಯಾ IA ಮೇಲೆ? ಅಲ್ಲ IA ಮೇಲೆ ಹೋಗಿಲ್ವಾ? IA 1 of 24. Issue notice on IA 1 of 24.
Also have filed an application for early hearing.
Same order.
18th, May,
Serial number
21.
21 order, same.
I'm grateful.
T. Karnataka. But does this survive for consideration? So this is a 2014 matter. This writ petition is filed in the year 2014. So does it survive for consideration? Matter relates to selection. Pass over. Lakshmikant,
For petition.
yes, BL Sanjeev. BL Sanjeev. Burn transfer waste oil. You're still in service.
ಇವಾಗ ತುಮಕೂರಲ್ಲಿ ಇದೆ.
ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಹಾ ಮೇಡಮ್, ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಮಾಡಕ್ ಇದು ನಾವು ಮಾಡ್ತಾ ಇದ್ದೀವಿ. 2010 ಆಗಿರೋದು ಇನ್ಸಿಡೆಂಟ್ ಮೇಡಮ್. 13 ವರ್ಷ ಆದ್ಮೇಲೆ ಈ ಕಂಪ್ಲೇಂಟ್ ರೈಸ್ ಮಾಡಿದ್ದಾರೆ.
ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಇದ್ರೆ ಮಾಡ್ಬೋದಲ್ಲಪ್ಪ.
ಅಲ್ಲ, ಈಗ ನಾವು ಮಾಡಿದ ಯಾವಾಗ ಎವ್ರಿ ಇಯರ್ ಆಡಿಟಿಂಗ್ ನಡೆಯುತ್ತೆ ಆ ಟೈಮಲ್ಲಿ ಯಾವ್ದು ಅಲಿಗೇಷನ್ ಅಷ್ಟೊಂದು ರೇಟ್ಗೂ ಹೋಗೋದಿಲ್ಲ. ನಾವು ಕೊಟೇಶನ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಮೇಡಮ್. ಅದು ಕೆಟ್ಟೋಗಿರೋ ಟ್ರಾನ್ಸ್ಫರ್ ವರ್ಕ್ ಆಗದಿರೋದು ಅದನ್ನ ಇದ್ ಮಾಡಿದೀವಿ. ಮತ್ತೆ ಆಯಿಲ್ ಇದ್ ಮಾಡಿದೀವಿ.
ಕರೆಕ್ಟ್, ಅದನ್ನೆಲ್ಲ ನೀವು ಲೆಕ್ಕ ಕೊಡ್ಬೇಕಲ್ಲ.
ಲೆಕ್ಕ ಎವ್ರಿ ಇಯರ್ ಆಡಿಟಿಂಗ್ ನಡೆದಿದ್ದು ಲೆಕ್ಕ ಕೊಟ್ಟಿದ್ದೀವಿ ಮೇಡಮ್.
Learn counsel for the response 1246 list on. ಯಾವತ್ತು ಬೇಕು ಕೇಳಿ, whatever date you want. When do you want? ಯಾವತ್ತು ಬೇಕು ಹೇಳ್ಕೊಡ್ರಿ, ಯಾವತ್ತು ಯೋಚನೆ ಮಾಡ್ಲಿ ಅವ್ರು. ಎಸ್, ನೆಕ್ಸ್ಟ್. ಮಧ್ವಾಚಾರ್
Capable.
ಅದೇನೋ ಕಾಸ್ಟ್ ಕಟ್ಟಿಲ್ಲ ಅಂತಿದ್ರೆ.
Annexure B, in page 18.
ಹಾ,
The respondent recovered the amount from the DCRG of the petitioner.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಯಾರು? ಎಸ್ಕಾಂ ಯಾರಿದೆ? ಇಲ್ಲಿ ಪ್ಯಾನಲ್ ತಗೊಳ್ರಿ. ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗದೆ ಯಾರು? ಎಲ್ಲ ಅಪಿಯರ್ ಆಗ್ತಾರ?
Sanjeeva ಇದ್ದಾರೆ.
ಎ ಚಂದ್ರಚೂಡ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಅಕ್ಸೆಪ್ಟ್ ನೋಟಿಸ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್. ಒಂದು ಕಡೆಯಿಂದ ಕೊಡ್ಕೊಂಡ್ ಬರ್ತೀನಿ.
Petitioners are Anganwadi workers, my lords. They have been working in Udupi district, my lords, in Karnataka. Page number 119, my lord. There is a growing disparity, my lords, in payment. Is one judgment of Gujarat High Court, my lords, which I would like to draw your lordship's attention.
What is growing disparity? First ಅದನ್ನ ಹೇಳಿ.
My lord, the disparity is, my lords, in some states, ICDS scheme of central government. In some states, they pay 26,000. In Karnataka, they are paid 11,600. Anganwadi workers are paid 6,500, depending upon service. It is far less than minimum wages, my lords, prescribed by the government. Now there are two judgments, my lords.
How many hours of work you do in the Anganwadi?
My lord, 6 hours, 7 hours, 8 hours, depending upon the.
As per the notification, or
Please.
how many hours of work you have to do?
From 9 o'clock in the morning to 3:45 minutes.
ಎಷ್ಟಾಗುತ್ತಲ್ಲಿ?
My lord, ಆರು ಮುಕ್ಕಾಲು ತಾಸು ಆಗುತ್ತೆ ಸಾಹೇಬ್ರೆ. My lord, we have given representation, my lords, in section A1 to A34. That was not considered. It was given in December 2024. There is one gratuity judgment of Honorable Supreme Court in 2022.
But when it comes to,
Please.
when it comes to other matters, you say you're not it's not a civil post.
My lord,
ಬೇರೆ matters ಬಂದಾಗ, when it comes to, for example, recruitment, where residence is treated as a criteria, you say it's not a civil post. When it comes to treating on you on par, you say you treat it as government servants.
my lord, it is a post, vacant post they were appointed. They are the local candidates.
AG is directed to accept notice for respondents
2 to 4.
2 to 4. What about R1?
R1 is already served, Government of India, my lords. B. Pramod is already noted in the cause list.
List this petition along with WP numbers.
My lord, 5041 of 2025.
Next.
Please.
ಇದಕ್ಕೆ ಯಾಕೆ adjournment ತಗೊಳ್ರಿ?
Hello, Saibra.
Why do you ask for an adjournment for this simple thing?
I'm sorry, my lords. Simple matter.
Lord, I pay for the petitioner in this case.
And you want this matter to be again listed, which you can avoid, isn't it? Sum adjournment ಕೇಳ್ಬೇಡಿ.
Lord, I pay for the petitioner in this case.
Ah.
The petitioner was working as a scientist in the Indian Council for Agriculture Research, Bangalore Center. While he was working, he was requested to be a chairman of a tender evaluation committee.
Called AJ, learned additional solicitor general, sorry, DSG, DSG has drafted accept notice for respondents 1, 2, 3, and 4. I have sought for an interim prayer.
No, my lord, I have not.
For the petitioner in this case,
Yeah, the WP is the order.
Swami,
Which is the order passed in WP?
it's a similar petition filed by
No.
this court.
Where is the order passed in WP number 7047?
It's a writ petition number 35.
Please come to Annexure G. That is the impugned order.
Annexure G, Your Honor.
Alva?
Yes, sir.
ಓದಿದ್ರ Annexure G na?
Yes, Your Honor.
ಓದಿ ಹೇಳ್ತದೆ. ಉಲ್ಲೇಖ ಓದಿ.
ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ನ್ಯಾಯಾಂಗ ನಿಂದನಾ ಅರ್ಜಿ ಸಂಖ್ಯೆ CCA ನಂಬರ್ 87/2025.
ಆಮೇಲೆ
ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 7047/2023.
ಅದೆಲ್ಲಿದೆ? 7047 ಎಲ್ಲಿದೆ?
Swami, it's already disposed, Your Honor.
ಎಲ್ಲಿದೆಪ್ಪ ನೀನ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ? Why don't you give it?
Yes.
Okay. Do you recollect what is held in WP number 7047?
Yes, Your Honor.
Ian, what is it held? It's already disposed of as what?
It's not to relieve from the where they are working.
ಎಲ್ಲಿದೆ ಆರ್ಡರ್?
In the
ಅದು
next.
ಮುಖ್ಯವಾಗಿ ಅದನ್ನೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು, ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲ್ವಲ್ಲ? ಪಾಸ್ ಓವರ್, ಪ್ರೊಡ್ಯೂಸ್ ಇಟ್. Whatever it is, I don't know what is that order. If that Annexure G is based on that order. ಅದನ್ನೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲ್ಲ ಅವರು. ಪಾಸ್ ಓವರ್.
Appear for petitioners in this case, Lord.
Hmm.
Lord, as per the order passed by the second respondent on 3/4/2020, Annexure EA page 22, Lord.
Hmm.
These petitioners have been appointed as the members in the District Consumer Forum, Lord. So thereafter, this Annexure EA page 22, Lord.
What is your right for continuation?
Lord, this because for that Consumer Protection Rule 22, Lord. Annexure C page 37, Lord.
Page 37.
Yes, Lord.
Ah.
Sub-rule 2, Rule 10 of that rule is very clear, Lord. Page 37, Lord.
Ah.
Page 37.
Yes.
Sub-rule 2, Lord. Lord, kindly see. Every member of the sub-rule 2. Page 13. Every member of the State Commission and the President and every member of the District Consumer Commission shall hold the office for a term of 4 years or up to the age of 65 years, whichever is earlier, and shall be eligible for reappointment for another term of 4 years, subject to the age limit of 65 years, and such reappointment shall be made on the basis of the recommendations of the selection committee. This issue has been raised before this apex court, Lord. Annexure E, Lord. Annexure E page 63, Lord. Apex court. Lord, Annexure E page 63. Lord, kindly see.
Yes.
The page 64, Lord. The interim order has been passed by the apex court on 27/6/24, page 64, Lord.
Yes.
Lord, kindly come to that operative portion is at page 66, Lord.
Yes.
66, Lord, that second, Lord, we have perused the interim order dated 10th November 2023. We make it clear that the benefit of the interim order will be available to those president, chairman, and members who are actually in service on the date of impugned judgment. That means on 20th October 2023, provided the second term has not been expired. We make it clear that the benefit of interim relief granted by the order dated 10th November 2023 will not be available to those who have completed their second term. We also make it clear that those who are yet to complete the second term, any may complete in terms of the interim order. but they will cease to be the president or member as the case may be immediately on completion of their second term. In short, no one is entitled to continue for third term extension on the basis of the interim order of this court. This is the order. Thereafter, my lord, the coordinate bench of this court, my lord, this grant by considering the apex court decision, my lord, is granted the interim order on 25th, my lord. Madam. The similar identical case, my lord, they are also approached this court. The court has granted the interim order, Lord, on 27th February 2025, my lord. The second page, my lord, kindly see.
Based on recommendation selection committee ನಿಂತಿದಲ್ಲ ಅದಕ್ಕೆ ಅದ್ರ ಬಗ್ಗೆ ಏನು? Suppose if some member
Yes, my lord.
is not suitable or not doing proper work, ಅವ್ರನ್ನ ಹೆಂಗ್ ಡೀಲ್ ಮಾಡೋದು?
ಇಲ್ಲ, selection ಅಲ್ಲಿ already in view of this apex court decision, my lord,
That's
if
okay.
they are not that completed their year of 65 years, if they are already in continuing for second term.
You didn't understand what I said. Suppose if in the second term, the selection committee feels that the member doesn't deserve. And the situation in
Till that whatever because for that with regard to that review petition also the matter has been reserved for judgment before the apex court. That is also pending for
Lords, the context of the
pronouncement
other
of judgment.
interim orders that was passed by the Supreme Court was in the context, my lords, of the Bombay High Court judgment, my lords, where the rule itself was struck down. But Bombay High Court granted stay of the judgment passed by it, where the rule was struck down. Finally, my lords, matter was pending in the Supreme Court and it's been reserved. In the meantime, my lords, there was an issue. Kindly see Annexure L, page 116. My lords, this was in a PIL that was filed before this honorable court. My lords, may kindly see, my lords, I'll just
Yes.
page 116, my lords. Para 3, my lords. In the memo, it is stated that the state government has constituted the selection committee under Rule 6(1) of the Consumer Protection Qualification for Appointment Method of so and so, Rules 2020 for the purpose of filling up the vacancies. Along with the memo, the notification dated 24/7/2024 issued by the Undersecretary of the Government of Karnataka, so and so is produced, which reflects that under the chairmanship of a judge of this honorable court, as required, a 3-member committee is formed. Then an additional government advocate submits that not only that the committee is constituted as above, the committee has already started the process for making the appointments. When the committee constituted and the state government are in the process of dealing with the subject, the grievance of the petitioner would be attended. The present petition is
What
disposed
was
of.
this petition filed for?
My lords, this was filed, my lords, for the purpose of to fill up the
vacancies.
vacancies, my lords, of president and members, my lords, including lady members of all the prayer is at, my lords, bottom of page 116.
Lord, one submission, Lord. This is in
Complete.
sorry, Lord, extremely.
116 ಅಲ್ಲಿ bottom of the page, my lords, the writ petition. Now, my lords, insofar as the petitioners are concerned, they have given representations. Selection committee has been constituted, and in terms of the new act and rule,
When is the term of these petitions going to end?
my lords, as per their statement,
But this
made
PL,
on-
Lord, with regard to that fresh recruitment, Lord, not in the respect of the persons who are already in
Okay,
service.
when is your appointment likely to end?
That today evening, Lord, Annexure A, Lord, and page 22, Annexure A, page 22. Is the order passed by the second respondent, Food and Civil Supply and Consumer, second respondent.
You continue,
please, my lords,
till you subject them to selection process.
please, my
To
lords.
continue them.
Yes.
ಇಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ ಖಾಲಿ ಆಗ್ಬಿಡುತ್ತೆ. It will be
ಖಾಲಿ ಆಗುತ್ತೆ. See,
Please.
the rules provide for extension.
Yes.
rules
But
provide for it.
Selection committee is satisfied.
Please, my lords.
So let them continue, let them appear before the selection committee.
Please.
If the selection committee is satisfied, let them continue
Please, my
for
lords.
the
In
next
fact,
term.
Selection committee has, I'm told, my lords, I'm informed that insofar as the president of the State Consumer Forum, the process is completed, sent to the government. Insofar as the remaining posts are concerned, my lords, they're in the process of issuing the advertisement. Now, there also, my lords, in respect of the vacancies and in respect of renewal also, whoever have sought for a second term, my lords, it could be considered. Till that time, my lords, it can be limited because otherwise, my lords, there will be a.
That is right. We will only say
Please,
that till the selection committee decides the suitability of these petitioners,
please,
they shall be continued.
please, my lords. That could be a fair order.
Can we dispose of the writ petition?
In apex court also, Lord, there is a specific
My lords,
direction.
It could be disposed of.
For full.
Alva?
The petitioners are members of various district consumer disputes redressal commissions in the state, and whose appointments are due to come to an end today na?
Yes, Lord, Annexure A, page 22, Lord.
ಇಲ್ಲ, page 7 ಅಲ್ಲಿ ಟೇಬಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ, page 7 ಅಲ್ಲಿ.
7 ಅಲ್ಲಿ ನೋಡಿದೆ.
Literally, sir. Annexure A page 22 is the
And
appointment. order.
tomorrow, today and tomorrow,
Today and tomorrow, my lord.
full stop. All the petitioners contend that the consumer protection rules as amended by a notification
Annexure C, my lord.
when they dated 15th September 2022.
15 September 2022.
ಅದೇ ಹೇಳಿದ್ದು ನಾನು. Provided for reappointment for another term of 4 years, subject to the maximum age limit of 65 years and subject to the recommendation of the selection committee. The petitioners they all submitted representations seeking for continuation of their service for the next term of 4 years. And that the same is not considered till date. And therefore, the petitioners are before this court seeking for appropriate directions to the respondents to continue their services. Full stop. Next, for the learned counsel for the petitioners reiterated the above and contended that the Honorable Supreme Court in SLP 25612/2023, while considering a case from Bombay, had granted an interim order in similar circumstances
Page
and
64.
continued the service of the members for the next term of, for the second term. He therefore contends that the petitioner is also entitled to be treated alike. He further submits that a coordinate bench of this court in WP number 101539/2025 had granted the relief to the petitioners therein based on the interim order passed by the Honorable Supreme Court in SLP number 25612/2023. Thus, he contends that the petitioner is also entitled to be treated alike and hence prays for appropriate orders. Next, for the learned AG representing the respondents submit that the
My lord, sir, my
the Honorable
submission,
Division,
my submission is that the context of the interim orders given by the Supreme Court is different. But be that as it may, my lords, we will place these representations before the selection.
admits that the Honorable Supreme Court was had granted the interim reliefs in a different context, and that has no bearing with the facts of this case. They are bearing on the facts of this case. He further contends that in respect of vacancies of members in various consumer dispute forums, my public interest litigation was filed before this court, and the Honorable Division Bench in Writ Petition 16634 of 2024 had taken cognizance of the fact that the state government had constituted a selection committee and that the grievance of the petitioners therein would be looked into by the selection committee. He contends that the Division Bench therefore disposed of the writ petition in view of the fact that the committee was seized of the matter. Full stop. The learned AG therefore submits that the issue of the the representation of the petitioners would also be considered by the selection committee. Next. A perusal of Rule 10(2) as amended by the notification dated 15/9/2022 reads as follows. Page number 37, red line number. Full stop. It therefore, a reading of Rule 10(2) makes it apparent that the members are eligible for reappointment for a second term of 4 years, subject to the age limit of 65 years and subject to the recommendation of the selection committee. Full stop. The petitioners have submitted their representations before the respondents seeking for reappointment for the second term. Full stop. It is needless to mention that such reappointment is not automatic, but should be based on the recommendation of the selection committee. Now that the learned AG submits that the selection committee is constituted, since the term of the petition is due to end by today and tomorrow, it is appropriate to dispose of this petition by directing the respondents to continue the services of the petitioner till the selection committee makes appropriate recommendations regarding the continuance of the petitioners as members of the
Various district. forums.
various district forums in the state of Karnataka.
Yes.
The writ petition stands disposed of on the above terms.
That's one observation. All the representations were not given to the selection committee. The respondent number 2 has to be directed to place all the representations.
The
before the selection.
respondent number 2 is directed to place all the representations filed by the petitioners before the selection
Selection, please.
committee for appropriate consideration and appropriate orders.
Please, grateful.
For the petition. My lord, one K. Nagraj was working as lane.
How old are you? ಎಷ್ಟು ವಯಸ್ಸು ನಿಮ್ಗೆ?
By
You're
April,
still a minor.
he completes 18 years on 23/4/2025, my lord, within 1 month. So he
Yes.
is also entitled for compensated grounds thereafter. Within 1 year, he has to apply according to rules. But in the meanwhile, if respondent number 1 or 2 get everything, the respondent number 2, the son will be deprived of all the benefits, man. And in the writ petition, I was not made a party. The respondent number 1 only file a petition, and on the basis of direction issued in writ petition, the authorities are taking immediate steps to grant all benefits to R1, my lord. That's why I have come before the court for.
A BL Sanjeev is directed to accept, issue emergent notice to respondent number 1. AJ for R2, BL Sanjeev for R3, 4, 5, 6,
7.
7. 7 ಹಿಂಗ್ರಿ ಬರ್ತಾರೆ. AJ for R2 and R7.
Okay.
You can take notice for accountant general. 4 and 7. Principal accounts 2, 4 and 7. BL Sanjeev for the other respondents.
The private respondent, one Mr. Pradeep Casey had appeared.
Pradeep Casey is directed to accept notice for respondent number 1.
I pray for interim order, my lord.
What
Let them not-
interim order?
Let them not take in action.
No.
They have referred the matter to the police for verification.
Yes.
And they have also asked for authenticity of the educational certificate issued by the respondent 1, my lord. They are likely to complete the process by this week, my lord, I apprehend.
Pradeep is serve ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ.
If order to be passed, my lord, then.
You
this
serve
request
Mr.
will-
Pradeep, who is the advocate for respondent number 1 in the earlier petition.
I'll sir,
List on ಯಾವತ್ತು ಬೇಕು?
I have next week,
ಹೇಳಿ ನಿಮ್ ತಾರೀಖ್ ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ.
10th.
10th, list on 10th.
But in the meanwhile, they shall not precipitate the action.
No, next. Stay SN but.
Similar matter has been disposed.
What is? The petitioners have sought for writ in the nature of certiorari to quash the order bearing number so and so dated 5/7/2005 passed by the respondent number 3 as well as the order dated bearing number so and so. Order in appeal numbers 9/2007-8 dated 17/12/2007 passed by the respondent number 2. And for a direction to the respondent number 2 and 3 to approve the appointment of the petitioners in the post of assistant teacher in the school run by the respondent number 4. Next paragraph.
Lordship, my senior is no more in this matter.
Dispose as similar matter.
Similar matter.
I will get an instruction and I will undertake to file wakalat.
2003 ನೋಡ್ ಹೇಳ್ರಿ ಪಾಸ್ ಓವರ್ 2013 ಮ್ಯಾಟರ್ ಪಾಸ್ ಓವರ್ ನೋಡಿ
Day after tomorrow ಹಾಕಿದ್ರೆ ನನಗೆ
ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ
I'll
ಇಲ್ಲಿದೆ
go through it and I will have a
ಟುಡೇ
ನಂದು ವಕಾಲತ್ ಇಲ್ಲ ಅದರಲ್ಲಿ.
ವಕಾಲತ್ ಇದ್ರೂ ಪರವಾಗಿಲ್ಲ ಹೇಳಿ
ಪ್ಲೀಸ್.
ನೆಕ್ಸ್ಟ್ ಎಸ್ ಕೆ ವೆಂಕಟರೆಡ್ಡಿ
Number 4 it is. Or respondent number 4 it is.
ಪಾಸ್ ಓವರ್ ಏನಿದ್ರು
The
ಡಿಸಿಪ್ಲಿನ್
matter may be taken up on Thursday.
ಫಸ್ಟಿಕ್ ಎನ್ಕ್ವೈರಿ
The matter may be taken up on Thursday.
ನೋ ಸಾರಿ
Because copy is not there.
ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ ಇವತ್ತು ಮುಗಿಸಿ 2012 ಎಲ್ಲ ಇಟ್ ಶುಡ್ ಬಿ ಆನ್ ವಾರ್ ಫುಟಿಂಗ್ ಮಿಸ್ಟರ್ ಶಂಕರ್ ರೆಡ್ಡಿ.
Will not kindly pass over.
ಪಾಸ್ ಓವರ್ ಸುಬ್ರಹ್ಮಣ್ಯ ಭಟ್
Pass over, your lordship.
ಪಾಸ್ ಓವರ್ ಗೋಪಾಲ್ ಕೃಷ್ಣ
My lord,
Hmm.
the petitioner was working as a security, my lord, from 2/11/1990, more than 35 years.
Yes.
At annexure A, my lord, page number 12. This is appointment letter,
ಅನಕ್ಷರ್ ಏನಾ
page 12. On 2/11/1990, ನಮ್ಮ ಸಂಸ್ಥೆಯ ನಡೆಸಿರುವ ಹೊಸ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಕಾವಲುಗಾರ ಹುದ್ದೆ ನೇಮಕಾತಿ ಮಾಡಿರೋ ಬಗ್ಗೆ ಮೇಲ್ಕಣವಿ ಸಂಬಂಧಿಸಿದ ಕೆ ಜಗನ್ನಾಥ ಇವರು ನಮ್ಮ ಸಂಸ್ಥೆಯ ಸುಬ್ರಹ್ಮಣ್ಯೇಶ್ವರ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಸುಬ್ರಹ್ಮಣ್ಯ ಸುಳ್ಯ ತಾಲೂಕು ಇಲ್ಲಿಗೆ ತಾತ್ಕಾಲಿಕ ಕಾಯಂ ಕಾವಲುಗಾರ ಹುದ್ದೆಯಲ್ಲಿ ಕೆಲಸ ಮಾಡಲು ನೇಮಕ ಮಾಡಿದೆ. This appointment letter. The salary was, my lord, at page number annexure B, page number KJ 9th serial number 9. K Jagannath Javana 500 rupees per month, my lord. My lord, thereafter the salary was enhanced to annexure C at page number 14, my lord, at 4,368 in the year 2012.
ಸೀರಿಯಲ್ ನಂಬರ್
In the year 2012 November 2012 annexure C. My lord, thereafter request was made on 22/6/7 for regularize his employment, my lord, at annexure D at page number 15. My lord, the annexure E is again a request was made on 7/5/2008, my lord. My lord, again, my lord, the annexure G at page number 19.
Yes, government.
Respondent.
Huh?
Government is not a contestant. He is the employee of the respondent.
His appointment is approved or not?
It is a 3% government aided at annexure G. It is available. Annexure G.
ಏನು ಅನಕ್ಷರ್ ಜಿ ನಲ್ಲಿ ಏನಿದೆ?
Annexure H, my lord, page number 20.
ಏನು
K ಜಗನ್ನಾಥ ಕಾವಲುಗಾರ ನೇಮಕಾತಿ 3% ಗ್ರಾಂಟ್ ನಲ್ಲಿದ್ದು ಇದರ ಮಾಹಿತಿ ನೀಡುವ ಬಗ್ಗೆ this is the correspondence made by the respondent number 8 to the respondent number 5, my lord. ಮೇಲಿನ ವಿಷಯ ಸಂಬಂಧಿಸಿದ ನಮ್ಮ ಕಾಲೇಜಿನಲ್ಲಿ ಕಾವಲುಗಾರ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಜಗನ್ನಾಥಕ್ಕೆ ಇವರು ಹೆಸರು 3% ಅನುದಾನದಡಿ ಸೇರ್ಪಡೆಯಾಗಿದ್ದು ಈ ಕೆಳಗಿನ ವಿವರದಂತೆ ಲಭ್ಯ ಇದ್ದ ದಾಖಲೆಗಳನ್ನು sought for certain document from the respondent number 5, my lord.
You sought for approval of your appointment.
Yes, my lord. Similarly placed at annexure J, my lord, one at page number 21, the 4th para. ಗಿರಿಯಪ್ಪ ಗೌಡ ಇವರನ್ನು ಪ್ರಯೋಗಶಾಲಾ ಸಹಾಯಕರ ದಿನಾಂಕ 1/1/90ಕ್ಕೆ ಮುಂದೆ ನೇಮಕಾತಿ ಮಾಡಿಕೊಂಡಿರುವುದರಿಂದ ಈ ಕಾಲೇಜಿನ ವಿಜ್ಞಾನ ಸಂಯೋಜಕದಲ್ಲಿರುವ 3 ಪ್ರಯೋಗಶಾಲಾ ಸಂಯೋಜಕ ಹುದ್ದೆಯಲ್ಲಿ ಯಾರು ವೇತನ ಅನುದಾನ ನಡೆಯುತ್ತಿಲ್ಲದೆ ಇರುವುದರಿಂದ ಸರ್ಕಾರಿ -31/8/90 ಅನ್ವಯ ನಿರ್ದೇಶನ ಇವರ ಶಿಫಾರಸಿನ ಮೇರೆಗೆ ಕೆಳಗಂಡ ಆದೇಶ ಮಾಡಲಾಗಿದೆ. SSC ಕಾಲೇಜು ಸುಬ್ರಹ್ಮಣ್ಯ ದಕ್ಷಿಣ ಜಿಲ್ಲೆಯಲ್ಲಿ ಪ್ರಯೋಗಶಾಲಾ ಸಹಾಯಕರಾಗಿ 18/14/86ರಲ್ಲಿ ನೇಮಕವಾಗಿ ಶ್ರೀ ಗಿರಿಯಪ್ಪ ಗೌಡ ಇವರ ನೇಮಕಾತಿಯನ್ನು 810 1310.
Appointment was not approved.
But see, after so many years, you can't be saying there's no paper advertisement. He- He's only a watchman, mister.
Yes,
What is
ma'am.
the education qualification for that? For a watchman, what is the education qualification? Group D. ನೇಮಕಾತಿ ಆದೇಶದ ಪ್ರತಿ, ಹುದ್ದೆ ಮಂಜೂರಾತಿ ಆದೇಶದ ಪ್ರತಿ. Why don't you consider his case for approval? Instruction ಇವತ್ತೇ ತಗೋಬೇಕು. ಪಾಸ್ವರ್ಡ್. No.
2 days, sir.
ನೀವು ಹಳೆ ಕೇಸ್ಗಳೆಲ್ಲ ಬಂದಾಗ ನೀವು 2 days, 3 days ಅಂತ ಹೇಳ್ಬೇಡಿ ನೀವು. If you want, I'll issue an advance list, but I will not, once if the matter is listed, I can't adjourn. These are old matters. Password. ಇಲ್ಲ ತಿಳ್ಕೊಳ್ಳಿ, ಫೋನ್ ಮಾಡಿ ತಿಳ್ಕೊಳ್ಳಿ. Government, you should cooperate, I am telling you seriously. Old matters, if you can't, I will not permit any adjournment. This tomorrow, learn council, learn AGS seeks time to secure instructions. This tomorrow is the last chance. P. Mahesh. AG Vasant Kumar.
I'm for the R2 in this case, madam.
R2.
MOC Wakalat, my name is not reflected. Sidhanur Vishwanath.
Huh?
I'm for respondent number 2 in this case.
ಯಾರು ವಸಂತ್ ಕುಮಾರ್ ಅಂತ ಇದಾರಲ್ಲ?
I filed the NOC Wakalat, I'm respondent number 2.
ಯಾರು ಮಹೇಶ್ ಬಿ? There's no representation for the petitioner. Office is directed to show the name of Mr.
Sidhanur Vishwanath.
Mr. Sindhanur Vishwanath as the counsel for respondent number 2. After by replacing the name of Mr. H.G. Vasant Kumar. List on ಯಾವತ್ತು?
Next week, any date.
ನಿಮ್ಗೆ ಹೇಳಿ ಯಾವತ್ತು ಬೇಕು?
Day after tomorrow, Pudra.
This day after tomorrow. Muradhar Peshwa, huh?
Lord, respond. Pertaining to my lord, regularization of the employees, my lord, the petitioner as my lord, data entry operators, my lord, to Gram Panchayat, my lord.
Hmm.
There is no contract between the my lord, Panchayat and my lord, petitioner, my lord. No, my lord, petitioner sought for my lord,
Sourced employees.
please, home security, my lord. They have given a home security as an agency, my lord.
L. Muradhar Peshwa. Password. Password, huh?
Please.
Password. A. Nagarajappa and Associates.
Day after tomorrow, my lord. Senior is not in station, my lord. That is the reason. Day
Yeah,
after
I-
tomorrow, my lord.
Mr. All these file hearing matters, no adjournment.
My lord, day after tomorrow, my
No
lord.
adjournment. Day after tomorrow, adjournment ಇತ್ತಾನೆ.
Senior is
Day
not
after
in station,
tomorrow
my lord.
adjournment ಅಲ್ವೇನಪ್ಪ?
Senior not in station, my lord. Only for that reason, my
I'll
lord.
dismiss it. You please argue whenever you are free.
My lord. Day after tomorrow.
No, mister. These are all old matters, no adjournment.
My lord, we'll submit our arguments, my lord. Day after tomorrow, my lord. Senior is not there, my lord.
Learned
Only
counsel
for that
the
reason, my
petitioner
lord.
seeks for an adjournment. Since the petition is filed in the year 2013, no indulgence can be shown. Hence, the petition is dismissed for non-prosecution.
No, my lord.
My ಐ ಹಾಕೊಂಡ್ ಬನ್ನಿ.
No, my lord. We'll submit my arguments, my lord. We'll submit my arguments, my lord.
Pass over.
My lord.
Mr. M.K. Girish. Ah?
Appearing for the petitioner, my lord.
39 matter.
39, huh?
Was in other court.
Right, please wait.
Is
This
it?
M.K.
My lord,
Possible.
appearing for the petitioner, my lord.
Yes.
My lord, my senior has met with a road accident, my lord, and his leg is fractured and is currently undergoing treatment from Prakriya hospitals, my lord. We've already informed the opposing counsel as well, my lord. So kindly grant 2 weeks' time, my lord.
What is the issue, madam?
My lord, it's a 2013 matter, my lord. We've already informed the other party
What
as
is the
well.
issue? What is the issue? What are the
My-
facts?
Oh, his right leg is fractured, my lord. The tibia is
That I
fractured.
understood, madam. Tibia is
Yes.
fractured, he met with an accident, all those things is fine. But what are the facts of the case?
My lord,
What are
I'm
the
not well.
Please
My
read the
lord,
file and come back.
my
Read the
lord,
file, give me
kindly,
the facts. Please read the
My lord.
file, give me the facts, only then I'll grant adjournment.
my
Next.
lord, I'm not well versed with the facts of the case, my lord,
Please
since my
get-
senior wishes to argue with
Please
himself.
read the
my lord.
file, please read the file,
Yes,
get well versed with the facts. I'll call it again, pass over.
much obliged, ma'am.
Prasad Yavar. Prasad Yavar. Prasad Yavar. Pass over. And but ready na?
Ready.
Put it.
My lord, may I submit, my lord, in the second writ petition first and then the first writ
Do
petition?
whatever you want.
My lord, in WP 54272.
Second repetition.
My lord, the issue is, my lord, to consider the representation made by the petitioner at annexure E.
What is annexure E?
Annexure E, my lord. ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇನ್ನೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಇತ್ತು, ಮೈ ಲಾರ್ಡ್, ದಟ್ ಕೇಮ್ ಟು ಬಿ ಅಲೌಡ್. ಮೈ ಲಾರ್ಡ್, ಐ ಮೇ ಬಿ ಪರ್ಮಿಟೆಡ್ ಟು ಪ್ಲೇಸ್ ದಟ್.
No, first let me understand what is annexure E.
My lord, annexure E, my lord, your lordship gets it at page 1919.
Ready now, only Krishna, pass over. Let him argue then. Please listen to whatever he submits.
My lord, it is an appeal made, my lord, to the chairman of the choir board.
For?
My lord, for considering his case, my lord, for promotion, my lord, to the post of manager grade 1 from the date on which the vacancy had occurred.
Yes.
My lord, the vacancy had occurred on 1st April 2003. My lord, there was an inquiry, my lord, initiated against the petitioner. And my lord, a punishment of censure was passed. My lord, that was challenged before this honorable court. Writ petition came to be allowed.
WP number?
WP, my lord, I may be permitted to place the order.
Told.
My lord, your lordship gets the operative portion, my lord, at page 15.
Subject matter of appeal, my lord, been writ
That
appeal.
is true.
Yes.
In the light of the, your lordship gets the operative portion at page 15. In the light of the judgment of the Honorable Supreme Court, articles of charges are vague as could be seen from on this ground and also on the ground of delay in framing the charges. I hold that the article of charges has to be ignored and accordingly punishment and order dated so and so has to be set aside, and consider the petitioner for promotion without looking into or considering the punishment or dated so and so. My lord, the other side has preferred a writ appeal. My lord, there is no stay. My lord, one more order, my lord, is at operative portion, my lord, is at page 22.
This is one more order.
My lord, there was another writ petition, my lord.
Correct, but what was this writ petition against?
My lord, that is, my lord, consider his case for promotion, my lord. Operative portion, your lordship gets it at page 22, para 7. Be that as it may, if a person is eligible for promotion for a post of director marketing, then it is the duty of the respondents to consider the case of the petitioner along with the candidates who have applied with the requisite qualification. The qualification for promotion to the said post is a seniority, and in addition to that, possessing postgraduate degree in business management with the 10 years of working experience. Learned counsel for the petitioner submits that the petitioner possesses such qualification. In the light of the above, the first and the second respondents are directed to consider the case of the petitioner as per the service regulations, so and so, so and so. My lord, against this order, my lord, I don't think, my lord, there is a writ appeal.
Yes.
only against the other matter, my lord, there is a writ appeal pending and there is no interim order.
Yes.
My lord, in this case, my lord, the representation, my lord, is to consider his case for promotion, my lord, for manager grade 1
Yes.
from 2003. Subsequently, he was promoted, my lord. But if he is considered, his case is considered from this date, my lord, he will be getting 1 or 2 additional increments. That's all.
1st of April.
1st of April 2003. ಅಷ್ಟೇ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಇರುವುದು.
What about the next petition?
My lord, next case, my lord, is also for promotion, my lord, to the cadre of joint director.
The subsequent next promotion.
My lord, from manager, my lord, next is, I understand, deputy director in the joint director in the director.
So ನೀವು ಡೆಪ್ಯೂಟಿ ಡೈರೆಕ್ಟರ್ ಯಾವಾಗ ಆದ್ರಿ?
My lord, I did not get, my lord, the exact date. My lord, if your lordship.
ಅಲ್ಲ ಸ್ವಾಮಿ ನಾಳೆ ಹಾಕೊಂಡ್ರೆ I will also go on with this. ಎಲ್ಲ ನಾಳೆ everybody wants tomorrow. Why did
Actually, ನಾನು what had happened, my lord, I did not expect, my lord, ಅದು ಇವತ್ತು
ಏನು ಬರುತ್ತೆ
ಆಗಿಲ್ಲ. ಅಲ್ಲಿ ಬರುತ್ತೆ ಅಂತಲ್ಲ, ನಾನು ರೆಡಿ ಮಾಡಕ್ಕಾಗಿಲ್ಲ. I had many matters.
Every lawyer says.
ಅಲ್ಲಲ್ಲ, ನಾನು ನಾಳೆ ಮಾಡ್ತೀನಿ. In fact, this matter I have also argued, but it's not.
Matter.
ನಾಳೆನೆ ಮಾಡ್ತೀನಿ.
Everybody will have a reason not to argue the matter today. Everybody has a reason not to argue the matter.
I undertake.
Court last ಇದೆ, so we can't run from that end to this end.
ಅದಲ್ಲ.
ಏನ್ ಮಾಡೋದು? Everybody has a reason to seek for an adjournment.
Dispose ಮಾಡಿ. ಒಂದು ಡಿಸ್ಪೋಸ್ ಮಾಡಬೇಕು.
ಸ್ವಾಮಿ ಎರಡನೇ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ.
ಎರಡನೇದು ಡಿಸ್ಪೋಸ್
because to consider disposal of that appeal ಅದ್ ಮಾಡಬಹುದು.
WP number 54272 of 2014. The petitioner has sought for a writ in the nature of mandamus to direct the respondent number.
My lord, respondent number
3.
Appellant. Respondent number
3 to consider his case for promotion to the post of manager grade 1/deputy director. Same cadre.
ಅಲ್ಲ ಸ್ವಾಮಿ, appeal is pending. He wants appeal to be disposed of.
ಅಲ್ಲ, ಅಪೀಲ್ ಅಂದ್ರೆ ಇದು ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಅಪೀಲ್ ಅಲ್ಲ, ಕನ್ಸಿಡರ್ ಮಾಡದೇ ಇದ್ದಕ್ಕೆ ರೆಪ್ರೆಸೆಂಟೇಷನ್. My lord, it is,
ಹೌದು.
though it is termed as appeal, my lord, it is a representation.
I asked you one thing, Narayan, but manager grade 1 deputy director, same cadre.
Same cadre.
ಹೌದು.
Is it the same cadre? So next post, promotion post is joint.
ಅಲ್ಲ, ಇದಲ್ಲಿ ಏನಾಗಿದೆ, my lord, an appeal is produced, filed, my lord, which was not considered at all. Disposal consider ಮಾಡಕ್ಕೆ ಹೇಳು. ಇಲ್ಲ, ಎರಡು ಮ್ಯಾಟರ್ ನಾಳೆ.
ಅಲ್ಲ, please come to the writ petition prayer.
ಹೌದು.
Here. Manager grade 1/deputy director.
ಒಂದೇ cadre ಸ್ವಾಮಿ.
ಒಂದೇ cadre ಅಂತ ಕೇಳ್ತಿರೋದು ನಾವು.
ಹೌದು.
ಏನ್ ಮೇಡಮ್ ಆಯ್ತು? And dispose of his by disposing of his representation. Full stop. Next paragraph. The facts in brief are that the petitioner joined the services of the respondent number 3 as a
Lower division clerk
with effect from December 1986. He was thereafter promoted to the post of manager grade 3 during December 90, manager grade 2 during February 1996. He was eligible for promotion to the post of deputy director or to the alternative, to the cadre of manager grade 1. However, full stop, the petitioner alleges that in order to grant benefit to certain others, his promotion was withheld. Full stop. He contends that he was promoted to the post of manager grade 1 during August 2011, though he was entitled to be promoted with effect from
1st April
2003. Full stop. He contends that in order to deprive the promotion with effect from 1/4/2003, he was implicated in a departmental proceedings and was placed under suspension. The order of suspension was later on revoked and revoked. Full stop. The respondent number 2 did not frame any charges. The respondent number 2 issued a charge memo which was challenged before this court in WP number 37042 of 2015. 15 आएंगे 54272. 54272 ना
37042.
37042 of 2015. Full stop. He contended that the department proceedings were issuing charge articles of charge. I thought. Full stop. An inquiry was conducted and the petitioner was slapped with an order of censure. Full stop. He challenged the said order. ಇದ್ಯಾವ್ದ್ರಿ 36973 ಯಾವ್ದ್ರಿ ಇದು?
ಅದು ಇನ್ನೊಂದು ರಿಟ್. ಅದು that is, my lord, to consider his case for director marketing.
Where have you mentioned about this WP number 37042 ಎಲ್ಲಿ ಹೇಳಿದ್ರ?
ಅದು ಪೇಜ್ 15 ಸ್ವಾಮಿ.
ಪಿಟಿಷನ್ ಹೇಳಿಲ್ವಾ?
ಪಿಟಿಷನ್ ನಲ್ಲಿ ಇದು ಹೇಳಿಲ್ಲ, ಇದು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್. ಈ ರಿಟ್ ಹಾಕಿದ ಮೇಲೆ ಆಚೆದ್ದು ಹಾಕಿದ್ದು ಸ್ವಾಮಿ.
ಏನ್ ಮೇಡಮ್ ಆಯ್ತು? The order of censure was passed. Full stop. The petitioner contends that in the meanwhile, the departmental promotion committee considered the case of the petitioner and adopted the seal cover procedure. The petitioner contends that the said order was challenged in WP number. ನೀವು ಹೇಳೋದೇ ಇಲ್ಲ ರಿಟ್ ಪಿಟಿಷನ್ ಎಲ್ಲೂ. Challenge in WP number 37042 of 2015. Full stop. A coordinate bench of this court, while order dated
11th September 2018. In WP number 37042 of 2015.
September 2018. Set aside the order of censure. And directed the consideration of the case of the petitioner for promotion. Full stop. Following the above order of this court, the petitioner submitted a representation dated.
This representation is much earlier, my lord. This is dated
In the meanwhile, the petitioner had submitted a representation
7/12/2011.
on 7/12/2011 for consideration of his case for promotion to the post of manager grade 1 with effect from
Actually, my lord, it's an appeal under the law, bylaws. It's an appeal, proper appeal, annexure. He is not a
1/4/2003.
appellate authority ಮುಂದೆ ಹೋಗಿರೋದು.
Full stop. The petitioner contends that the said appeal is not considered till date and therefore seeks for an appropriate direction to the respondent number 2 and 3 to consider the appeal in the light of the order passed by this court in WP number 37042/2015. Next, for the learned counsel for the respondent number 2 and 3 submits that the order dated so and so passed in WP number 37042/2015 is pending consideration in writ appeal
151/2014.
151/2015.
2015, sorry.
15. And therefore submits that the case of the petitioner would be considered after disposal of the writ appeal. Full stop. Next para. This court in WP number 37042/2015 had set aside an order, set aside a penalty of censure imposed upon the petitioner. Full stop. The Departmental Promotional Committee had found the petitioner eligible to be promoted to the post of Manager Grade 1 and therefore had adopted the sealed cover procedure. Full stop. The coordinate bench of this court in WP number so and so had held double inverted comma had directed the consideration of the case of the petition for promotion without looking into the penalty of censure with an order dated 13/7/2011. Full stop. In that view of the matter, the respondent 2 and 3 are bound to disclose are bound to open this the sealed cover and declare the promotion of the petitioner if he is found to be eligible. Full stop. It is needless to mention that any promotion that may be granted to the petitioner shall be subject to the outcome of writ appeal number so and so.
2019, sorry, 15 alla.
Whatever, 2019, 2019. Yes.
Much up.
Other matter, naale
List the other petition tomorrow. Idella hale case lawyers should cooperate. Otherwise it will remain like this forever. Naveen Chandra.
My lords, I appear in this matter for the petitioner.
Yes.
My lords, this matter was actually taken up about 2-3 weeks ago, and it was in fact fully heard. I made my submissions. I'm ready now as well. It's a simple issue. In fact, after this honorable court, in fact, asked the respondent that why they have not implemented, again, the government advocate asked for time. If my lord sees the prayer is at page 13. My lords, here the issue is that in the prayer, reservation of 3% for persons with disabilities has not been provided in the appointment of presiding officers in the district consumer redressal forum. And the petitioner was someone with disability who had applied. Of course, since there was no reservation itself, he was not considered. Now, while we may not consider prayer B, because even this petitioner may have lost his chance, at least prayer A is important, because going forward, as per the act, the requirement under the statute is there. Now, my lords, if I can show my lords.
This will be treated as a public interest litigation.
No, not necessary. In fact, he has raised it. Yeah, they can even create a supernumerary post and appoint him. He is not abandoning his prayer.
How old is he?
For that reason, whether there is any age bar, when he applied, he was eligible. I'm not sure if there is
I
any
make one submission
restriction.
to clarify.
Let him move. Yes.
Now, my lords.
You're not pressing prayer number B.
No, I'm not pressing. What the only reason, because this is this was filed in 2015 when the notification was issued. My lords may see the notification which initially called for appointments is at page 19. The English translation for my purpose is at page 22. Around 17 vacancies were there for members. 17 vacancies were there of members for different district consumer fora all over.
It's all
Karnataka.
right. Why should you waste time, madam? First you find out whether your client is interested to pursue a relief B.
In fact, the reason I said is because we are not able to contact the client. He may
Just
have,
leave it. Just leave it then.
my lords,
If your
Prayer
client is
A-
not interested, why do
no,
you want to, why should we go and look into academic matters?
my lords, prayer A, may I just,
Prayer A will place it before the Chief Justice if you want to treat it as a public interest.
in
So
fact,
far as
this
prayer
honorable
B is
court,
concerned,
yes.
if you are
Prayer B,
interested,
then give me a week's time. If we don't get any response, I will make that submission. We were trying to contact him when the matter had come up. In case we give us a week's time, I can clarify clearly.
you said you argued this matter a few weeks back before
Yes,
another bench.
yes, it had come up
You
2-3
must have
weeks.
got instructions from your client whether he's interested to pursue B or not.
In fact, we were unable to reach him since this was a very
So
long
you
time.
argued the case though you are not sure.
We
OT
argued,
case.
my lords, this is a matter where a statutory provision also is not complied
We are
with.
not on that. I'm not at annex relief A, I'm at
Yes.
B.
Yes,
So therefore, are you sure whether you want to pursue a B, relief B?
I will get instructions whether we are able to reach him or not. If we are not,
And without getting instructions, you say that you argued the matter at
no,
length.
because we were on instructions. Advocate is on instructions.
Right, but you are not aware whether he's interested to pursue B or not, relief B or not.
My
And
lords,
yet you say that you argued the matter.
no, because we have always been on instructions. Advocate on record has been on instructions. Matter has been reaching on several occasions. We were always there.
When do you want it?
My lords, may
Tomorrow?
keep it next week. Next week, give us at least 4-5 days time. My lords may keep it on any fixed date next week. I have no difficulty.
And counsel for the petition seeks time. This, huh? No, she says that she doesn't have instructions. ಯಾವತ್ತು argument ಆಗಿದ್ದು?
This happened, the last date was on 14th.
14th of?
February of February.
By 14th February, you're not aware whether relief B was necessary to be pressed into service or not.
No, in fact, on 14th Feb, when the matter was argued, we submitted, this honorable court, in fact, asked the government, why haven't even the reservation as per law been provided? And the
We'll
government,
look into that in an appropriate matter. We'll look into that in an appropriate matter. First, you please tell us whether you're interested in the relief B or not.
I will get those instructions. I will get those instructions. My lords may keep it next week, any date.
The land counsel for the petition seeks time. List on date could ಯಾವತ್ತು? ಅಲ್ಲ ಅವ್ರಿಗೆ ಇಲ್ಲ ಕೇಸ್ ಬೇಡ ಅಂದ್ರೆ ಹೊಸ ರೂಲ್ಸ್ ಅಲ್ಲಿ ಇದೆಯಾ? ಹೊಸ ರೂಲ್ಸ್ ಪ್ರಾವಿಷನ್ ಮಾಡಿದೀರಾ?
No, they have not stated that. If they have, in fact, that was the submission even.
Consumer protection qualification for appointment, method of recruitment, procedure of appointment, 2020 rules have been framed for.
ರೂಲ್ಸ್ ಫ್ರೇಮ್ ಮಾಡಿದ್ರ ಅದ್ರಲ್ಲಿ ಏನ್ ಪ್ರಾವಿಷನ್ ಮಾಡಿದೀರಾ? ಮಾಡಿಲ್ಲ, ಇಲ್ಲೂ ಮಾಡಿಲ್ಲ. So therefore she wants to know whether her client wants to pursue the writ petition or not. ಏನ್ ಲಾಯರ್ ಅರ್ಥ ಆಗಲ್ವಾ? Small simple things, I don't know why. Learn counsel for the petition seeks time, list on date. Yes, Mr. C.S. Dwaraknath.
Great. My lord, I appear for respondent number 4 in this matter.
Yes. C.S. Dwaraknath. There is no appearance for the petitioner. Dwaraknath, C.S. Dwaraknath. Even on the last date, there was no appearance. The petition is dismissed for non-prosecution. Yes.
Obliged.
Appear for the petitioner, my lord.
Hmm.
My lord, this is a case of non-selection of the petitioner, my lord, to the post of assistant professor, physical education.
Yes.
My lord, petitioner has a BPed and MPed degree, plus my lord, he has passed SLET.
What was he, is he working from the last 9 years? What is he doing?
Pardon, my lord.
The last 9 years, what has he been doing?
My lord,
ಕೆಲಸ ಮಾಡ್ತಿದ್ದಾನ ಇಲ್ಲ?
ಇದು the other respondent,
ನಿಮ್ಮ
ನಮ್ಮವನ್ ಬೇರೆ ಎಲ್ಲಿ ಟೀಚರ್ ಆಗಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾನೆ.
More appointment ಆಗಿದ್ದಾರೆ, he is working, he is discharged.
ನಿಮ್ಮವ್ರು ಅಪಾಯಿಂಟ್ ಆಗಿರಕ್ಕೆ ಅವ್ರು ಇಲ್ಲಿಗೆ ಬಂದಿರೋದು.
ಅದೇ 9 ವರ್ಷದಿಂದ ಏನು ಮಾಡಿ.
ಕೇಳಿದ್ದು.
Yes.
ಏನಾದ್ರು ಹೊಟ್ಟೆ ಪಾಡಿಗೆ ಏನೋ ಇದೆಯಾ ಅಂತ?
ಇದೆ.
In some school, my lord, he is working. My lord, petitioner is qualified, my lord, as per the UGC regulation.
Where is the notification?
My lord, notification is at Annexure E, page 21, my lord.
Annexure E.
E. Sorry, my lord, notification is at Annexure F, page 22. My lord, applications along with documents, so and so, so and so. My lord, assistant professor, SC5, ST2. My lord, this BPed is at serial number 6. It is reserved for scheduled tribe, my lord.
Yes, please.
Pay scales, my lord, as per the pay scales, educational qualifications, my lord, etc. are as per the UGC notification. My lord, UGC notification, my lord, I have produced at Annexure G. My lord, the relevant portion, my lord, your lordship gets it at page 25.
25.
Para 3.
Yes.
Recruitment and qualifications. The direct recruitment to the post of assistant professors, associate professors and professors in the universities and colleges shall be on the basis of the merit through all India advertisement and selection by the duly constituted selection committee as per the guidelines, so and so. 3.2. The minimum qualification required for the post of assistant professors, associate professors, so and so shall be as prescribed by the UGC, and that qualification, my lord, your lordship gets it at page 26. 3.3.
Yes.
The minimum requirements of a good academic record of 55% of the marks at the master's level and qualifying in the national eligibility test, NET, or an accredited test, state level eligibility test, SLET, shall remain for the appointment of assistant professors. Next clause, your lordship may kindly see. NET, SLET bar SCT shall remain the minimum eligibility condition for recruitment and appointment of assistant professors in universities, colleges, and institutions. Provided, however, that candidates who have been awarded PhD degree in compliance of the University Grants Commission minimum standards and procedure for award of PhD degree regulation 2009 shall be exempt from the requirement of the minimum eligibility condition, so and so. My learned friend's case is that, my lord, he has a PhD. His PhD is of the year 2007. So, my lord, this qualification must be as per the UGC regulations, PhD regulations 2009. So, my lord, that cannot be made applicable in the case of the respondent.
Where the regulations live? PhD regulations.
Our PhD certificate, page
Sir,
36.
where are the PhD degree regulations 2009?
My lord, your lordship may have it tomorrow, my lord.
Oh, sorry.
Your lordship may.
ಎಲ್ಲದಕ್ಕೂ tomorrow.
ಅಲ್ಲ, ಅದು
Sorry, Mr.
PhD was
My-
completed
my-
2007.
You're arguing a point, you don't bring the regulations.
My lord, my specific case is 2009 regulations here, 2007 PhD
Let us
apply
see the
ಆಗಲ್ಲ.
regulations. ನೀವೇನ್ ಹೇಳಕ್ಕೆ? Why should I accept whatever you say? I should see it and accept it.
Your lordship may pass it over, my lord, in the afternoon I will produce.
Yeah, once ಕೇಳಿದ್ರೆ tomorrow. Pass over.
ಇಲ್ಲ, ಇದೆ ಸ್ವಾಮಿ ಇಲ್ಲಿ, ಸಾರಿ. One second.
ನೋಡಿ ಫೈಲೇ ನೋಡಿಲ್ಲ ನೀವು.
ಅಲ್ಲ, ಫೈಲ್ ನೋಡಿದ್ದೇನೆ ಸ್ವಾಮಿ.
ಫೈಲ್ ನೋಡಿ ಇಲ್ಲಿ ಬಂದು ನೋಡಿದ್ರ ಅಷ್ಟೇ, ಫೈಲೇ ನೋಡಿಲ್ಲ ನೀವು.
ನನ್ನ ಹತ್ರ ಒಂದೇ ಕಾಪಿ ಇರೋದು.
So what should happen to all those PhDs which are awarded before 2009?
They should pass NET or SLET.
So one more ಮಾಡ್ಬೇಕಾ?
ಅಲ್ಲ, ಅದು my lord, that is the.
What is this, Mr.? If he's got a PhD, he's got a PhD, whether it is 2007, 6, 9, 8, whatever, how does it matter?
My lord, as far as a candidate is concerned, my lord, PhD is not required. He is required to be a postgraduate with 55% or above. Plus, my lord, he is required to pass NET or SLET.
Correct.
A rider is put, my lord, those who have passed PhD with these regulations, under these regulations, they are exempted from passing.
Yes.
But the first clause says it shall remain the qualification,
Yes.
passing in NET or SLET. So 2007 PhD, my lord, doesn't come under these regulations.
So what should happen to the PhD that he has got?
My lord, they are required to pass NET or SLET. PhD passing, my lord, is not the qualification.
Yes.
That's all, my lord, is the case.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ. ಅವರಿಗೆ ಅದಿಲ್ಲ. He is not a PhD under the 2009 regulations.
Yes.
So my lord, I possess the prescribed qualification.
You might, but if he has got better qualification.
And marks is available there, Mel.
Yes.
That is page 33, Miller. Serial number 6 is petitioner, R2, and serial number 15 is petitioner, Miller. 77 ಅವರಿಗೆ STL, ಇವರಿಗೆ 74.82. But he process MPhil also ಕೊಡುತ್ತೆ degree ಇದೆ ಅವರಿಗೆ, philosophy. MPhil, that is respondent number 2, MPhil.
Yes, please.
And my lord, as per clause 310, my lord, the direct recruitment to the post of assistant professors, associate professors, and the professor university and college shall be on the basis of merit. 3.10. 3.10. The direct recruitment to the post of assistant professors, associate professors, and professors in the universities and colleges shall be on the basis of merit. And the merit ಮೇಲೆ ಇದನ್ನು ಕನ್ಸಿಡರೇಷನ್ ಮಾಡಿದ್ದಾರೆ. ರಿಕ್ವಿಸಿಟ್ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಇವ್ರದ್ದು ಹೈ ಇದೆ. MPhil ಬೇರೆ ಮಾಡಿದ್ದಾರೆ.
ಬರ್ಕೊಳ್ಳಿ. The petitioner has.
May I make one request? Really, this issue was raised, my lords, insofar as regulation, my lords, UGC regulation. Whether that particular regulation can be given prospective effect or retrospective effect, my lords. Guwahati High Court has held that, my lords, so it should be prospect.
The petitioner has sought for writ in the nature of mandamus. Has sought for writ in the nature of certiorari to quash the selection and appointment of the respondent number 2 to the post of assistant professor in physical education as illegal and contrary to the UGC regulations. He has also sought for writ in the nature of quo warranto to remove the respondent number 2 from the post of assistant professor of physical education on the ground that he does not possess the requisite qualification. He also sought for writ in the nature of mandamus to consider his case for appointment to the post of assistant professor, physical education. Next para. The respondent number 1 issued a notification dated 16/5/2012 inviting applications to several posts, including the post of assistant professor, physical education, which was reserved for scheduled tribe. Petitioner contends that he had all the qualifications and was eligible to apply against the said post, and that he also belonged to scheduled tribe. Full stop. The petitioner appeared for the interview. However, he was not selected and the respondent number 2 was selected. The petitioner secured information and found that the respondent number 2 had a PhD certificate and that he had also completed his MPhil. Full stop. He contends that the PhD certificate, he contends that the respondent number 2 was awarded with the PhD in the year 2007. And that he was not awarded with the PhD as prescribed under the UGC regulations of 2009. Full stop. He contends that the UGC regulations on minimum qualifications for appointment of teachers and other academic staff in universities and colleges and measures for maintenance of standards in higher education prescribe the recruitment and qualifications as follows. Copy page 25, red pencil mark, red ink, 3.0 so and so, so and so. 3.30, 3.31. Stop. He therefore contends that the respondent number 2 was not exempt from the requirement of obtaining a pass certificate in NET SLET to be qualified for the appointment of the post. Full stop. The petitioner is therefore before this court challenging the appointment of the respondent number 2 and has also sought for a direction to the respondents to select him, respondent number 1, to select him to the post of assistant professor. Next paragraph. The learned counsel for the petitioner reiterated the above contentions and contended that the respondent number 2 had obtained a degree, PhD degree, not under the PhD regulations of 2019 prescribed by the UGC, but was obtained prior thereto, and therefore it did not exempt the respondent number 2 from the NET, SLET, it did not exempt anything. SLET eligibility condition. Full stop. The writ petition is opposed by the respondent number 1 and 2. Full stop. So respondent number 2 has stated, even objection hakilla.
R2 hakide.
Non-file matter.
Hakilla. You hakilla.
R1 hakide.
The writ petition is opposed by the respondent number 2, who contends that as per the regulations referred supra,
My contention annexure came in.
referred supra, the candidate who had a postgraduate degree was exempt from the requirement of passing NET, SLET. Full stop. He contends that the issue whether a candidate who obtained a postgraduate PhD degree prior to the year 2009 was exempted. The eligibility criteria of passing NET, SLET came up for consideration before the Guwahati High Court in writ petition civil 101/2011, where the court held that the the PhD degree obtained prior to the 2009 regulations, cannot be effaced and cannot be declared ineligible, cannot be declared And such candidates cannot be declared ineligible to apply to the post of assistant professors. Full stop. Similar references are made to the judgment of the Honorable Apex Court in the case of University of Kerala and others versus Merlin JN, where it was held that the 2009 regulations are prospective in nature and does not affect PhD degrees awarded prior to the date of the 2009 regulations coming into force. Full stop. Next paragraph. The learned counsel for the respondent number 2 reiterated the above contention and submitted that the respondent number 2 was more meritorious than the petitioner and that he had also completed his MPhil degree. Full stop. He therefore contends that on all counts, the appointment of the respondent number 2 was justified and hence prays that the writ petition be dismissed. Next paragraph. The learned counsel for the respondent number 1, supporting the learned counsel for the respondent number 2, contended that the respondent number 2 had obtained, respondent number 2 had a more merit than the petitioner, and therefore his appointment is just and proper. Full stop. Next, I consider submissions made by the learned counsel for the petitioner and the learned counsel for the respondents. Next para. The eligibility criteria as prescribed by the UGC for the post of assistant professors in universities and colleges was good academic record with 55% of the marks, 55% of marks at the master's level, and qualification in the NET or an SLET. Full stop. However, in respect of those candidates who had a PhD degree, they were exempt from the requirement of the minimum eligibility condition of a pass in SLET, NET. Full stop. It is not in dispute that the respondent number 2 had obtained a PhD degree in the year 2007, which was much prior to the University Grants Commission bracket minimum standards and procedure for award of PhD degree, regulations 2009. Full stop. The contention of the learned counsel for the petitioner that the respondent number 2 had obtained the degree prior to the 2009 regulations coming into force and therefore cannot exempt the respondent number 2 from the eligibility condition of a pass in NET, SLET does not appear logical and does not stand to reason. So as a matter of fact, the regulations 2009 does not speak about the effect of the regulations 2009 on the PhD degrees awarded before the regulations coming into force. Full stop. It is, since the petitioner has not disputed the fact that the respondent number 2 had a PhD qualification, the respondent number 2 was rightly held exempt, rightly entitled to be exempted from the requirement of a pass in NET, SLET. This apart, the respondent number 2 had a higher qualification than the petitioner and had more merit in as much as the respondent number 2 had obtained 77.62% in the master's degree as against the petitioner who had obtained 74.82%. Full stop. Therefore, the appointment of the respondent number 2 cannot be held to be in violation of the prescribed qualification. Therefore, the writ petition lacks merit and is
Like.
Great.
Serial number 48, urgent serial number 49.
Shashidhar Agali.
I appear for petitioner, my lord.
Ah,
I'm for petition, I am petitioner number 2, my lord.
I hope you're ready.
Yes, my
Are you
lord.
ready?
Yes, my lord.
Rafi, Vyasa Tirtha. Vyasa Tirtha for R2.
P. Vyasatirtha for R2.
Yes.
His mother is unwell, my lord. So Adhika aur bandila. But however, in the previous occasion, he made a submission that he doesn't have any objection, my lord.
Objection for what?
I mean, in allowing the writ petition, my lord. In the previous occasion, he made a submission like that, my lord, because they are the one who recommended my promotion, my lord. So, my lord, I am a second petitioner, my lord. I joined
The
on.
Legal Services Authority in Tidilri.
Sorry, my lord.
He appears for the State Legal Services Authority. How can
Yes,
he,
yes, my lord.
how can he concede, mister?
Because now, actually, my learned counsel for government of Karnataka is the one who has to decide this matter, my lord. Yeah.
I have to decide, I have to decide the
I
matter.
mean, I'm sorry, you have to decide. I mean, they're the one who has to, whose main contending party, my lord. Kasha Kotra, I'm prepared, my lord.
Ready, na?
I want to secure instruction regarding the promotions of the petitioner lordship. He is working as a clerk in legal added service authority lordship.
ಎಲ್ಲದಲ್ಲಿ ಯಾವ್ದಲ್ಲಿ ರೆಡಿ ಇದ್ರಿ ಹೇಳಿ, ಯಾವ್ದಲ್ಲಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಂಡಿದ್ದೀರಾ ಅದನ್ನೇ ತಗೊಳ್ಳೋಣ.
Options ಹಾಕಿಲ್ಲ ಏನಿಲ್ಲ.
My lord,
ಮತ್ತೆ ಅವ್ರು ಹೇಳ್ತಾರೆ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ವಾಂಟೆಡ್ ದಿಸ್ ಕನ್ಸಿಡರ್ಡ್ ಟು ದ ರಿಟ್ ಪಿಟಿಷನ್ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ, ನೀವು ನೋಡಿದ್ರೆ
ಅವ್ರು ಬರ್ಲಿ ಸ್ವಾಮಿ ಅವ್ರು.
my lord, ಒಂದೇ ಒಂದು submission ಇದೆ, my lord. There is a GO which is acts as a Bhagavad Gita, my lord, which gives a guidelines, my lord.
ಮಾಡಲ್ವಾ ನೀವು ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ಸ್ ಅಪಿಯರ್ ಆಗ್ತಿರ್ಲಿಲ್ಲ ಹಿಂದಿನ ರೋಸ್ಟರ್ ಅಲ್ಲಿ?
Last time ಇದೆ ಒಂದು 1 month, last month ಇದೆ.
ಮತ್ತೆ you must by now you must be thorough with service matters.
This GO gives a guidelines for honorable court, my lord, basis on which it is guidelines, it acts as a guidelines, my lord. One opportunity kotre, I am ready, I will do my hearing. Subsequently, I leave it to the court, my lord. My lord, I am the second petitioner here, my lord.
Yes.
I joined on 21/3/1980 and retired on 31/7/2016, my lord. 21/3/1980, I joined, retired on 31/7/2016, my lord.
31/7.
Yes, my lord, 2016. And the first petitioner joined along with me, retired on 30th June 2016, my lord. And unfortunately, he passed away on 24/8/2020. This LRs are on record, my lord. We both appointed, from 21/3/1980, we worked for almost 16 years, my lord. However, our services were not regularized, my lord. So because of that, we filed a writ petition in the Honorable High Court, and the Honorable High Court was pleased to regularize our services effective from our date of joining, my lord. The order has been annexed as Annexure A, page 11, my lord. Subsequently, what happened, my lord? The department did not consider the judgment given by the Honorable High Court. They considered they regularized our services effective 7/6/1997, my lord. That means after 16 years instead of from the date of joining. So agreed by that, we again filed another writ petition, my lord, the Honorable High Court. So Honorable High Court has given a direction to both the respondents saying that to redo the entire exercise and act accordingly, my lord. The order is the annexed as Annexure D, page 28, my lord. Subsequently, the respondents have done an exercise, and accordingly, our services has been regularized from 21/3/1990, my lord. And accordingly, salary has been fixed, my lord. Annexure E and Annexure F and G, it talks about the salaries, my lord.
Yes.
So at least we were happy saying that at least our 10 years odru parvagilla, 10 years in the 19 confirmed agide anta, we were happy, my lord. And this is first part, my lord. And the second part is, my lord, there was a 14th annual general body meeting happened with my second respondent, my lord. In that, there was a decision taken to promote both of us, my lord. My lord, kindly refer page 44, Annexure H, my lord. Adrali, please refer to page 47, my lord. If you permit, I would like to read, my lord. Page 47, my lord.
to consider amendment to serial number 8 and 11 of Schedule 1 in the Karnataka State Legal Services Authorities Rules 1996. My lord, this is very important, my lord, so as to provide promotional opportunities to the existing clerk cum typist to the post of assistant, my lord. So this was decided on in the 14th annual general body meeting, my lord, on 5th October 2005, saying that we should be given promotional opportunities, my lord. However,
What was the decision?
sorry, my lord,
What was the decision in the meeting? It was unanimously resolved to formulate and
to amend the rules, my lord. Sorry.
Okay.
Yes,
not
amend
to
the
give the
rules.
promotion.
Yes, my lord. To amend the rules so
ಹಂಗೆ.
that to facilitate future ಅಲ್ಲಿ ನಮ್ promotion ಕೊಡ್ಬೋದು ಅಂತ ಅಂದ್ಬಿಟ್ಟು amendment ಮಾಡ್ಬೇಕು ಅಂತ decide ಆಯ್ತು, my lord. Subsequently, what happened, my lord? Basis on this, the second respondent has requested the first respondent to consider our promotion, my lord, Annexure J. Again, they have recommended, my lord, to consider our promotion, but though in two responses, it was not considered, my lord. Now I'll come to the very, very important point, my lord. Kindly see Annexure N, my lord, page 66.
Yes.
Annexure N.
Yes.
Annexure N, ಅಲ್ಲಿ, if you permit, I will read, my lord.
L or N?
N, Annexure N, page 66.
Yes.
My lord, ಇದರಲ್ಲಿ ಕ್ರಮ ಸಂಖ್ಯೆ 8 ಅಂತ ಇದೆ, my lord. This is the ಟಿಪ್ಪಣಿ given by the first department, my lord. ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ, ಸಹಾಯಕರ ಹುದ್ದೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಆಡಳಿತ ಇಲಾಖೆ ಪ್ರಸ್ತಾವಿಸಿರುವ ತಿದ್ದುಪಡಿಗೆ ಸಿಆಸು ಇಲಾಖೆಯು ಅಭ್ಯಂತರವಿಲ್ಲವೆಂದು ತಿಳಿಸಲಾಗಿದೆ. It means the recommendations made by the second respondent, who's my parent department, first respondent, who's my learned friend, government of Karnataka, they have mentioned that they don't have any objection, my lord. Idu ಒಂದು. Now, subsequently what happened? Kindly see Annexure P, my lord, page 72, my lord. Page 72. Can I read, my lord? Again, ಕ್ರಮ ಸಂಖ್ಯೆ 8, first point, my lord. ಕ್ರಮ ಸಂಖ್ಯೆ 8, ಸಹಾಯಕರ ಹುದ್ದೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪ್ರಾಧಿಕಾರದವರು ಪ್ರಸ್ತಾಪಿಸಿರುವ ತಿದ್ದುಪಡಿಗೆ ಸರ್ಕಾರ ಮಟ್ಟದಲ್ಲಿ ಅಭ್ಯಂತರವಿರುವುದಿಲ್ಲ. This is very, very clear, my lord. ಸರ್ಕಾರ ಮಟ್ಟದಲ್ಲಿ ಅಂದ್ರೆ ಗವರ್ಮೆಂಟ್ ಆಫ್ ಕರ್ನಾಟಕ, there is no any objection ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಸೆಕೆಂಡ್ ಟೈಮ್ ಕೂಡ ರೆಕಮೆಂಡ್ ಮಾಡಿದೆ, my lord. Now I request
ರೆಕಮೆಂಡ್ ಮಾಡಿಲ್ರಿ, ಕರೆಕ್ಟ್ ಓದ್ರಿ. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸರ್ಕಾರದ ಮಟ್ಟದಲ್ಲಿ ಪರಿಶೀಲಿಸಿ
ಅವಲೋಕಿಸಲಾಗಿದೆ.
ಅವಲೋಕಿಸಲಾಗಿದೆ.
Yes, my lord. Yes, my lord. So now, my lord, I request you to page 84, my lord, Annexure S. ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ, my parent department, that is the respondent number 2, they have written a communication to the respondent number 1 on 26/4/2014 saying that just ವಿಷಯ ಹೋಗ್ತೀನಿ, my lord. ಕರ್ನಾಟಕ ರಾಜ್ಯ ಕಾನೂನು ಸೇವೆಗಳ ಪ್ರಾಧಿಕಾರದ 1996 ಶೆಡ್ಯೂಲ್ 1 ಕ್ರಮ ಸಂಖ್ಯೆ 8 ತಿದ್ದುಪಡಿ ಮಾಡುವ ಬಗ್ಗೆ. So again they have recommended, my lord. So at the end of the day, what happened to, so the recommendation was by my parent department, government of Karnataka, the respondent number 1 also, they said, okay, we can, promotions can be considered, the ಹೇಳಿದ ಮೇಲೆ ಕೂಡ we were not promoted, my lord. So, my lord, now I request you to very, very important, my lord, annexure ಅಂತ ಹಾಕಿದೀನಿ, my lord.
ಇವತ್ತವರೆಗೂ ರೂಲ್ಸ್ ಮಾಡಿಲ್ಲ.
ಮಾಡಿದ್ದಾರೆ, my lord. annexure ಅನ್ನೊಂದು ಹಾಕಿದೀನಿ, my lord.
ಎಲ್ಲಿದೆ?
ಇದು ಅವ್ರಿಗೂ ಕೊಟ್ಟಿದ್ದೀನಿ. ಒಂದು ಜಿಒ ಇದೆ, my lord. ಜಿಒ annexure ಅಂತ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಮಾಡಿದ್ದೀನಿ, my lord. Can I read, my lord? annexure ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ನಾನು ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. ಇದು 5/3/2016. 5/3 memo ಹಾಕ್ಬಿಟ್ಟು I have filed a government order, my lord. Subsequent, not with the original suit, my lord. Subsequent ಆಗಿ ಹಾಕಿದ್ದೀನಿ. There is a GO.
GO.
Yes, my lord. ಓದ್ಲಾ, my lord? My lord, this is dated 5/3/2016, my lord. My lord, in exercise of the powers conferred by Section 2B of the Legal Service Authorities Act 1987, Central Act, and in consultation with Chief Justice of the High Court of Karnataka, my lord. I repeat it, my lord. In consultation with Chief Justice of High Court of Karnataka, the government of Karnataka hereby makes the following rules. And the rule now, 1, title and commencement. These rules may be called as Karnataka State Legal Services Authorities Amendment Rule 2016, my lord. Now, the one only, second, they shall come into effect date of publication in the official gazette. It means This will be effective from 5/3/2016, my lord. Very, very important point, my lord. Serial number 2, my lord. Amendment of Schedule 1 in the Karnataka State Legal Services Authority Rules 1996 were scheduled the following shall be substituted namely ಅಂತ. I mean, ಈ ಒಂದು GI ಯಾವ್ದ್ರ ಬೇಸಿಸ್ ಮೇಲೆ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ 2005 ಅಲ್ಲಿ ಏನ್ ರೆಕಮೆಂಡೇಶನ್ ಮಾಡಿದ್ದಾರೆ ಇನ್ ದ 14th annual general meeting ವೇರ್ ಐ read it in page number 47 ಅಲ್ಲಿ ವೇರ್ ಇಟ್ ವಾಸ್ ಡಿಸೈಡೆಡ್ that subsequently the rules will be amended ಅಂತ ಅವತ್ತು ಡಿಸೈಡ್ ಮಾಡಿದ್ದು. But they have made the amendment on 5/3/2016, my lord. My lord, now I request you to come to page 3, my lord.
Yes.
Idralli page 3 bani, my lord. I'll read page 3. Page 3 nalli this shows about the number of posts, my lord. So if you permit, I will read it, my lord. Serial number 11, my lord. This is for the post of assistant, my lord. Number of posts 10, my lord. Adralli column number 5. Method of recruitment antide, my lord. Method of recruitment alli 50% by direct recruitment from KPSC and 50% by promotion from the cadre of junior assistant, my lord. It means, my lord, out of 10 posts alli 5 posts should be from direct recruitment and another 5 posts from the cadre of junior assistant. Now I request you to see the last column, my lord, minimum qualification. What are the qualification for the consideration of the promotion, my lord? My lord, direct recruitment must be a holder of any degree antide, my lord. And promotion, my lord, must have put in a not less than 5 years of service in the cadre of junior assistant.
ಎಲ್ಲಿದೆ seniority list ಎಲ್ಲಿದೆ? Where is the seniority list of junior assistants?
Seniority list idre
ಇರೋದು 5 post ಅಲ್ಲ.
ಹೌದು, my lord.
Promotion is 5 posts.
Yes, my lord.
What is there to show that you are within that 5 posts?
Because I have completed more than 15 years of service.
Dear
my lord.
friend, are you the only 2? Are there
Yes,
no
my lord.
others?
ಬೇರೆಯವರಿಗೆ
Correct.
ಕೆಲವು ಬೇರೆ ಪೋಸ್ಟ್ ಪ್ರಮೋಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ಈ ಒಂದು ಕ್ಯಾಡರ್ ಅಲ್ಲಿ ಓನ್ಲಿ ವಿ ವೇರ್ 2, my lord.
Assistant post ಅಲ್ಲಿ ಅದು assistant
ಅಂದ್ರೆ
post ಗೆ
ಕ್ಲರ್ಕ್ ಕಮ್ ಟೈಪಿಸ್ಟ್ ಅಲ್ಲಿ ಓನ್ಲಿ ವಿ ವೇರ್ 2.
clerk cum typist ಇಡೀ ಕರ್ನಾಟಕ ರಾಜ್ಯದಲ್ಲಿ
ಅಲ್ಲ, ಈ ಒಂದು ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ನಾವು ಇಬ್ಬರೇ ಇದ್ದಿದ್ದು.
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ನೀವಿಬ್ರೇ ಇರ್ಬೋದು, ಬಟ್ ದಿಸ್ ಸೆಲೆಕ್ಷನ್ ಕ್ಯಾನ್ ಬಿ ಡನ್ ಫ್ರಮ್ ಎನಿಬಡಿ ಫ್ರಮ್ ಆಲ್ ಓವರ್ ದ ಸ್ಟೇಟ್.
ಸೆಲೆಕ್ಷನ್ ಡೈರೆಕ್ಟ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಗೆ 50%, ಅನದರ್ 50% is
ಪ್ರಮೋಷನ್.
ಹೌದು, my lord.
Out of 5 posts,
Yes.
you say that you are eligible for 2 posts.
Yes, my lord.
This promotion can be effected to all posts in the state of Karnataka.
Yes, my lord.
Who are holding the post of typist or whatever.
But only for DLSA department. Respondent number 2.
DLSA entire Karnataka.
Respondent number 2.
Entire Karnatakaದಲ್ಲಿ.
ಹೌದು, my lord.
ನೀವಿಬ್ರೇ ಇದ್ದೀರಿ ಅಂತ ತೋರ್ಸೋದಕ್ಕೆ ಏನಿದೆ?
ಅಲ್ಲ, ಆಕ್ಚುಲಿ ನಾವಿಬ್ರೇ ಇದ್ದಿದ್ದು, my lord.
ಆಕ್ಚುಲಿ ನಿಮ್ಗೆ ಗೊತ್ತು, ನನಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗ್ಬೇಕು?
I agree, my lord.
5 ಜನ ಇದ್ರೆ if you come within the first 5,
Yes,
what
my
you
lord.
say is right.
Yes, my lord.
Because the rules are in place,
Yes.
there is no selection criteria,
Yes, my lord.
promotion is automatic.
Yes, my lord.
I can understand.
Yes, my lord.
What is there to show that you are within that 5? What is there to show that you are within that 5?
But because in that ಆ ಒಂದು ಕ್ಯಾಟಗರಿ ನಾವಿಬ್ರೇ ಇದ್ದಿತ್ತು ಅನ್ನೋದೊಂದು I agree, my lord. I agree from where you are coming. But I don't have right now, I don't have any, apart from this GO, I don't have any other thing. Because yakandre that is the reason subsequent agi I have filed so many recommendations by my parent department kuda nu 2 sati recommend madidare, and even the respondent number 1 also said that we don't have any objection anta.
Do you not, will the legal service authority not have these details?
That I am not. ಅದಕ್ಕೆ previous occasion ಅಲ್ಲಿ ಅವ್ರು ಏನ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು ಅಂದ್ರೆ ನಮಗೆ ಪ್ರಮೋಷನ್ ಕೊಡೋದಕ್ಕೆ we don't have objection ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅವ್ರು ಹೇಳಿದ್ರು. Unfortunately his mother is unwell, so today he is not here, my lord.
ಪ್ರಮೋಷನ್ ಕೊಡಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ ಅಂದ್ರೆ ನೀವು ಫಸ್ಟ್ 5 ಒಳಗೆ ನೀವು ಬರ್ತೀರಂತ ತೋರಿಸ್ಬೇಕಲ್ಲ. Suppose you are at serial number 7 or 8.
Got it, my lord.
You are not entitled.
Kindly give me a week time. The date might be fixed, my lord. I'll produce the relevant document, my lord. I humbly request you to fix the date.
Counsel for the petition seeks time. ಯಾವತ್ತು ಬೇಕು?
1 week, my lord. Maybe a week or.
ಕೊಡ್ರಿ ಯಾವತ್ತು?
7th March.
Much obliged.
Serial number 50, G. Sridhar.
G. Sridhar.
Serial number 50.
Yes, madam.
Appearing for the plaintiffs, your lordships, the senior is held up in another court hall. Have a short accommodation can be given to us.
What are the facts?
Your Lordship, as a petitioner, we have obtained for squashing of a endorsement in annexure A, Your Lordship.
What is annexure?
ಇವಾಗ ಅದು ಕನ್ನಡದಲ್ಲಿದೆ Your Lordships, ನನಗೆ ಕನ್ನಡ ಅಷ್ಟು ಚೆನ್ನಾಗಿ ಓದಕ್
No, but
ಬರಲ್ಲ.
writ
ಅದೊಂದು
petition is in
ಕಾರಣದಿಂದ-
English, isn't it? Writ petition is in English.
Yes, Your Lordship.
So you must have read the writ petition.
How's Your Lordships ಓದಿದ್ದೀನಿ.
Then why don't you say what are the facts? Don't tell me you can't even read and write English.
I can, Your Lordships.
Then what are the facts?
Lordships, at the momentarily, I am not well versed with the.
Madam, you
facts.
sit in the court, open the file, take out the petition, read the petition for 5 minutes. I'll take it up
Can we-
afterwards.
Can we take this passed over to 2:30, Your Lordships?
I will pass it over, but read the file. Don't come to the court without reading the file.
I apologize.
Pass over.
Seal number 51, VS Naik.
Mr. V.S. Naik.
The short point
Hmm.
for consideration. Few points, few facts. Not in dispute between the parties. I will just state and then, my lord, I will go to the point that is involved and what is the prayer, whether that prayer is maintainable ಅನ್ನೋದು ಸ್ವಲ್ಪ ಪ್ರಶ್ನೆ ಇದೆ ಇದರಲ್ಲಿ.
Hmm.
No, my lord, Lordship may kindly recall, my lord, during 2000 and 2001,
Hmm.
this government of India, my lord, they announced privatization of hotels, including this Hotel Ashok,
Hmm.
where, my lord, this petitioner was working.
Hmm.
ಅದ್ರ ಪ್ರಕಾರ ಪ್ರೈವೇಟೈಸೇಷನ್ ಆದ್ಮೇಲೆ ಇಟ್ ವಾಸ್ ಹ್ಯಾಂಡೆಡ್ ಓವರ್ ಟು ಭಾರತ್ ಹೋಟೆಲ್ಸ್ ಅಂತ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಇನ್ ದಿಸ್ ಪಿಟಿಷನ್.
Hmm.
ಭಾರತ್ ಹೋಟೆಲ್ಸ್ ಬಂದ್ಮೇಲೆ ಮೈ ಸರ್ವಿಸಸ್ ದೇರ್ ವರ್ 2 ಆಪ್ಷನ್ಸ್. ಐದರ್ ಯು ಕ್ಯಾನ್ ಅವೈಲ್ VRS or go to Bharat Hotels and continue your employment. Your earlier service and everything will be protected. That was done.
Yes.
Then I went to Bharat Hotels. I continued my services. Then I resigned ಮಾಡಿದೆ ನಾನು. That is also permitted. After resignation, I came out. Then, my lord, I made a request. Look here, at the time when I was working, last 2 years, some increment to salary ಅದೆಲ್ಲ ಕರೆಕ್ಟಾಗಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು I made a representation ಕೊಟ್ಟಾದ್ಮೇಲೆ, my lord, I also gave representation to ITDC because that is the main parent ಇದು. ITDC ಗೆಲ್ಲ ಎಲ್ಲ hotels throughout India. ITDC ಇಂದ what happened, my lord, they did not respond. Then I got issued a notice. Notice-ಗೆ reply ಬಂತು. That reply notice is, my lord, it is a challenge.
Hmm.
The question is, my lord, whether a lawyer notice can be quashed in a writ petition ಅಂತ. Annexure K ತಾವು ದಯವಿಟ್ಟು ನೋಡಿ.
Hmm.
In fact, I advise him here, ಮುಗಿದೋಗಿದೆ. Annexure K, my lord, it is from ITDC. Dated 24th July 2014.
Hmm.
It is addressed to the advocates. That is our advocate, ಮೊದಲು earlier advocate. That is for the petitioner. Is first para ಓದಿ last para ಓದಿ ಇನ್ನೇನು ಓದಲ್ಲ. This has reference to your notice dated so and so, issued on behalf of the D.N. Nandan. D.N. Nandan is the petitioner. So and so, and this is the reply. Last sentence, last para. By the lease document, the employees of the erstwhile Hotel Ashok at Bangalore should transfer to the lessee. That is BHL is Bharat Hotels Limited. And for all purposes, your client was the employee of BHL, and that ITDC has no administrative or supervisory control over the employees of the BHL. And as such, ITDC is not in a position to provide your client the statement. What happened, my lord? Statement ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು representation ಕೊಟ್ಟರು. Since that representation was not considered, he got legal notice issued. ಅದಕ್ಕೆ ಉತ್ತರ ಬಂತು. ನಾವು prayer ನೊಳಗೆ I challenge that lawyer's notice. That is one thing. And secondly, my lord, if I have to
go before
get
the-
any relief from respond number 2 and 3, they are the private people. Adrinda, I have some difficulty in maintaining. But one submission I would like to make on behalf of the petitioner. My lord, in case, my lord, he has got other alternative forum that is approaching the civil court for recovery of the certain monetary benefits, it may be permitted. Only thing, my lord, period spent here may also be considered by that honorable court. ಅಷ್ಟಾದ್ರೂ ಸಾಕು.
The petitioner has sought for a writ in the nature of
Sir,
certiorari.
I appear for the respondent 2 and 3, my lord.
You are dismissing the petition with.
Yes, my lord, I have heard my learned friend, he has fairly considered that this court has no jurisdiction because he became the private employee. I wanted to bring it to notice of the lord.
Please come again.
Blood, the petitioner has become my employee, that is Bharat Hotels Private Limited.
He is re-employed.
No, my employee. He became my employee after leaving the services of the ITDC.
Yes.
And he submitted resignation and he got his gratuity and everything.
No, he says that after resigning, there were certain other benefits that he was entitled to, which was not settled.
Which have to be settled by the ITDC, not by BHL. Therefore, repetition is not maintainable against me. That's what my friend considered now, right?
Was it before or after?
After.
After.
While I was in service of after ITDC, because transfer ಆದ್ಮೇಲೆ I became the employee of BHL.
ನೀವು ಕೇಳ್ತಿರೋದು during what tenure was it?
That is subsequent to this lease sale agreement.
Not before it was taken over.
ಇಲ್ಲ ಆ period ಖಂಡಿತ ಆ period still my petition is maintainable. Yes. For the subsequent period.
The petitioner has sought for writ in the nature of certiorari to quash the communication bearing number so and so dated 24/7/2014 and to direct the respondent number 1 to extend the benefit of pay scale and other emoluments to which he is entitled to, having regard to the terms of the agreement between the petitioner, between the respondent number 1 and the respondent number 2. Between the respondent number 1 and respondent number 2. And the order dated 28/12/2001 passed by this court in WP number 42641-42680 of 2001. Iದೇನಿದೆ writ petition ಇದೆ?
On behalf of the union, when this takeover took place, I challenged by filing a writ petition.
The petition is also sought for a
General
direction to the response 2 and 3 to pay all the terminal benefits by extending the pay scale and other emoluments on par with the pay scale and other emoluments prevalent in the first respondent corporation pursuant to the lease agreement and the judgment passed by this court in WP number 42641-680/2001. By considering his representations dated 28/5/2014, notice dated 17/7/2014, letter dated 26/8/2014, and notice dated 15/9/2014. Next para. The facts in brief are that the petitioner was employed at the respondent number 3.
No, initially he was employed by respondent number
ITDC, one.
ITDC,
Respondent number, petitioner was employed with the respondent number 1
as an executive, my lord, not a workman.
as an executive and was deployed at the respondent number 3.
No, subsequently, after the ITDC handed over the property to the respondent number 2 and 3, my lord. That is on 29/11/2001.
Mr. Before it was taken over by the respondent number 2, it was your own concern.
No, it was not ITDC concern.
Then he was employed with the respondent number 1 and deputed to the respondent number 3.
No question of deputation, my lord. What has happened is he became the employee by leaving the services of the ITDC and joined my services as a fresh candidate after 29/11/2001.
He was appointed by the respondent number 1.
Yes.
And later, respondent number 1 on 38/1977. Full stop.
Then privatization during 2000-2001.
Stop. The petitioner earned frequent promotions, regular promotions under the career development scheme. And during the year 2000, 2001.
Yes.
He was granted promotion as a deputy manager, head office in F&B service at the respondent number 3.
No, respondent number 1.
Second respondent.
Bharat Hotels. Second respondent is Bharat Hotels.
First respondent, I'm sorry.
First respondent.
First respondent, ತಪ್ಪಾಗಿ ಬಂದಿದೆ. First respondent.
ಹೋಟೆಲ್ ಅಶೋಕ್ ಬೆಂಗಳೂರು ಅಂತ ಇದೆಯಲ್ಲ ಪೇಜ್ ನಂಬರ್ 7 ನಲ್ಲಿ.
ಹೌದು.
ಅದು that they have not what
ಹೋಟೆಲ್ ಅಶೋಕ್ ಆವಾಗ ITDC ಆಗಿತ್ತು.
ಏನು ಆಯ್ತು?
At that time it was ITDC.
Deputy Manager, Head Office in F&B Service Department. Full stop. Petitioner contends that pursuant to the disinvestment program,
Policy, POL.
huh?
Disinvestment policy of the government of India.
Pursuant to the policy of disinvestment in public sector undertakings
Yes.
by the government of India, comma, it recommended the disinvestment of the respondent number 1. Full stop. Consequently, the board of directors respondent number 1 passed resolutions to take appropriate steps to demerge some of their hotel properties so as to spur contributing and in furthering and fulfilling the decisions of the government of India and to achieve the goal of disinvestment. Full stop. As a result of the said program, the respondent number 1 entered into an arrangement to lease out its property, its hotel, namely the respondent number 3 in favor of the respondent number 2.
Yes.
Full stop. The scheme came to be challenged by the employees of the respondent number 3 and other employees union in WP number 42641-680/2001 connected with 43871-872/2001, challenging certain clauses contained in the agreement. Full stop. The writ petition was disposed of in terms of an order dated 28/12/2001. Full stop. As part of the settlement arrived at between the respondent number 1 and the respondent number 2.
One submission.
Ah,
What has happened after the passing the orders in the repetitions, what your lordships have now observed? They, very same unions, they filed writ appeals, my lord. They have
Writ appeal.
writ appeals. I will give the numbers, my lord, which my friend cannot dispute that.
now how does it matter? Writ petition, the same terms were upheld.
No, the repetition was disposed of with a
Please
direct.
wait, I'll come to you. I am only recording whatever facts that he has mentioned in the
Yes,
writ
yes,
petition.
Yes,
there's no problem.
Full stop. Yeah, so the petitioner submitted his resignation on 14/10/2013. And he was relieved from duties on 13/11/2013. Full stop. The respondent number 3 called upon the petitioner to furnish the office orders issued by the respondent number 1 for fixing his pay and allowances. Consequent to which, the petitioner furnished the details. Full stop. The petitioner contends that after relieving his services, his accounts were not settled. ಏನು ಈ ತರ ಹೇಳ್ತೀರಾ?
ಅಲ್ಲ 2 ತಿಂಗಳದ್ದು ಸಂಬಳ ಮತ್ತು
ಅಲ್ಲ, you
ಪ್ರಾಪರ್
said-
ಪೇ ಫಿಕ್ಸೇಷನ್ ಮಾಡಲಿಲ್ಲ ಅಂತ.
So ನೀವು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಮೇಲೆ
ಹೌದು, ಅಲ್ಲ ನಾನು ಹೇಳಿದ ಹಾಗೆ, ಯಾಕಂದ್ರೆ ಅದರಲ್ಲಿ ನಾನು ರಿಪಿಟೇಷನ್ ಮೇಂಟೈನಬಿಲಿಟಿಗೆ ಅದನ್ನು ಮಾಡಿ.
ಅಲ್ಲ ಕರೆಕ್ಟು.
Yes.
ಸುಮ್ಮನೆ ಅಂದಾಜ್ ಮೇಲೆ ಹಾಕಿದ್ದೀರಾ ಟು ಮೇಂಟೈನ್ ದ ರಿಟ್ ಪಿಟಿಷನ್.
Yes.
Yes, madam.
ಆಯ್ತು.
ಹಾಗೆ ಅದು ಒಂದು ಟೈಮ್ ಸೆಟ್ಲ್ ಮಾಡ್ತೀನಿ ಅಂತಂದ್ರು.
Accounts were not settled, which compelled the petitioner to make repeated representations. Full stop. Despite the representations, the respondent number 1 did not make any settlement. On the contrary, it sent a reply through its advocate on 24/7/2014,
Yes.
declining to consider the request of the petitioner. In view of the understanding entered into between it and the respondents 2 and 3. Full stop. The petitioner thereafter pursued the matter with the respondent number 1 by sending letters dated 26/8/2014, which was again replied by the respondent number 3 on 12/9/2014, indicating that they had deposited the amount due to the petitioner in his account at Axis Bank. Full stop. The petitioner, not satisfied with the same, issued another notice dated 15/9/2014, calling upon the respondents to furnish a detailed amount statement containing all the amounts due to the petitioner. Full stop. The petitioner is therefore before this court challenging the reply issued by the respondent number 1 and has sought for consequential directions as stated above. Next paragraph. The learned counsel for the petitioner reiterated the above contentions and submitted that the respondent number one was bound to furnish the details of all the amounts payable to him. Full stop. Next paragraph. The learned counsel for the respondent, even objection hakidira?
ಹಾಕಿದ್ದೀನಿ.
Yes, ma'am.
ಇವ್ರು ಹಾಕಿದ್ದಾರೆ.
29/7/16
Number 1
and produced.
ಇಬ್ರು ಹಾಕಿದ್ದಾರೆ.
has filed its statement of objections. Contending that as per the scheme of disinvestment, the respondent number 1 had transferred the respondent number 3 hotel to the respondent number 2. Full stop. As per the understanding, the respondent number 2 took over the charge of the respondent number 3 for a period of 30 years. As per Article 13 of the agreement, the respondent number 2 had agreed to continue the service of regular employees of the respondent number 3 on the same terms and conditions. And in clause 13 bracket 1 bracket small Roman 3 of the agreement, the respondent number 2 had agreed to give all the benefits required to be statutorily given to all the employees. Full stop. It therefore contended that it has no liability whatsoever to the petitioner. Full stop. It did admit that the employees of the respondent number 1 and 3 had challenged the disinvestment scheme in WP number 42641-680 of 2001, which was dismissed, and therefore contends that the petitioner cannot have any grievance against the respondent number 1 relating to the scheme. Full stop. It also claimed that the writ petition under Article 226 of the Constitution of India cannot be filed challenging a reply issued through the advocate for the respondent number 1. It's a reply issued to the notice sent by the petitioner through his advocate, and therefore the writ petition is misconceived. It further contended that as part of the disinvestment program, the respondent number 1 had given an option to all its employees either to continue their service in the respondent number 2 or seek for voluntary retirement. The petitioner had opted for continuation of service, and therefore the terms and conditions entered into between the respondent number 1 and respondent number 2 is binding on the petitioner. Stop. Next paragraph. The respondent number 2 and 3 have also filed a statement of objections, contending that as per the disinvestment scheme, they took over the respondent number 3 along with its business Full stop. It claimed that all the employees of the erstwhile, all the employees of the respondent number 1 many of the employees of the respondent number 1 had availed VRS and many of them had submitted resignations. It, however, contended that the petitioner was continued in service from the date of the lease cum management agreement dated 29/11/2011. Full stop. It contended that the respondent number 3 accepted this resignation submitted by the petitioner and he was relieved of his duties on 13/11/2013 and therefore he ceased to be an employee of the respondent number 3 with effect from 29/11/2011 and became the employee of the respondent number 2 and 3 till he resigned on 14/10/2013. They claim that the petitioner was paid all the terminal benefits by crediting it into his account at Axis Bank. Full stop. Therefore, contended that the petitioner has no right to make any claim against the respondents 2 and 3. Full stop. The learned counsel for the respondent number 1 and 2, 1, 2 and 3 reiterated the contentions made in the written statement in the statement of objections. Next para. The facts are the fact that there was a disinvestment scheme in terms of which the hotel of the respondent number 1, namely respondent number 3, was taken over by the respondent number 2 for management. Full stop. It is not in dispute that as per the terms of the scheme, the petitioner continued in service of the respondent number 2. Therefore, for all practical purposes, the petitioner continued in employment of the respondent number 2 until he submitted his resignation in the year 2013. Full stop. Therefore, the petitioner was not well advised to cause a notice to the respondent number 1 for demanding a statement of the amounts payable to him. Full stop. The petitioner must have been cautious while expressing his option to continue in services of the respondent number 2. Full stop. If the petitioner is laying any claim to any entitlement to which he was entitled to when he was in service of the respondent number 2, the remedy to the petitioner is not to file a writ petition, as respondent number 2 is neither a state nor an instrumentality of state or other authority amenable to the jurisdiction of this court. Therefore, the proper remedy for the petitioner was to approach the competent civil court for adjudication of his claim. Full stop. In that way of the matter, this writ petition is not maintainable and the same is dismissed. However, liberty is reserved to the petitioner to approach the competent civil court to espouse his cause and claim the benefits that he is lawfully entitled to. If a civil suit is filed, the time consumed in pursuing this petition shall be deducted while calculating the limitation applicable.
Serial number 52 and 53 are adjourned. Serial number 54, PM Naik. Serial
PM
number
Naik. Ashwini
Lordships, in
Rajgopal.
this matter,
Hmm.
in this matter, I appeal for the respondent number 1, Your Lordships. This matter needs to be connected with petition number 13376 of 2018, Your Lordships. In both the matters, Your Lordships, there is a challenge by the petitioners to the grant of revision of the pay scale, Your Lordships. So both the matters
That is
will be
entirely
connected.
different matter. Grant of pay scale there. Here,
Are you ready?
I'm ready, my lord.
Are you ready, Mr. Ashwini? What is this? Ashwini Rajgopal, are you ready?
Kindly a date may be granted, Your Lordships. Short
I'll-
date may be granted.
No, I'll
Next
fix a
week.
date, but
We are ready, Your Lordships. Date may be granted, Your Lordships.
that
Next
is
week.
right, but everybody wants time. Everybody say next week, everybody will says the same thing. I'll get ready. Yes, who is Ashwini Rajgopal?
I appear for the respondent number 1, Your Lordships.
Please get, he is ready, petition is ready, I am going to hear him. I will not wait for
Kindly
you.
time.
No, I will not wait for you, mister. If the petitioner's advocate is ready, I will take it up. Yield.
ಬೇಕಾದ್ರೆ ಫೈನಲಿ ಕೊಟ್ಬಿಡಿ, ಐ ಆಮ್ ನೋ ಇಶ್ಯೂ.
ನೀವು ರೆಡಿ ಇಲ್ಲ ಅಂತ
ಅಲ್ಲ, ರೆಡಿ, ಐ ಆಮ್ ರೆಡಿ ಮೈ ಲಾರ್ಡ್.
ಮತ್ತೆ ಆರ್ಗ್ಯೂ ಮಾಡಿ.
ಟು ಸೇವ್ ದ ಟೈಮ್ ಆಫ್ ದ ಕೋರ್ಟ್ ಮೈ
ಬೇಡ ಬೇಡ ಬೇಡ, ತೊಂದರೆ ಇಲ್ಲ, ನನಗೆ ಇನ್ನ 2.5 ಗಂಟೆ ಇದೆ.
Lord, the petitioner was, my Lord, is employed as foreman in Karnataka Regional Engineering College, Surathkal, my Lord. No, my Lord, that is now reclassified as NITK. Lord, then, my Lord, 17/2004, Government of 2002, my Lord, Government of India converted all RECs to NITKs, my Lord, NITs. My Lord, then, my Lord, 17/2004, my Lord, Government of India issued clarifications for rationalization of pay scales in all NITs, my Lord. My Lord, then 11/2006, my Lord, the government issued directions to the restructuring of the post, my Lord. This is annexure R6, my Lord. There, my Lord, statement of objections. My Lord, that's this foreman, erstwhile foreman, they are under the cadre of academic technical service, my Lord. They are cadre earlier. My Lord, the annexure R6, my Lord, specifies, my Lord, page 40. My Lord, scientific and technical services must be designated as, there are 3 categories, my Lord: principal scientific technical officer, senior scientific technical officer, scientific/technical officer. My Lord, this petition, my Lord, has to be designated as technical officer, my Lord, under the pay scale of PB3, grade pay of rupees 5,400. My Lord,
No, PV3 is grade pay of 7,600.
no, that is not for this, my Lord. This is
Technical officer.
technical officer, my Lord. Senior.
Yes.
He is entitled for this redesignation, my Lord. My Lord, the other NIT case in annexure Q, my Lord. All other NIT case, they have redesignated the post of foreman as
Annexure Q, no?
Q, my Lord. Annexure Q, R and S, my Lord.
Yes, please.
Page number 102, 104, 102, my Lord.
Annexure Q is page 99.
Yes, my Lord, 99, my Lord.
Ah.
That is related to Kurukshetra, NITK Kurukshetra.
Alla, foreman,
100 ಅಲ್ಲಿ foreman in the technical officer.
technical officer.
ಹೌದು,
Grade pay 5,400.
5,400. Annexure R ಅಲ್ಲಿ ತಿರುಚಿರಾಪಳ್ಳಿ foreman of next 100/02 ಅಲ್ಲಿ redesignated as technical officer. Annexure S related to Durgapura, technical officer. My Lord,
ಇಲ್ಲಿದೆ annexure S ಅಲ್ಲಿ ಏನಂತಿದೆ?
annexure S ಅಲ್ಲಿ page 104, my Lord.
104,
The
technical
persons who
officer.
are holding foremen, they have appointed as technical officer.
ಇದು ಯಾವ್ದು ಬೇರೆ ಇದೆಯಲ್ರಿ ಇದು?
104 ಅಲ್ಲಿ.
This is with effect from 2013. What was the grade pay then? 6,600 ಅಂತಿದೆ.
ಹೌದು, ಅದು ನೆಕ್ಸ್ಟ್ ಕಾಲಮ್ ಅಲ್ಲಿ.
Correct. Next, please come to annexure.
ಅಲ್ಲ, ಅಲ್ಲಿ ಗ್ರೇಡ್ ಪೇ ಜಾಸ್ತಿ ಕೊಟ್ರು. Here, my Lord, this Kurukshetra, they have given grade pay of 6,600.
Next pay band.
Pay band same 15,600 to 39. ಅದು ಬ್ಯಾಂಡ್, ಗ್ರೇಡ್ ಪೇ ಜಾಸ್ತಿ ಕೊಟ್ರು. ದಟ್ ಇಸ್ ದ ಇಶ್ಯೂ. ಬೇರೆ ರಿಪಿಟಿಷನ್ ಇದೆ ಗ್ರೇಡ್ ಪೇ ಕೊಡುವಂತದ್ದು, ಗ್ರಾಂಟ್ ಆಫ್ ಪೇ ಸ್ಕೇಲ್. It is not on that, my Lord.
Yes.
My Lord, then, my Lord, this first respondent, my Lord, they have given the restructuring to the petitioner, annexure L, my Lord.
Yes.
Annexure L, my Lord, page 80, my Lord. Lord, the existing designation, foreman, my Lord, assistant engineer ಕೊಟ್ಟು. This post was not in the rules, my Lord. Not in the rules, not in the direction. Annexure R6 ಅಲ್ಲಿ ಇಲ್ಲ ಅದು. My lord, then my lord, that the petitioner submitted a representation, annexure M, my lord, stating that this post is not available and he is entitled for the restructuring of technical officer, my lord.
Senior administrative officer ಅಂತ ಇದೆ.
ಅಲ್ಲ ಇವರು ಜಾಸ್ತಿ ಕೇಳ್ತಾರೆ, ಈ ಅದು ಮೇಲ್ಗಡೆ ಕೇಳ್ತಾ ಇದ್ರು ಇವರು, ಬಟ್ ಈಸ್ ರಿಯಲಿ ಎಂಟೈಟಲ್ಡ್ ಫಾರ್ ದ ಟೆಕ್ನಿಕಲ್ ಆಫೀಸರ್.
No, as per MHRD notification, foreman category is treated as senior administrative.
ಅವರು ದೇ ಆರ್ ಆಸ್ಕಿಂಗ್ ಇಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಏನು ಮೇಲ್ಗಡೆ ಅದು ಕೇಳ್ತಾ ಇದ್ರು, ಇಲ್ಲಿ ನಾವು ಈಗ annexure R6 ಅಲ್ಲಿ ಫಸ್ಟ್ ಕ್ಯಾಟಗರಿ ಕೇಳ್ತಾ ಇದ್ರು, ಬಟ್ ಆಕ್ಚುಲಿ ಈಸ್ ಎಂಟೈಟಲ್ಡ್ ಫಾರ್ ದ ಟೆಕ್ನಿಕಲ್ ಆಫೀಸರ್, ಮೈ ಲಾರ್ಡ್. No, then it was not considered, my lord. Then annexure N, my lord. They have the first respondent board, my lord. No, annexure P. It was annexure P.
Yes.
Page number 93, my lord. Adali item number 36.4.2. BOG resolved to approve in principle the report submitted by the restructuring committee for the non-teaching staff and also approve the roster. This is not specifically, this is only general agenda, my lord. There is no specification of the redesignation from foreman to assistant engineer.
So what is the date of annexure, page 93? 2013.
13. My lord, this is the board minutes, my lord. They are referring in the annexure L, my lord. Annexure L. Annexure L ಅಲ್ಲಿ 2, reference number 2. It will, they are referring this, but this is not board minutes related to redesignation, my lord. Specifically illa ಅಲ್ಲಿ. My lord, then my lord, this again, my lord, it was reclassified as annexure, wide annexure U, my lord. He was promoted as assistant executive engineer. That petitioner, my lord. This also is not in the rules, my lord. He has to be promoted as from technical officer to senior technical officer, my lord.
Yes.
That is the annexure R10 produced by the respondent.
Except the designation, were you given the same pay band?
Illa. That is the main, my lord.
5,400 ಕೊಟ್ಟಿಲ್ವಾ?
ಅಲ್ಲ 5,400 ಈಗ ಪ್ರಮೋಟೆಡ್ ಪೋಸ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅವರಿಗೆ. ದಿಸ್ ಪ್ರಮೋಟೆಡ್ ಪೋಸ್ಟ್ ಇದರಲ್ಲಿ ಟೆಕ್ನಿಕಲ್ ಆಫೀಸರ್ ಆಗ್ಬೇಕು, ಆಮೇಲೆ senior technical officer.
When you were granted this benefit of assistant engineer,
ಹೌದು,
annexure R6 ಅಲ್ಲಿ,
ಹೌದು,
what was the
annexure L, my lord.
R6 ಗೆ annexure R6 ಅಲ್ಲಿ what was the pay band?
R6 ಅಲ್ಲಿ assistant engineer ಪೋಸ್ಟೇ ಇಲ್ಲ.
ನಾನು ಕೇಳಿದ್ದು ಟೆಕ್ನಿಕಲ್ ಆಫೀಸರ್ ಅಂತ ಅಂದ್ರಲ್ಲ,
ಹೌದು,
ಅದಲ್ಲಿ PB3 ಗ್ರೇಡ್ ಪೇ ಆಫ್ 5,400 ತಾನೇ ಇದ್ದಿದ್ದು.
ಹೌದು.
ನಿಮಗೆ ಅಸಿಸ್ಟೆಂಟ್ ಇಂಜಿನಿಯರ್ ಅಂತ ಕೊಟ್ಟಾಗ ವಾಟ್ ವಾಸ್ ದಿ ಗ್ರೇಡ್ ಪೇ?
ಅದು ನಾನು ಐ ವಿಲ್ ಗೆಟ್ ಮೈ ಲಾರ್ಡ್ ದಟ್ ಪೇ ಬ್ಯಾಂಡ್ ರಿಲೇಟೆಡ್ ಟು ಅಸಿಸ್ಟೆಂಟ್ ಇಂಜಿನಿಯರ್ ಮತ್ತೆ ಅಸಿಸ್ಟೆಂಟ್ ಇಂಜಿನಿಯರ್ ನಾನು ನಾಟ್ ಅವೈಲೇಬಲ್.
ಯು ಆರ್ ಆಲ್ಸೋ ನಾಟ್ ರೆಡಿ.
ಅಲ್ಲ, ರೆಡಿ ಅಂದ್ರೆ ಆಗಲ್ಲ ಇದರಲ್ಲಿ. ಐ ಹ್ಯಾವ್ ನಾಟ್ ಡ್ರಾಫ್ಟೆಡ್ ದ ಪಿಟಿಷನ್, ಮೈ ಲಾರ್ಡ್. ಐ ನೋ ಸಿ
ಸರ್, ದ ಮ್ಯಾಟರ್ ಇಸ್ ಕಮ್ ಅಪ್ ಫಾರ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಇನ್ B group. I have not drafted the writ petition.
ಅಲ್ಲ, ಈ ಪರ್ಟಿಕ್ಯುಲರ್ ನೋ ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಇಟ್ಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ರಿಲೇಟೆಡ್ ಟು ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಹಾಕೊಂಡ್ರೆ ನಾನು ಐ ವಿಲ್ ಗೆಟ್ ಕಂಪ್ಲೀಟ್ ಇಂಟ್ರೆಸ್ಟ್.
Rogi by
no, I also thought of that, my lord. My lord is correct, my lord. That what is the difference of this?
It's only
how it affect this one? I also thought of, my lord.
It's only redesignation.
Redesignation, whether it affects on pay band and all. From 2014 in the retired ಆಗಿದ್ದು 20 retired ಆಗಿದ್ದು during the pendency. Petition retired, my lord. If it is related to effect on the pay scale, then he has got a case, my lord. I have thought of that.
But you thought of what you did.
ಅಲ್ಲ, ನಿನ್ನೆ ನಾನು ಫೋನಲ್ಲಿ ಸಿಕ್ಕಿಲ್ಲ. This particular point, it's only that much.
You thought
Monday,
of what you did not come with a solution.
Monday, Swami. I'll assist and next Monday.
One counsel for the petition seeks time as the last chance list on.
Both the counsels. How to put a time?
ನೀವು ತಾನೆ first I told you, gave you the first option. Are you ready?
You show the point.
You are not ready. So therefore.
I'm sorry, my lord. Next Monday. Next Monday, my lord.
Next.
55. Chandrasekhar GM.
GM Chandrasekhar.
Regarding the
Hardship.
claiming service benefits
ಯಾವ್ದು?
prior to serial number 55. Granting aid law, right?
Ready na?
Which is pending before.
The Lordship is not feeling well. Kindly have it next week. I am a practice counselor.
ಏನಾಯ್ತು ಅವ್ರಿಗೆ?
ಮೈಯಾಗ ಹುಷಾರಿಲ್ಲ ಅನ್ಸಮ್ಮ.
ಮೈಯಾಗ ಏನ್ ಹುಷಾರಿಲ್ಲ?
ಏನ್ ಗೊತ್ತಿಲ್ಲ ಸರ್.
ಕೇಳ್ಬೇಕಲ್ರಿ, ಕರೆಕ್ಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೋಬೇಕಲ್ಲ. ಅವ್ರು ಸಾಹೇಬ್ರು ತುಂಬಾ ಸ್ಟ್ರಿಕ್ಟ್ ಅಂತ ಹೇಳ್ಬೇಕು ನೀವು ಅವ್ರಿಗೆ. ಎಲ್ಲ ಹೇಳ್ಬೇಕು ಅಂತ. ಸುಮ್ನೆ ಮೈಯಾಗ ಹುಷಾರಿನ ಟೈಮ್ ಕೊಡಕ್ ಆಗೋದಿಲ್ಲ.
Kindly have it next week.
Issues pending before division bench. Also, they are claiming service benefits prior to granting aid law. That issues is pending.
The
2476.
learned AGA submits that the petitioners have sought for service benefits prior to their appointments being admitted to grant in aid, and that the issue is pending consideration before the division bench.
Appeal number
In writ appeal
2476 of 15.
2476 of 2015. Hence list this petition after disposal of writ appeal number sounds. Yes.
Number 56, Yogesh Nayak.
Yogesh Naik. Yogesh.
59.
Yogesh Naik. Here all government advocates, I am going to issue a advance list. ನೀವು ದಯವಿಟ್ಟು ಪ್ರಿಪೇರ್ ಆಗಿ ಬನ್ನಿ. ಇಟ್ಸ್ ಎ ರಿಕ್ವೆಸ್ಟ್ ಟು ಆಲ್ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಸ್. ಬೇಕಾದ್ರೆ ಒಂದು ವಾರದ ಮುಂಚೆನೆ ಲಿಸ್ಟ್ ಇಶ್ಯೂ ಮಾಡಿಸು ಅಂದ್ರೆ ಮಾಡಿಸ್ತೀನಿ. There is no representation for the petitioner and the respondent. List as a last chance on.
11-3.
Hmm.
Serial number 57.
For the
Yes, Victor
respondent.
Manoharan.
I'm sorry, my lord, I have not signed the objection slip. That is one of
No,
the
mad-
office subject.
ಮಾಡಿ.
Lordship, may kindly have it next week.
Oh, sorry. ಎಲ್ಲರೂ ಹಂಗೆ
I'm sorry, my lord. First time I'm taking a date. my lord.
ಅಲ್ಲ, this is the second time sitting in service roster, so
ಅಲ್ಲ,
you can
ಇದರ-
rest be
ಇದರಲ್ಲಿ
assured
ನಾನು
that I
type-
also know something.
Ella, definitely I will.
If you're trying to
I will
test the
assist you.
water.
Week's time on the, ಅಥವಾ the day after tomorrow also.
ಸರ್, ಇವತ್ತು ಅಲ್ದಿದ್ರೆ ಅದು ಅರ್ಜೆಂಟ್. ವೆದರ್ ಇಟ್ ಇಸ್ ಇವತ್ತು ಅಲ್ದಿದ್ರೆ ಇಟ್ ಇಸ್ ಅರ್ಜೆಂಟ್. ವೆದರ್ ಟುಮಾರೋ, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ, ನೆಕ್ಸ್ಟ್ ವೀಕ್, ನೆಕ್ಸ್ಟ್ ಮಂತ್, ನೆಕ್ಸ್ಟ್ ಇಯರ್, ಇಟ್ ಇಸ್ ಅರ್ಜೆಂಟ್. Why should I quarrel with the lawyers for
ಬೇಡ ಬೇಡ,
adjournment?
ಅಲ್ಲ
ನೀವು ಗಲಾಟೆ
ಇಲ್ಲ, ನಾನು I am also ready. Today I have got some.
ಅಲ್ಲ, ನಾನು ಫಸ್ಟ್ ನೋಡಿ, ಫ್ರಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 34 ಇಂದನೂ ಎವ್ರಿಬಡಿ ತೋಡಿ ರಾಗದಿಂದನೇ ಶುರು ಮಾಡೋದು ಪ್ರತಿಯೊಬ್ರು.
I'm sorry.
From serial number 34, everybody is asking for time.
ಸಿದ್ಲಿಂಗಪ್ಪನ ಸಿದ್ಲಿಂಗ
ಎಲ್ಲಿ
57 ನೀವಿಲ್ಲ.
ರೆಡಿನಾ?
ಇಲ್ಲ ಅವರಿಲ್ಲ ಗೌರ್ಮೆಂಟ್.
ಅಲ್ಲ, ಯೋಗೇಶ್, ಯು ರೆಡಿ? ಪ್ಲೀಸ್ ವೆಯ್ಟ್, ದೆನ್ ಪಾಸ್ ಓವರ್ ಮಾಡ್ರಿ. 56 ಪಾಸ್ ಓವರ್.
7.
ನೀವು ರೆಡಿನಾ?
6 minutes.
ಎಸ್, ಹೇಳಿ ನರಸಿಂಹಸ್ವಾಮಿ, ಎಷ್ಟು ಏನಂತ ಹೇಳಿ, ವಾಟ್ ಈಸ್ ಇಟ್ ಅಬೌಟ್?
My lords, regarding promotion from grade 4 to grade 5, my lords, with effect from 1/6/2012, my lords, on which date he became eligible, my lords. And petitioner, my lords, was appointed as an assistant security officer, grade 1. My lords, on 1/6/1989, my lords. And time to time, my lords, on 26/10/96, 1/6/2001, and 1/6/2007, my lords, he was promoted as grade 2, grade 3, and grade 4.
1/6/2011.
No, 1/6/2012, my lords, he was eligible for promotion from grade 4 to
That's
grade
okay.
5, my lords. And that was not considered, my lords, and he had made several representations also. And the reason what the respondent says, my lords, is annexure A, my lords, which I am challenging, my lords, because there, my lords, they have categorized as A, B, and C. And for B category, my lords, they have stated that the career horizon would go up to grade page number 20, my lords. The career horizon would go maximum up to grade 4 level. Further promotion for grade 3.
Ready?
column 4, my lords,
Column number 4 of,
4 of page number 20.
row
Annex
number
A.
5 or what?
No, 4.
4. Yeah.
Bachelor degree, my lords,
Hmm.
because petitioner is a bachelor degree holder.
Hmm.
The last column, my lords, the career horizon would go up to maximum of grade 4. For the promotion from grade 3 to grade 4, 4 ACR ratings out of 6 shall have to be outstanding. And
So-
for diploma holders, my lords, they say that career horizon would, that is one above, my lord, that is 3 diploma holders.
Correct, you have
The
not done any
career
engineering.
horizon would go up to 4.
Correct, but diploma engineering, they have done an engineering subject.
Engineering subject.
So therefore, you have done only a BA or BSc.
BSc, my lord, but
BSc.
that, no, he's a BSc graduate, my lord.
So therefore, you
is-
don't have an engineering background.
No, this is CDP promotion, my lords. That is time-bound promotion. Next page, my lords, is non-CDP promotion,
Hmm.
selection process and vacancy, my lords.
Yes.
Here, my lords, from grade 4 to grade 5, B category is 5 years, my lords. And for the criteria, my lords, is 3 outstanding and during the preceding 5 years.
Yes.
Petitioner has got all these qualifications, my lords. And in spite of that, my lords, he was not considered. Even as per the earlier
Yeah, what is the CDP promotions?
CDP, my lords, CDP is time-bound promotion, my lords.
Time-bound manner.
And non-CDP is through selection process and vacancy, my lord, existing vacancies,
So under the CDP promotion, you reach the maximum.
maximum, my lords.
So
And the
non-CDP, you are
non-CDP,
entitled.
Please, my lords, that has not been considered, my lords.
Hmm.
And he has made several representation. My lords may kindly take page number 45, my lords.
Yeah, but have you got these 3 outstanding during the 3 preceding 5 years?
As per the petitioner, my lords, he say he has got it, my lords.
Where is
But
it?
that is confidential, my lord. It'll be with them.
Hmm.
It will be the respondent, my lords. Therefore, my lords, my second prayer, my lords, is to direct them to
Yes.
submit the records pertaining to the process, followed by the sanctioning promotion of non-technical and technical staffs to B category, my lords. That is my second, because that's a confidential report and it has to be submitted by the respondent, my lords.
What is this category B?
Category B, my lords, degree holders, my lords,
The
are
category
categorized.
B is graduate engineers. Please come to page 19. Category B, qualifications refer to graduate engineers, engineering diplomas.
Category A is graduate engineers, my lords.
Please read
Category
further.
B is postgraduate diploma holders, and petitioner, my lords, has passed a post-graduation diploma in HR also, my lords. He has not been considered under B plus category. And diploma holders, my lords, B. And below diploma, my lords, bachelor degree is also B category. And the last one is C category.
How is it relevant to the area of operation in addition to the existing qualification prescribed possessed by the employees? Your degree is BSc,
BSc
correct?
and diploma, my lords.
BSc
BSc
and
and diploma in HR,
PG
Post-
diploma in
PG
HR.
diploma.
So how is it relevant to the area of operation? How is it relevant?
Well,
If you had
it's,
obtained a MSc degree, if you had obtained an MSc degree, you could qualify to become a category B plus.
B plus.
If
But-
you obtained a degree which does not have any relevance to the area of operation. For example, even on centrifugal pump,
Well, he's a security officer, my lord.
is a security officer. Hmm. PG diploma in what?
PG diploma in HR, my lords. I have produced, my lords, page number 59, my lords.
Hmm.
Page number 59. And it is also incorporated as an additional qualification by the department. my
Yes,
lords.
what about this furnished security service record?
I will secure it, madam. I will secure. it.
ಯಾವಾಗ?
Two days time, 2 days ಅಥವಾ next week ಹಾಕಿದ್ರೆ
ಇಲ್ಲ,
leave it to the court.
This week I will be liberal, next week cost.
ಬೇಡ ಈ ವಾರದಲ್ಲೇ ಹಾಕಿ sir.
ಅಲ್ಲ, ಈ ವಾರನೇ ಇವತ್ತು ಅಲ್ದಿದ್ರೆ ಮುಂದಿನ ವಾರದಿಂದ ಕಾಸ್ಟ್ ಹಾಕ್ತೀನಿ. Let
ಬೇಡ.
lawyers, let
Your
lawyers
lordship
be
may have
aware.
it day after tomorrow.
ಅಲ್ರಿ ಇವತ್ತು ಅಲ್ದಿದ್ರೆ ಈ ವಾರದಲ್ಲಿ ಅಡ್ಜರ್ಮೆಂಟ್ ಐ ಆಮ್ ಲಿಬರಲ್,
ಸರಿ ಸರ್.
ಮುಂದಿನ ವಾರದಿಂದ ಕಾಸ್ಟ್. ಸೊ ದಟ್ ಲಾಯರ್ಸ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್.
ಆಯ್ತು.
ಈಗ ಹಳೆ ಮ್ಯಾಟರ್ಸ್ ಇನ್ ಹೆಂಗ್ರಿ ಡೀಲ್ ಮಾಡೋದು?
ಇದು
Will
ಏನಾಗಿದೆ?
these old matters get closed?
Definitely, I filed my objection.
For the lawyers to say next week.
I filed objections also. Aದೇನು some mistake ಆಗಿದೆ, ಅದನ್ನ I'll rectify it.
The learned counsel for the respondents 192 is directed to place on record the service record of the petitioner.
ಮೈಸೂರು ಅಲ್ಲ. ಮೈಸೂರು.
The list ಯಾವತ್ತು?
Next Monday or Tuesday.
ಕೊಡ್ರಿ ಯಾವತ್ತು?
Tuesday, 11th March.
ಆಯ್ತು. Most.
Serial number 58, urgent, serial number 59.
HM
KB.
KB Muralidhar.
I appear for.
Case. Who appears for the other side?
Government, my lord. In fact, my lord, this is a petitioner is a retired chief officer. During the pendency of this petition, my lord, his claim for settlement of pensionary benefits have been settled. My lord, but this honorable court, my lord, had order dated, my lord, 11/6/2019. Order sheet may kindly be seen, my lord.
Yes.
Directed the government, my lord, to settle the pensionary 11/6/2019, my lord.
Yes, please read.
Merit, it is true that the petitioner's retirement benefits has not been settled as and when he was retired on 31/3/1994. For the reason that he was subjected to disciplinary proceedings and it was concluded on 4/6/2003. While imposing penalty of withholding of 1/4 of pension on permanent basis. It is bounden duty of the respondent to release the rest of the retirement benefits which while calculating the except 1/4 of pension from 4/6/2003 onwards. From 31/3/1994 till 4/6/2003, he is entitled for full pension on permanent basis. In this regard, respondents are hereby directed to calculate and disperse along with the interest at the rate of 8% and produce such order within 3 weeks. Failing which the first respondent principal secretary shall be present in appeal. My lord, the pensionary benefits pursuant to this order has been settled. My lord, I have filed a memo along with the settlement of pensionary benefits.
Yes.
Only thing left is, my lord, he has to be paid 8% interest on the delay settlement of pension benefits. Let them do that, my lord, let them.
Lordship, actually, with his services with regard to the panchayat, it comes in a different department, your Lordship. And since with regard to the interest approval, some 50,000 odd amount is there, your Lordship. But the finance audit have raising objections, since there is no provision in the law to give interest on that, your Lordship. What that, order? please, that's what, your Lordship. I have apprised them, your Lordship, to comply with that also, your Lordship. A week's time, your Lordship. Learned AGA seeks time to comply the order. Lordship, to make his submissions a week time. To comply and I can, they are still. Learned AGA seeks time to secure instructions regarding compliance of the order dated 11/6/2019. List on Yavat. Obliged. Any date. On what?
12th March.
12th.
Number 60.
Obliged.
Lord, in 60, my lord, I appear for the petitioner. Lord, petitioner, my lord, he was working as bus stand sergeant.
There are other side.
Other side government.
In this, your Lordship, in the parawise instructions I have received, your Lordship, it appears that they have not been filed. A day's accommodation, your Lordship, I will put it on record. Next week in the cast. Please. Learned AJ seeks time to file statement of objections as a last chance list on
12th March.
obliged. To pass over yesterday. Huh? 10. Good.
First floor matter, serial number 25.
25.
Serial number 25.
Karnataka
P.
Associates.
Karnataka Associates.
Karnataka Associates. ಯಾರು ಬರ್ತಾನೆ ಇಲ್ವಾ? ಹ? 16 last ಬಂದಿದೆ. There is no representation for the petitioner, though it is called twice in the day. And the last chance list on
12th March. Serial number 30. Nagesh N. Okay.
Petitioner in this case. What is that copy, Your Honor?
What is this petition?
Petition number 7047, Your Honor, and 5359.
What was the direction issue?
Your Honor,
What was the direction issued in this petition?
in this, Your Honor, the respondents are hereby directed to continue to service of the petitioners as a teachers till regular recruitment, Your Honor. I am the regular recruitment candidate in this case, Your Honor. And for me, they have transferred from Ekalavya Residential School to Gandhi Tattva Residential School. There, and I went there and I joined, Your Honor. That is,
But who was the person who was there earlier?
no, Your Honor, in that they have not declared. In the annexure G, they have not clearly said that who is that earlier person working there.
No, but you were appointed and posted here.
Your Honor,
Were you appointed and posted here for the first time?
first time I appointed in Ekalavya School, Your Honor. After that, they have transferred me to that.
So therefore, I am asking you,
Your Honor.
was there any person earlier who was working here? Gandhi Tattva Adharita Vasati Shale.
No, Your Honor, it's a vacant place. They have, it's in annexure E, Your Honor. Kindly see the annexure E, Your Honor. In that, they have clearly said that ಖಾಲಿ ಇರುವ ಹುದ್ದೆಗೆ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸಿ ಆದೇಶಿಸಿದೆ. It's last line, Your Honor. When I was there was no one was working in that place, Your Honor. And moreover, this order has been passed.
AG is directed to accept notice for the respondent number.
Stay may be granted, Your Honor.
Respondent number 1 and 3 to 3. Yaru Krais yaru?
Siddharth Baburao, Your Honor.
Yeah?
Siddharth Baburao.
Siddharth Baburao is directed to accept notice for respondent number 2. Till the next date of hearing, comma, the impugned order is stayed. List on date good.
So by hand, Your Honor.
For what? No one else is there, isn't it?
Yes, Your Honor.
No? We'll upload it.
18th March. Serial number 33. SN Bhatt.
Mr. SN Bhatt. ಅವ್ರು ಯಾರ ಕಲೀಗ್ ಬಂದಿದ್ರಲ್ಲ.
Serial number 33.
MC Veerabhadraya.
Covered by judgment. Similar matter has been.
Yeah, what are the facts?
That is on 17/1/2017. They have confirmed that the petitioner will confirm and then withdraw the order, my lord, sir. That has been challenged before this honorable court.
Annexure E and F. What is annexure E? ಗೌರವಾನ್ವಿತ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ದಾಯವ ಸಂಖ್ಯೆ ಮುಗಿಸುವ ಅನುಷ್ಠಾನಗೊಳಿಸುವ ಬಗ್ಗೆ.
ಆದೇಶ
ಹ್ಮ್
ಕರ್ನಾಟಕ ರಾಜ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ನೀಡಿರುವ ತೀರ್ಪನ್ನು ಪರಿಗಣಿಸಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು that has been reinstated, my lord, and
No, please read it further.
ವಿಶ್ವಭಾರತಿ ವಿಶ್ವ ಗುಬ್ಬಿ ವತಿಯಲ್ಲಿ ತುಮಕೂರು ತಾಲೂಕು ಮಲ್ಲಸಂದ್ರದಲ್ಲಿ ನಡೆದಿರುವ ಅನುದಾನ ಶ್ರೀ ವಿಶ್ವಭಾರತೀಯ ಹಿರಿಯ ಪ್ರಾಥಮಿಕ ಶಾಲೆಯಲ್ಲಿ 4, 5, 6 ಮತ್ತು 7ನೇ ತರಗತಿಯಲ್ಲಿರುವ ಹೆಚ್ಚುವರಿ ಅನುದಾನ ರಹಿತ ವಿಭಾಗಗಳಿಗೆ ಆಡಳಿತ ಮಂಡಳಿಯ ನೇಮಕಾತ ಮಾಡಿಕೊಂಡಿರುವ ಶ್ರೀ ಮುತ್ತುರಾಯಪ್ಪ ಶ್ರೀ ಬಿಜಿ ಸುಗಂಧರಾಜ್ ರಾಮಕೃಷ್ಣಯ್ಯ ಹಾಗೂ ಶ್ರೀಮತಿ ಲತಾ ರವರ ನೇಮಕಾತಿಯನ್ನು ಅನುದಾನ ಸಹಿತವಾಗಿ ಅನುಮೋದನೆ ಮಾಡಿರುವ ಈ ಕಚೇರಿಯ ಆದೇಶದ ಸಂಖ್ಯೆ ಅದು ತಕ್ಷಣ ಜಾರಿಗೆ ಬರುತ್ತದೆ.
This was cancelled.
Yes, my lord. That has been cancelled since they were excess teachers, my lord.
So they challenged it before the authority.
My lord.
131. ಏನಾಯ್ತು? ಮೇಲೆ ಚರ್ಚಿಸಿದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸರ್ಕಾರದ 4 ಜನ ಶಿಕ್ಷಕರುಗಳು ಹೆಚ್ಚುವರಿ ಶಿಕ್ಷಕರೆಂದು ಎಣಿಸಿಕೊಳ್ಳುವುದಿಲ್ಲ. ದಿನಾಂಕ 5/7/2005 ನಂತರ ಅವರ ಅಸ್ತಿತ್ವ ಕೂಡ ಇರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಇವರುಗಳು ಬೇರೆ ಅನುದಾನ ಸಂಸ್ಥೆಗಳು ವಿಮುಕ್ತಿಗೊಳಿಸುವ ಪ್ರಶ್ನೆ ಬರುವುದಿಲ್ಲ. ಈ ಶಿಕ್ಷಕರನ್ನು ಬಿಡುಗಡೆ ಮಾಡುವ ಆದೇಶವನ್ನು ಆಡಳಿತ ಮಂಡಳಿಯು ನಡೆಸಬೇಕಾಗಿತ್ತು. ಇದರಲ್ಲಿ ಇಲಾಖೆಯು ಮಾಡುವಂತಹ ಕರ್ತವ್ಯ ಇರುವುದಿಲ್ಲ. So this is upheld by this court. Who are?
That has been, there are 6 teachers, my lord. 2 are there for and separate. Here in this case,
Lata Sugandhraj. Barkoli. The petitioners have challenged an order bearing number so and so dated 5/7/2005 passed by the respondent number 3, as well as the order passed by the respondent number 1 in proceeding, respondent number 1 in appeal number 9/2007-2008. Next para. The petitioners were employed as teachers in outsourced part-time ಏನಿದು?
Approval was taken, my lord.
Were employed as teachers at the respondent number, the school run by the respondent number 4. So their appointment was approved on 7/8/1995. The respondent number 4 was covered under grant in aid, and therefore the salary of the petitioners was paid till the year 2004. When their salary was later withheld, the petitioner along with 2 other teachers filed WP number 33177-80/2004. Full stop. This court, in terms of the order dated 28/1/2005, set aside the order withholding the salary and directed the respondent therein to pay salary. Full stop. While disposing of the writ petition, this court observed that unless and until the approval of the appointment of the petitioner was validly recalled or annulled, the respondent cannot withhold the salary. Thereafter, the respondent number 3 issued a show cause notice on 7/3/2005 accusing the petitioners of improperly securing an appointment. ಅಲ್ಲ ಮೇಡಮ್ ಆಯ್ತು.
Appointment
7/3/2005.
on the ground that their appointment is not made as per the
7/3/2005, on the ground that the approval of the appointment of the petitioners was not genuine.
it's not made as per the sanctioned poster.
And that it is not, and that they were not appointed against sanctioned posts. Full stop. The petitioner submitted their reply, consequent to which the respondent number 3 passed an order dated 7/7, respondent number 3 passed an order dated 5/7/2005, holding that the appointment of the petitioners were not in accordance with the rules. And thus recall the order approving their appointment, recall the order dated 18/4/1995 approving their appointments. The petitioners then challenged the order in a proceeding under section 131 of the Education Act before the respondent number 1. Before the respondent number 2, who upheld the order passed by the respondent number 3. Full stop. Being agreed with the said order, the petitioners are before this court. The learned counsel for the petitioners contended that the approval of the appointment of the petitioner was mooted by the respondent number 4 after furnishing all required information, and that the respondent number 3 was duly satisfied about the process of the appointment of the petitioners, and therefore the respondent number 3 would not have doubted the validity of the appointments of the petitioners. It therefore contends that the impugned order passed by the respondent number 3 and upheld by the respondent number 2 deserves to be interfered with. Per contra, the learned AGA, AGA and GA na? AGA submitted that the order impugned in this writ petition, orders impugned in this writ petition were challenged before this court in WP number 39154 of 2012. And this court, in terms of the order dated 4/4/2024, had upheld the impugned orders. It therefore contends that the impugned order has to be upheld in this writ petitions also, in this writ petition also. Besides this, she contends that the coordinate bench of this court had noticed that ಹಲೋ ಆಗಿದೆ ಇದು
Please,
Ah,
madam.
it
is allowed.
And,
order is quashed.
remanded back to
dismissed.
fresh inquiry. No.
ಏನ್ ಮಾಡಮಾಯ್ತು? And this court, noticing that the inquiry was not conducted in accordance with law, before setting aside the orders approving the appointment of the petitioners, and hence set aside the impugned orders. She therefore submits that this writ petition may also be allowed on the same lines. Next paragraph. A perusal of the order passed in WP number 39154 of 2012 shows that what was challenged in the said writ petition is also challenged in this writ petition. Therefore, following the judgment rendered in WP number 39154 of 2012, this writ petition also deserves to be allowed. Consequently, this petition is allowed and the impugned orders passed by the respondent number 3 bearing number so and so dated so and so, as well as the order passed by the respondent number 2 in appeal number so and so dated so and so are set aside. The matter is remitted back to the respondent number 3, who shall reconsider the matter in accordance with law after conducting a fresh inquiry as per the observations made by this court in WP number 39154 of 2012.
Time limit.
My lords, respondent number 2, my lord.
ಅಲ್ಲ ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3, ಸಾರಿ ಅಲ್ಲಿ 2, ಇಲ್ಲಿ 3 ಅಲ್ಲ. Deputy Director is respondent number 3 here.
2 has, recons.
2 and 3 is the authority who has to consider that. The respondent number 3 shall decide the ಯಾರು ಇಲ್ಲಿ ಡೈರೆಕ್ಟರ್. Respondent number 2 ಅಂತ ಮಾಡಿ.
Respondent number 2
is directed to hold a fresh inquiry and decide the appeal.
This
By considering-
present case 2, my lord, there
Considering the observations made by this court in WP number 39154 of 2012, respondent number 2 is directed to dispose of the appeal within a period of 3 months from the date of receipt of a copy of this order. The parties are reserved liberty to raise additional grounds and also place additional material before the respondent number 2 if they choose to do so.
My senior name might kindly be deleted and my senior name,
Order sheet ಅಲ್ಲಿ officers directed to show the name of
SS Parikshit.
Mr. So and so as the counsel for the petitioner.
34, SK Venkat Reddy. Number 34.
SK Venkat Reddy. There is no representation for the petitioner, though it is called twice in the day as a last chance list on. ಯಾರ್ಗೆ ಹೇಳು ಲಿಸ್ಟ್ ಆನ್ ಡೇಟ್
March. Number 35, C Shankar Reddy.
BY ಕುಮಾರ್
For the petitioner.
ಮಹೇಶ್ ಚೌಧರಿ ನಟರಾಜು.
I think the private response.
Lord,
Yes.
petitioner is one of the contract employees, not in the first respondent Karnataka Pollution Control Board. Lord, at an earlier point of time, the contract employees, association had approached this honorable court not for regularization of their services. Not at that particular point of time, not this honorable court, not by an order dated 23rd February 2011, your lordships may kindly find it at page 28.
Yes.
An interim order came to be granted pending disposal of the writ petition. Thereafter, my lord, final order, my lord, came to be passed. Your lordships can find, my lord, from annexure G,
Yes.
that your lordships can find from page 40.
Yes, please.
Lord, in terms of the order passed by this honorable court, there were 2 submissions, my lord, that were made. That even if the contract employees, my lord, do not get selected in the regular process, their services will be continued. That was one submission that was made. It was recorded by this court. The second submission that was made, my lord, is insofar as the ensuing, at that particular point of time, my lord, fresh, my lord, proceedings for taking the new recruits, my lord, was initiated. We were all working, my lord, for about 10-12 years. Therefore, my lord, we made a request to this honorable court for each completed year of service, 4% weightage should be given as per the government order. But this honorable court recorded that in the coming, my lord, the process which is taking for selection, each of these applicants, my lord, who had served for any number of years, for each year, 4% of weightage is to be given. Lord, many of them got selected.
There is no upper limit.
Lord, it is
That's the maximum.
It goes up to 100, my lord.
No. What is the upper limit? Suppose if you have put in 20 years of service,
Lord,
4% of the
if I get 60% in the qualifying examination, and if my percentage is 40, then I will be treated as 100%.
correct. So shouldn't there be a cap?
There was no such
No
cap,
cap.
not initiated by the government.
Hmm.
Lord, it so happened this honorable court, my lord, with those directions, was pleased to dispose of the writ petition. Petitioner, my lord, made an application because she was already working as a data entry operator since the year 1997. She made an application and her application was considered. 61%, my lord, was the mark that she secured. Then taking 4% into consideration, my lord, she had crossed 100. But it was refused. That 4%, my lord, was refused on the ground that at an earlier point of time, she had already availed that opportunity for a different post. My lord, this honorable court, my lord, said for the coming the recruitment process, all of them should be given benefit for one time. That was refused. Consequently, my lord, my percentage stood at 61%. I did not get selected. I approached this honorable court, my lord, saying that the order passed by this honorable court in the previous round of litigation has not been given effect to. And such an observation that was made by the other side saying that since I had already taken a 4% weightage at an earlier point of time, therefore for the second time it is not applicable to me. Not is not correct because of the observation made by this court. During the pendency of the writ petition, the process has gone ahead, and this honorable court was pleased to grant an interim order. Subject to the result of the writ petition, the recruitment process can go on. Now, it so happened, I am one of the data entry operators. There are 20 sanctioned posts. Only 12 posts they were called for. 8 posts are still remaining vacant. Even to this day, my lord, I am working as a data entry operator, my lord, on contract basis. Now,
Please read the order. What was the order?
This honorable court, my lord. Your lordships may kindly permit me to draw your lordship's kind attention to internal page 58. In page 58, my lord, that would be paragraph number 12 of the order passed by this honorable court.
Para 12.
Paragraph 20, my lord. Page number 50, ink page 58. Learned counsel appearing for the petitioner association submitted that the weightage given as per the government order dated 12/11/2009 should not be confined to the post in which the contract employees were working, but also in respect of all posts to which they apply. The weightage should be extended irrespective of the post for which they have applied or in which they were working. The said benefit should be continued not only once, but also for future recruitment. He also contended that as far as the qualification for recruitment, as per the notification dated 6/10/2010, or for any subsequent recruitment, it should be only according to the qualification prescribed under the rules of 1992. Now, your lordships may kindly skip the portion. Your lordships may kindly turn to paragraph number 23 that your lordships can find from page 61. No doubt the recruitments are required to be made in accordance with the qualifications as prescribed under the cadre and recruitment rules prevailing as on the date of issue of the notification. But insofar as the contract employees in these writ petitions are concerned, it is not in dispute that they are working for several years and they might have completed 10 years of service as on 10/4/2006. However, at the time when they were recruited, they were all qualified for the respective posts. But for the shortage of length of service as on 10/4/2006, some of them became ineligible for regularization. At the same time, the very same posts have been advertised for direct recruitment. If they were all qualified when they were recruited and have been working in the said post, their experience itself could be treated as a qualification. It is in this regard, this court having noticed that only some of the contract employees have made applications in respect of the notification dated 6/10/2010, permitted the other contract employees who had not made applications to make applications, directed the board to treat the same as having been made under rules of 1992 and not rules of 2010. In my opinion, though the order dated 23/10/2011 is an interim order, it is passed by this court keeping in mind the fact that the contract employees have been continuously engaged by the board against clear vacancies and they were all qualified. Treating the said qualification as requisite qualification, their applications have been directed to be considered. In my opinion, these applications of these contract employees have to be treated as having made in conformity with the qualification prescribed under the rules of 1992. Learned counsel appearing for the board also fairly submitted that all the applications of the contract employees have been considered under the rules of 1992. It also filed details of the contract employees to be benefited from the weightage along with the memo. He also submitted that except for the post of field assistant in respect of other posts, the qualification which is prescribed under 2010 rules is the same qualification which is prescribed under 1992 rules. They may not be having in difficulty in considering the applications of all the contract employees who have made application for direct recruitment. Apart from this, even for the post of field assistants also, applications of contract employees have been considered in terms of the qualification prescribed under the rules of 1992. Apart from considering them under the rules of 1992, they have been benefited by the weightage as per the government order dated 12/11/2009. In my opinion, this statement of the board clearly satisfies the grievance of the petitioner for consideration of the rules, for consideration of their case under the rules of 1992. Even otherwise, having regard to the special circumstances and these employees were appointed on the basis of qualification as prescribed then, that is in 1992, they have deserved special consideration. As far as the extension of the weightage as per the government order dated 12/11/2009 for the subsequent recruitments is concerned, both the learned government pleader and the learned counsel appearing for the board submitted that the said extension of weightage would not only be contrary to the government order, but it would jeopardize the future recruitment. Such consideration would be violative of Article 14 and 16 of the Constitution. As far as the contention of the learned counsel for the petitioner, that the weightage given under the government order dated 12/11/2009 should also be available for any other post, there is no merit in this contention, as the purpose of giving weightage was to respect the length of service rendered by such employees in the concerned post. Considering their experience in the said post, the weightage is to be given. The government orders dated 12/11/2009 and 5/8/2002 were all made for the benefit of the contract employees and to see that there, as far as possible, their interest is protected. But it does not mean that the weightage given to a particular post can be extended to any other post for which the contract employees have no experience. No such benefit could be extended from time to time. The government order dated 12/11/2009 itself speaks that it is a one-time measure. And even according to the judgment of the apex court in Uma Devi's case, if the daily wage ad hoc contract employees are qualified and fulfill the norms prescribed there for regularization, their case shall be considered as a one-time measure. The apex court considered the judgment of Uma Devi's case insofar as the norms prescribed are concerned and held that one-time measure would be concluded only when all the employees were entitled to be considered in terms of para 53 of the judgment in Uma Devi's case. Once cases of such employees are considered and given benefit of weightage and also qualification, I do not think there can be any justification to extend the benefit again and again. If they do not qualify despite giving such benefit, it cannot be said that such weightage and benefit should be extended till they are selected. Since in this case, the board stated that it would extend the benefit of weightage as per the government order dated 12/11/2009, and the applications of the contract employees would be considered as if made under rules of 1992. And if the selection is made by considering those two criteria, one-time consideration stands fulfilled. Apart from this, the learned counsel for the board also made submission that even if the contract employees who have made applications for direct recruit are not selected, they will not be disturbed from their services as contract employees and they would be continued. This submission is placed on record. Thereafter, the operative portion your lordship can find.
No, but what is there to show that you sought for past service in some other recruitment?
Along with the statement of objections, they are placed on record stating, for a different post. For a different post. I had taken the benefit of one time that 4% weightage that your lordships can find from the statement of objections that the board has filed before this honorable court. Statement of objections that has been filed before this honorable court on 10/1/2013.
Yes.
Your lordships can find in page number 1. As your lordships could see, Srimati Shashikalayam, in the middle of the page, your lordships can find the name. There, your lordship, Shashikalayam is the petitioner before this court. There she says, Abhyarthi ಗಳಿಸಿದ ಶೇಕಡ 64.48%. ಅಭ್ಯರ್ಥಿಗೆ ನೀಡಲಾದ ಕೃಪಾಂಕ, because at that particular point of time, she had put in 6 years of service. Therefore, 24% was added and she had taken the benefit and it was given as 88.48%.
Yes.
And my lord, subsequent to me not, my application not being considered, I made a representation, my lord, to the petitioner, to the first respondent, bringing it to its notice that the one-time measure should be extended for the present, because the subsequent to the Honorable High Court's order, there was no other benefit that was taken by the petitioner, and this is the only my lord, benefit.
When
that
was this,
Please, my lord.
when was this recruitment?
2012.
No. The recruitment which is found at page 1 of the statement of objections. When was that?
My lord, that is in the year
2002 ಮಂಡಳಿಯಲ್ಲಿನ 2002 ನೇರ ನೇಮಕಾತಿಯಲ್ಲಿ ಸರ್ಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ 5/8/2002 ಅನ್ವಯ ನೌಕರಿಗೆ ಒಂದು ಬಾರಿಯ ಅವಕಾಶವಾಗಿ ನೇಮಕಾತಿ ಈ ಆದೇಶ.
That was, my lord, during the prior to filing of the writ petition, prior to 2010.
No, but this court has also said that it can be a one-time measure.
My lord, one-time measure for this subsequent, my lord,
No.
recruitment process that is
Please
taken up.
come to the order.
Please, my lord. Your lordships may kindly find it at page 67. Yeah, a second, my lord, portion, second operative portion, my lord, is the relevant portion. In respect of the contract employees who have made application in response to the notification dated 6/10/2010 and who have made application in pursuance to the interim order dated 23/2011 in WP number so and so, their applications shall be considered in terms of the qualification prescribed under the cadre and recruitment rules of 1992. Then, my lord, the weightage as prescribed by the government order, as prescribed by the government under the government order dated 12/11/2009, be given to such applicants.
No, but first of all, please tell me, annexure, the statement of objections, page 1,
Please,
which was that notification, recruitment? In the statement of objections at page number, what was that recruitment?
my lord,
What was that recruitment?
the lordships can find, my lord, from page 3. The previous application that I had made, they have made it available to this honorable court. Your lordships can find it for the year 2002. Page number 3, your lordships can find. This is the application, my lord, that is said to have been made by the petitioner at an earlier point of time during the year 2002. And your lordships can also find that at that particular point of time, my lord, there was a certificate that came to be issued. My lord, providing, my lord, saying that 4% weightage can be given because I've already worked for 5 years, that your lordships can find from page 5.
Yes.
These are all prior to 2002, my lord, that subsequent to this particular, because, my lord, this particular proceedings, when the writ petition was pending, simultaneously they had called for the applications. Because
But
we were thinking, my lord, it would be.
Earlier benefit that was given was post Uma Devi. It was
Clear
post Uma Devi.
benefit, my lord, is of the year 2002. Uma Devi's judgment, my lord, came in the year 2006. Prior to Uma Devi's case.
Yes.
My lord, and insofar as this particular issue, my lord, because there was no clarity insofar as this particular subsequent to making an application to the first respondent board, they said, no, High Court order is not clarified. We made an application before this honorable court, which was numbered as IA number 1 of 2014 for clarifying the order passed by this honorable court. And this honorable court, my lord, said there is sufficient clarification and was pleased to dispose of the same. Your lordships can find from page 74. IA 4 of 2012, my lord, came to be filed.
74.
74, page number 74. On an application that came to be filed by me, my lord, for clarifying whether the subsequent recruitment, whether such weightage can be given or not. This honorable court, my lord, was pleased to extract the relief 3 granted by this court, which is read as under weightage as prescribed by the government order under the government order dated 12/9/2002 be given to such applicants who have made application for direct recruitment. Therefore, my lord, this particular clarification that came to be made was also brought to the notice of the.
Who
first
filed this application?
We filed an application, petitioners,
Petitioner.
because my lord, when they made the order passed by the honorable court to the first respondent,
You are not party in the writ petition?
I'm a contract employee, my lord, all of them
Okay.
joined together and formed an association and filed.
Yes.
There were as many as, my lord, around 45 persons,
Hmm.
not whose regular services were not regularized. Therefore,
Yes.
they formed an association, and through the association, it was filed.
Hmm.
And
Yes,
this
sir.
honorable court, my lord, clarifying the, and one submission. Subsequent to this, the government has modified the very order and said it is applicable for any number of times. That along with an amendment application that was also placed on record before this honorable court, your lordships can find the amendment application that has been filed on 2/6/2014.
Hmm.
And your lordships can find the proceedings of the government at annexure Q.
Hmm.
And the same, my lord, was also gazetted at annexure R.
ಯಾವತ್ತು ಫೈಲ್ ಮಾಡಿದ್ದು ಅಧ್ಯಕ್ಷರ
My lord, it was filed along with an amendment application on 2/6/2014.
ಅಧ್ಯಕ್ಷರ ಕ್ಯೂ. ಹಾ.
Annexure Q, my lord, is the decision that was taken by the government during the pendency of the present writ petition. Your lordships can see in the bottom portion, order dated 23/4/2014, where what was, my lord, the one-time measure, it was said it will be given henceforth. And the same, my lord, was also gazetted through annexure R. Annexure R, your lordships can find the last portion, last page of annexure R.
Hmm.
One-time basis ಅಂತ ಏನಿದೆಯೋ ಅದನ್ನ ತೆಗೆದ್ಬಿಟ್ಟು ಇನ್ ಮುಂದೆ ಬರೋ ಎಲ್ಲದಕ್ಕೂ ಕೂಡ ಅನುಕೂಲವಾಗೋ ರೀತಿನಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. Since this particular decision was taken by the government during the pendency of the writ petition, I had to incorporate the same by filing amendment application and adding a particular prayer.
What is there in annexure R?
Annexure R, your lordships may kindly turn to the last page. The government order has been gazetted.
Hmm.
Last page, your lordships can find. ಸರ್ಕಾರ ಆದೇಶದ 195 EPC 212 2012 ಬೆಂಗಳೂರು ದಿನಾಂಕ 23/4/2014. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸರ್ಕಾರದ ಆದೇಶ ನಂಬರ್ 12/11/2009 ಭಾಗಶಃ ಮಾರ್ಪಡಿಸಿ ಆದೇಶ ಭಾಗದ 7ನೇ ಪಂಕ್ತಿಯಲ್ಲಿರುವ ಒನ್ ಟೈಮ್ ಬೇಸಿಸ್ ಎಂಬ ಪದವನ್ನು ಈ ಮೂಲಕ ತೆಗೆದುಹಾಕಲಾಗಿದೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ಮಾಲಿನ್ಯ ನಿಯಂತ್ರಣ ಮಂಡಳಿಯಲ್ಲಿ ಗುತ್ತಿಗೆ ನೌಕರರು ಸಲ್ಲಿಸಿರುವ ಗರಿಷ್ಠ 15 ವರ್ಷಗಳ ಸೇವೆಗೆ ಮಾತ್ರ ಶೇಕಡ 14 ಕೃಪಾಂಕಗಳನ್ನು, ಅಂದರೆ ಮೊತ್ತವು ಒಟ್ಟಾರೆಯಾಗಿ ಶೇಕಡ 100 ಮೀರಿದಲ್ಲಿ ಶೇಕಡ 100ಕ್ಕೆ ಸೀಮಿತಗೊಳಿಸಿ ಎಲ್ಲ ನೇಮಕಾತಿಯಲ್ಲೂ ಅನುಕೂಲವಾಗುವಂತೆ ಅವಕಾಶ ನೀಡಲು ಸರ್ಕಾರ ಆದೇಶಿಸಿದೆ. Even till today, there are as many as 8 sanction clause which is not being filled up.
Yes. Yes.
They are only, they have been implemented because we are not challenging their regularization.
Hmm.
Order is very clear. That is
Yaru.
the same order. It saves the the selection. Direction.
So you are sailing with them.
No, we are selling to the board.
Not
We
this
are
honorable
happy to
court,
the petitioner, madam.
this honorable court wanted to know.
Yes, ಯಾರು board ಯಾರು? Who appears for the board? Pollution Control Board.
Here.
Huh?
Mahesh Chaudhary.
ಯಾರು?
One Mahesh Chaudhary is here.
Not this honorable court wanted those persons to be implemented in order to examine whether they are going to get affected by any order that would be passed by this court. As against
Chaudhary.
20,
Very same order, madam. Our selection is saved. Cannot, it is not going to be.
we are, as many as out of 20 posts, 12 of them have been filled up. Those
No
persons are not.
representation for the respondent number 1. ಅದೇ ಹೇಳ್ತೀರೇನ್ರಿ ಅವ್ರಿಗೆ? Huh?
I'll inform.
As a last chance list on.
Number 36.
M. Subramania Bhatt.
Ready?
Appear for the petitioner.
You ready?
Yes, ma'am.
Yes.
That's matter pertains to selection, my lords. Now I am a petitioner who is having 10 years of experience in lecturer for Sanskrit, my lords. That's kindly turn to annexure B.
Next, sir.
B, my lords.
B.
B.
B for Bangalore.
Yes, my lords.
Yes. 10 ವರ್ಷಗಳು.
My lords, I've also annexed all the certificates at annexure A, my lords. That is my education qualification.
Yes.
My lords, on 16/7/2012, second respondent issues a notification for some post, my lords. That's at annexure D, my lords, page 26.
Yes.
Lords, in that, serial number 1 and serial number 2, I apply for both the posts. Adralli, the first one, Yojana Sahayakaru. That is the post. In that regard, I have put this writ petition, my lords. Lords, now I possess the educational qualification. I have been not called for interview in this. Is my prayer, my lords, that over here must be a holder of master degree in relevant subject with 55% must have studied Sanskrit as an optional subject in degree. Preference will being given to the candidates who have cleared NET acquired with Vidwat in traditional system in field of specialization. Anta helida. I do not possess the other half, my lords, but I possess the 55%. I exceed more than 55% also. My lords, the thing is, now my lords, I get a call on 13/9/2012 with regard to the second post which I have applied for, that is Upakula Sachivaru, but not with regard to the first mistake. My lords, now the facts go like this. I call the respondent institute as to why I have not been called for interview. They say that my age is barred, that is why I'm not called.
Yes.
Let's now kindly turn to annexure E, my lords. My age is 39.
Where is your marks card?
My lords,
Marks card. Where is your marks card? SSLC marks.
SSLC marks card, my
773.
lords. My lords, SSLC marks card is at annexure 1, my lords. A1.
What is the date mentioned? 773. Yes.
Yes, my lords. My lords, now, my lords, kindly turn to annex page number 29. There, my lords, ಈ ಮುಂದಿನ ಸಂದರ್ಭದಲ್ಲಿ ನೇಮಕಾತಿ ಗರಿಷ್ಠ ವಯೋಮಿತಿ ಈ ಕೆಳಗಿನ ತಿಳಿಸಿರುವ ಮಟ್ಟಿಗೆ ಹೆಚ್ಚಿಸಲಾಗುವುದು. There, in the first point, my lords, they say that if I have more than 35 years of experience, 5 years can be condoned. Now, my lords, in that regard, I fall under the eligibility criteria to be appointed, to be selected, my lords. In this whole selection process, my lords.
When were you appointed?
My lords?
When were you appointed?
My lords, I was not appointed. I was not called for this interview, my lords.
You said 35 years experience as what?
My lords, 35 years experience in as lecturer, my lords.
ಎಲ್ಲಿ ಅದು ಅಂತ? What is there to show that you had 35 years experience?
My lords, that is annexure B, my lords.
B.
B.
B is 10 years. ಒಟ್ಟು 10 ವರ್ಷಗಳು.
Sorry, my lords, not 35 years, my lords. 10 years of experience. Now, my lords, 10 years of experience.
That's what I was wondering. 35 plus 20 becomes 60.
That's sorry, my lords. Apologies. 10 years of experience. Now I have more than 10 years of experience. 5 ವರ್ಷ ನನ್ನ ಕಂಡೋನ್ ಮಾಡಿದ್ರೆ I would fall under the eligibility criteria. Now, my lords, my prayer is I have been not called for the interview.
The selection process says, my lords, in
35 years is the outer limit.
my lords, yes, my lords,
Your 29 plus 5 is 34.
yes, my lords.
What is the date of the notification? 16/7.
Yes, my lords.
So as on that date, how old were you?
My lords,
As on that day, what was your age? 1773.
my lords, my age was 39, my lords, on the day of putting application.
1/7/1973.
My lords,
39 plus 5. 34. Yes.
lords, now my prayer is, I have not been called for an interview, and my submission, my lords, I'm referring to a judgment of Apex Court, where the Honorable Apex Court
Hold.
has held that, my lords, that lords, para 7, my lords. Really, if the word selection is understood in the sense meaning thereby only final act of selection candidates with preparation of list of appointment, then the conclusion of tribunal unjustified. But the round phrases cannot give us square answers.
It should be from the date of notification, Mr.
Lords,
Right, the date of notification, correct, next.
lords, the
The
process.
age limit is to be reckoned from the date of the notification.
Yes, my lords.
Yes, next.
My lords, now my submission is, my lords, the Apex Court has held ಅಲ್ಲಿ
Apex court ಹೇಳಿದ್ರೆ ನಂಗೆ ಅರ್ಥ ಆಯ್ತು.
lords, that is
I
the
understood, I told you what is the proposition.
lords,
The age criteria fixed should be as on the date of the notification, not on the date of selection.
lords,
Correct.
my lords, that is what they are saying, my lords. Then in the written, in the statement of
This
objections,
is what is stated in the Apex court judgment.
my lords,
That is what is stated in the Apex court judgment. Read it again for your convenience. Both both.
lords, what I am saying is the process of selection begins with the issuance of advertisement, ends with the preparation of select list for appointment. Indeed, it consists of various steps like inviting application, scrutiny of application, rejection of defective application or elimination of ineligible candidates, conducting examination and calling for an interview or viva voice, and preparation of the list of successful candidates for appointment.
Yes.
Really, even calling me for an interview is also is something that in the which is in the selection process, my lords.
Yes.
I have not been called for an interview. That is my
Yes. Who has to answer?
Mainly, my lord, he has submitted an incomplete application form.
So why is it rejected? Why is it rejected first?
The reason being, my lord, Annexure E, my lord,
Annexure
to
E.
kindly see. It was compulsory for him to, my lord, state, fill up the application, my lord, that is at Annexure E. And that ought to have been, my lord, routed to an employer. That, my lord, has been left blank. Kindly see, my lord, Annexure E. Mandatory requirements, my lord, that are not complied. Page 32, my lord.
Yes.
There, my lords were to kindly see.
Thirty-three nalli ಇದೆ.
33 is Annexure E.
my lord, the column in the is left blank, my lord, at 33. ಶಾಲೆ / ಕಾಲೇಜಿನ ವ್ಯಾಸಂಗ ಮಾಡಿದ ಸ್ಥಳದ ಹೆಸರನ್ನು ಮತ್ತು ವಿವರಗಳನ್ನು ಈ ಕೆಳಕಂಡಂತೆ ನೀಡುವುದು. This mandatory, my lord, column has been left blank. Has he claimed the what you call? Yes, please, my lord. That is the reason, my lord, because even the for seeking relaxation, my lord, he claims that he has worked in as a lecturer. Has he claimed that in the application? Has he claimed that in the application? Annexure E ನಲ್ಲಿ claim ಮಾಡಿದಾರಾ? ನೀವು ವಿದ್ಯಾರ್ಹತೆ ಹೊಂದಿದ್ದೀರಾ? ಹೌದು. ಜನ್ಮಸ್ಥಳ 39 ವರ್ಷ. Where has he claimed the relaxation? In his petition, my lord, he states so.
That is page number 29, my lords, where they say that I am, if I have more than.
Claim ಮಾಡ್ಬೇಕಲ್ವ? Have you claimed?
Lords, I have claimed, my lords.
Where?
In the application, my lords.
Where have you claimed in the application at annexure E? See, the outer age limit was 35.
Yes, my
You are
lords.
39.
My lords.
Did you say
My lords.
that I am entitled for age relaxation because of this reason?
I have said it, my lords.
Yellide, where have you said it?
But I got a phone call, my lords, saying that I am not eligible.
Mister, where have you said? If you have said it in the counter, then what happens at the counter goes at the counter. If you said it in the application, then we'll consider. How will the employer know that you are working in some institution, that you are entitled for relaxation? How will the employer know?
I have said it in the application itself, my lords.
ಎಲ್ಲಿ
that-
ಅಂತ ಕೇಳ್ತಿರೋದು ಅದನ್ನು? Where have you mentioned?
Lords, there, my lords,
Page 34 ಬನ್ರಿ ಮಿಸ್ಟರ್. ಸೇವಾ ದೃಢೀಕರಣ ಪತ್ರ.
Dhrudhikarana Patra, that's serial number 14, my lords, over there in 11, 12 and my lords, there I have said, my lords. I've also produced it, my lords. That is annexure B.
Lord, annexure B, my lord, is neither affiliated college nor, my lord, recognized by any state government or any statutory or regulating authority. No affiliation to, my lord, any government. What is the document that he has produced? ಸೇವಾ ದೃಢೀಕರಣ ಪತ್ರ ಏನದು? Annexure B ಅಂತ ಹೇಳ್ತಾರೆ ಇವರು. ನೀವ್ ಹೇಳ್ರಿ, ನಿಮ್ಗ್ ತಾನೇ ಕೊಟ್ಟಿರೋದು ಅಪ್ಲಿಕೇಶನ್. Annexure B. Annexure B is serial number 11, page 34. Page 30. This is not in our university, this is elsewhere. My dear friend, he filed an application against a notification issued by you. So you should be having these documents. What is this? What he has produced. ನೀವು ನೋಡಿದಿರಾ? Have you seen it? ಈ ಸೇವಾ ದೃಢೀಕರಣ ಪತ್ರ, what is the, does it refer to the same document which is marked as annexure B? Very sure. My learned friend is referring to here annexure B, because, my lord, in my statement of objections, I have taken up a contention, saying that annexure B, whatever is produced, my lord, by the petitioner, claiming that. What was produced before you? ಅದ್ರ ಬಗ್ಗೆ ಹೇಳ್ಬೇಕಲ್ವಾ ನೀವು? ಯಾವಾಗ ನೋಡ್ತೀರಾ? Weeks accommodation. Huh? 1 week. The next Monday. ಇನ್ನ ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಜಾಸ್ತಿ ಅಪಿಯರ್ ಆಗ್ಬಿಡಿ ನೀವು. You don't seem to be conversant with service matters. ಇನ್ನ ಇವತ್ತು ನೋಡ್ತೀನಿ, ನಾಳೆ ನೋಡ್ತೀನಿ, ನಾಳೆ. Good for CPC, bad for service. Learned counsel for the respondent. Number 2. seeks time to secure the records that the petitioner furnished along with the application filed against the recruitment notification. List on next Monday. List has a last chance on Monday.
Grateful. Case number 39. L. Muralidhar Peshwa.
L. Muralidhar Peshwa. Yogesh Naik. Hello, ready na? All of you ready?
Please, yeah, also ready, but I make only one suggestion. A praise for very bulky petition. Lodge.
No, bulky for you, not for me. You have to break it down.
Yeah, I'll
praise
try
for
to make
time, my
it.
lord. Due to some personal inconvenience,
Who are you?
I appear for respondent number 3, my lord.
Jilla Panchayat, my
Jilla
lord, they are
Panchayat,
appeared.
What is your role?
My lord, it is already as in early occasion, my senior has told it is covered by judgment, my lord.
What is your role, mister?
The approving authority, my lord.
Approving authority, my lord.
Appointment is, my lord, Panchayat, those who are appointed, my lord, under the outsourced employees, my lord, the sought for
Who are these people, petitioners?
data entry operators,
Data-
my lord.
In Panchayat.
Please, please.
They are appointed by the Panchayat.
Please, my lord. Regarding Marega scheme, my lord, regarding specific scheme is, my lord, government given a direction to the, my lord, they are appointed under the outsourced employees. Now, if they want, my lord, now to regularize the employees, if, my lord, they want to regularize, my lord, we have sent the proposal to the Jilla Panchayat. My respectful submission is, my lord, they are not entitled for the regularization because, my
ಮತ್ತೆ ಯಾಕ್ ಕಳ್ಸಿದ್ರಿ?
ನಾವು ಕಳ್ಸಿಲ್ಲ ಅವ್ರು ಕೇಳ್ತಾರೆ. He say that, my lord, is covered by this ಅಂತ ಹೇಳ್ತಾರೆ, ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅದು. But in respect of in respect of, my lord, the against the respondents, because its honorable court taken a view, my lord, in the similar batch of matters, my lord, regarding, my lord, the contract based employees is concerned.
No regularization.
Please.
Yes.
Para number 4, my lord. 1 second, I read.
ಆಯ್ತು ಹೇಳಿ.
Lordship, this is the writ petition we had filed in the year 2013, your lordship. I filed writ petition to quash the circular dated 27/2012, your lordship, which is annexure U, which is in page number 162 of the petition. After the amendment of the writ petition, I have added one more prayer in my writ petition. That is for further direction to direct the concerned Gram Panchayats. Where the petitioners are working, forward the names of the petitioners to Jilla Panchayat, Ballari district for approval of their appointments to the concerned Gram Panchayats at the general meetings of the Gram Panchayats where they were appointed and now working in accordance with the government order dated 10/9/2015. And direct the respondent number 2 to approve the proposal sent by the Gram Panchayats for appointment of the petitioner and make the petitioner appointment by approving the same in accordance with the government order. That's additional prayer also made it. The fact remains at your lordship that I was appointed by the respective Gram Panchayats between the period 2007 to 2011 year.
2007 to 11.
Yes. In fact, here in this matter, I am appearing for respondent number 2, 3.
Where are your letters of appointment?
That is there, your lordship. Petition number 2, Siddha Reddy, was appointed with effect from 3/11/2011, annexure J, page 93.
Page 93.
93.
93 ಯಾರೋ
Annexure J, my lord. J.
Annexure J.
Huh?
Annexure J, your lordship.
What is this? Volume 1. ಸರಿ ನೀವೆಲ್ಲ 2007 to 11 ಬಂದಿದ್ದೀರಾ. Where's a question of regularization?
What I am telling you, lordship. What happened was, In between the government brought out a circular, that is the impugned order, Your Lordship, that all this workmen had to be outsourced. So accordingly, what they happened was all these workmen were ought to be terminated so that their appointment can be made to all sorts of things. I refuse to accept that, Your Lordship. I'll tell you the brief facts of the whole history, Your Lordship. They refused to do it. And they continue to work under the respective Gram Panchayat until a specific period, that is until 2015 August, Your Lordship. I continue to work under the respective Gram Panchayat. Then the respondent gave a misleading statement that, no, they are not at all working. I produced the attendance sheets also. I was also not paid the wages for that period. Later on, the government modified, and this honorable court modified that order, saying that until the writ petition is disposed of, work under the outsourced agencies. So as per an order dated 17/12/2015, this honorable court had asked me to start working through the outsourced agency. So where exactly I was working directly under the respective Gram Panchayat. After the order was passed on 17/12/2015, I started working under the outsourced agencies. I continued to work. The very important fact here is that even the original petitioners, 3 of them, Your Lordship, who were also part of the writ petition, after that withdrawn their respective names, their names got approved, they have become regularized, and even their name is also appearing in the unrated list. And all those writ petitioners, Your Lordship, the original writ petition, which is 8/5/2088, in that writ petition also, more than 400 data entry operators were all called as the so-called data entry operators through outsourcing. Even they have been regularized, except me, Your Lordship. Just because I have filed writ petition, just because I have been part of the writ petition, except me, all of the data entry operators throughout the state, including Ballari district, have been regularized. The only contention of the respondent number 2 is taking is that since the writ petition is pending, my name cannot be approved and I cannot be regularized. The only contention which has been taken, Your Lord. The association was part of the initial thing, the writ petition.
Yes.
1/8/2012, my lord. They are not from 1/8/2012, my lord. They are not working. On that regard, my lord.
I have also produced the attendance sheets, Your
My
Lord.
lord, that regard.
On the day when I was, what and all, how
7/12.
many days I have worked, how I have worked, all the attendance register also I have produced.
17/12.
When that being the case, Your Lord, how can I discriminate it? Just because I am part of the writ petition, can I be discriminated when all other similarly placed employees who have been working as data entry operators, including the workmen who were part of the writ petition, that Chand Pasha, Devendra Padikar, and other one more person, Fayaz, after they withdraw their names, Your Lordship, they have been immediately regularized. This is absolutely unfair enough.
That regard, my lord.
But only this Lordship
Let it complete. ಅವ್ರು ಕೂತ್ಕೋತಾರೆ ಆಮೇಲೆ ನೀವು ಎದ್ದೇಳಿ ನೀವು ಕೂತ್ಕೊಳ್ಳಿ ಸ್ವಲ್ಪ
Please.
ಟೇಕ್ ಯುವರ್ ಸೀಟ್ ರಿಲ್ಯಾಕ್ಸ್ ಯುವರ್
Can you look into Annexure B, Your Lordship? That's a circular which was issued. As per the said covering letter, a list of selected persons was also issued, Your Lordship. And the persons who are selected among those were all the petition number 2, 3, 5, 7, and 11, Your Lordship.
What is the circular?
That is circular about the publication for calling for recruitment of this class of employees, that is data entry operator.
ಓದಿ ಏನ್ ಹೇಳುತ್ತೆ ಓದಿ
ಓದ್ಬಿಟ್ಟು.
Should be.
Can you read it, Your Lordship? ಗ್ರಾಮ ರೋಜ್ಗಾರ್ ನೇಮ ಸೇವಕರನ್ನು ನಿಯೋಜಿಸಿಕೊಳ್ಳುವ ಬಗ್ಗೆ ಉಲ್ಲೇಖ ಮಾನ್ಯ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳು ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಬಳ್ಳಾರಿರವರ ಪತ್ರ ಸಲ್ಲಿಸುವ ಎನ್ಸೋ ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ ದ್ವಾರ 16/17/8/2017 ಹಾಗೂ 19/11/2017 ಜರುಗಿರುವ ಕಂಪ್ಯೂಟರ್ ಅರ್ಹತಾ ಪರೀಕ್ಷೆಯಲ್ಲಿ 6 ಹಾಗೂ 6ಕ್ಕಿಂತ ಹೆಚ್ಚು ಅಂಶ ಪಡೆದ ಅಭ್ಯರ್ಥಿಗಳ ಯಾದಿಯನ್ನು ಲಗತ್ತಿಸಿ ಗ್ರಾಮ ಯೋಜ್ಗಾರ್ ನೇಮಕ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಆಗಿ ಕೆಲಸ ಮಾಡಲು ಸರ್ಕಾರದ ಆದೇಶ 9/3/2007 9/3/2007 ಅಲ್ಲಿಂದ ಮಾರ್ಗ ಸೂಚಿಯಂತೆ ಕ್ರಮ ಜರುಗಿಸುವ ಕಳುಹಿಸಿದ್ದಾರೆ. ಅಭ್ಯರ್ಥಿಗಳ ಪಟ್ಟಿಯನ್ನು ಈ ಪತ್ರಕ್ಕೆ ಲಗತ್ತಿಸಲಾಗಿದೆ. ಕಾರಣ ಅರ್ಹತಾ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಹೆಚ್ಚು ಅಂಕ ಪಡೆದ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ತಾತ್ಕಾಲಿಕವಾಗಿ ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳುಕೊಂಡು ಸದರಿ ಸಿಬ್ಬಂದಿಯಂತೆ ಒಪ್ಪಂದ ಪತ್ರವನ್ನು ₹100 ಚಾಪಾ ಕಾಗದ ಮೇಲೆ ಬರೆಯಿಸಿಕೊಂಡು ಆದೇಶ ನೀಡುವುದು ಹಾಗೂ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿರುವಾಗ ವೇತನ ಪಾವತಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ. ಅದರ based on this, I have been appointed, your lordship. And a regular employee whom I was a regular employee, I became a outsourced employee because of the misleading statement by the respondents for that fact.
Then what happened?
Then what happened, your lordship? I have been making representative regularly, and in between, your lordship, there was also a government order, which is 10/9/2014, for which
Where is this government order dated 9/3/2007?
9/3,
9/3/2007, the one referred in annexure B.
Annexure?
Annexure C.
Your lordship.
C, my lord. C. No, annexure B nalli
Please, ಉಲ್ಲೇಖ ಮಾಡಿದ್ದಾರೆ.
something which is referred as 9/3/2007. ಎಲ್ಲಿದೆ? ರೋಜ್ಗಾರ್ ಸರ್ವೆ ಸೇವಕ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಆಗಿ ಕೆಲಸ ಮಾಡಲು ಸರ್ಕಾರದ ಆದೇಶ ದಿನಾಂಕ 9/3/2007 ಮಾರ್ಗಸೂಚಿಯಂತೆ ಎಲ್ಲಿದೆ ಮಾರ್ಗಸೂಚಿ?
We are not able to produce it. In fact, that is the response.
No, but you keep this petition pending like this.
No, your lordship.
What no, your lordship?
I'll come to that. I'll come to
Where
that.
is this notification?
This particular notification, we are unable to produce it because common notification.
No,
Subsequent.
how you came inside the respondents is based upon this notification.
Correct.
Where is that? Margasuchi ಏನದು? Whether it is temporary, contractual, determinable. Like
Annexure C, my lord, annexure C once,
annexure?
C, my lord. Page number 54. ಅದನ್ನ ಫಸ್ಟ್ ರೆಫರೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ 9/3.
ಎಲ್ಲಿದೆ ಅದು ಅಂತ ರೆಫರೆನ್ಸ್ ಮಾಡಿದ್ರೆ ಕರೆಕ್ಟ್ ನನಗೂ ಗೊತ್ತಾಗ
ವಿಷಯ ನಾನು ಓದ್ಬಿಡ್ತೀನಿ.
ಓದಿ.
ರಾಷ್ಟ್ರೀಯ ಗ್ರಾಮೀಣ ಉದ್ಯೋಗ ಖಾತರಿ ಯೋಜನೆ ಸಮರ್ಪಕ ಅನುಷ್ಠಾನಕ್ಕಾಗಿ ವಿವಿಧ ಪಂಚಾಯತ್ ರಾಜ್ ಸಂಸ್ಥೆಗಳ ಹಂತಗಳಲ್ಲಿ ಆಡಳಿತ ಸುವ್ಯವಸ್ಥೆಗೊಳಿಸಲು ಹೊರಗುತ್ತಿಗೆಯ ಆಧಾರದ ಮೇಲೆ ಸಿಬ್ಬಂದಿ ಸೇವೆಯನ್ನು ಪಡೆಯುವ ಕುರಿತು. Regarding, my lord, it is also, my lord, 9/3/2007, my lord, it's required, my lord, lordship, my lord. Based on this, my lord, we have appointed, my lord, on contract basis by way of the outsourcing. On that purpose, my lord, 17/12/2015, this honorable court passed in detail interim order. To say that, my lord, they are not up to 1/8/2012, my lord, they are last working. Thereafter, my lord, liberty is given to the petitioner. If you continue there, you will give application and consider the accordance with law.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಈ ನಮ್ಮ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. 17/12/2015 ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆ.
Look at the order sheet. It has become so bulky. And you are not ready to argue the matter.
I am ready to argue.
What ready?
That only
not
thing is
ready
that
with the
9/3/2007 circular, in fact, it's not part of
You
the.
came into the organization based on the Margasuchigulu which is mentioned in 9/3/2007. Where are those guidelines? The starting point itself is so doubtful. 17,
17/12/2015, my lord. Order. Married.
Yes, please.
Lord, order on so and so appearing for the respondent number 2 submits that petitioner number 226 were appointed data entry operators on the contract basis, full stop. They last working on 1/8/2012. He submits that thereafter they are not working, turn up the workplace at all. He submits that funding the implementation of the scheme project, the Mahatma Gandhi National Rural Employment Guarantee Act 2005. It is the central government as desired as a central government, state government is the outsourcing the data entry operators work. He submits that government has no objection to petitioner working the retrospective contract under the supervision of agency appointed the state government.
Why are you jumping?
Please.
Why are you eating up words?
Please. He submits that government has no objection to the petitioner working the respective panchayats under the supervision of the agency appointed by the state government. The petitioner number 2 to 10 have their own stopped coming to the workplace, but they continue to demand the salary for the periods for which they have not at all worked. He submits that even by their own admission on the memorandum of the writ petition, the petitioners are there terminated. He read out the relevant sentence from paragraph 30, number 31 of the writ petition. But their representation have not considered. On other hand, their service are terminated. ಅದೆಲ್ಲ ಆದ್ಮೇಲೆ ಸ್ವಾಮಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ the on hearing learned council the deemed necessary to just modify the earlier in merit page number para number 6.
ಜಂಪ್ ಮಾಡ್ತಿದ್ರಿ ಯಾಕೋ?
ಅಲ್ಲ ಅದು ತುಂಬಾ ನಂದಿದೆ ಕನ್ಸಿಡರೇಷನ್ ಬಂದಿರೋದು ಅದು.
Why are you jumping eating up the words, jumping the words, missing the words?
Please. ಮೊಬೈಲ್ ಓದ್ತಿದ್ದೇನೆ ಕನಕ.
ಅಲ್ಲ ಎಲ್ಲಿಂದ ಓದಿ, ಬಟ್ text cannot change.
Please, ಅಲ್ಲ third para ಇಂದ ಓದ್ತೀನಿ.
ನಿಧಾನಕ್ಕೆ ಓದಿ. Don't miss the words.
Please. He submits that petitioner service are terminated by third para. He submits that the petitioner service are terminated by their version and they have stopped coming to work in the government place in is the government's version. They have been baselessly claiming that salary. He submits that the government had to give 1 month's salary to the said petitioners and deposited 15 lakhs towards their claims in the contempt proceedings, wherein they have alleged disobedience of the court order dated 1/3/2013 and 29/2013. And the learned council appearing for the respondent Panchayat submits that respondent number 2 to 10 have been
Petition number 2 to 10.
Sorry, petition number 2 to 10 have been stayed away from the workplace the last 3 years by using force commas. Some of the signed the attendance register. Para 5, my lord. The so-and-so senior council appearing for the petitioner submits that petitioner number 2 to 10 have requisite qualification to the appointment of data entry operators. Other district.
In no other district.
Sorry, in submits that in no other district, the data entry operators are facing any difficulty. Full stop. He submits that Panchayat Development Officer has not been permitting the petitioner number 2 to 10 to the work. He submits that these proceedings, this court may have to determine who is the employer of the petitioner number 2 to 10. He praised for earlier adjudication of the main matter. On merit next paragraph. On hearing the learned council, I deemed to necessary just to modify the earlier interim order dated 1/3/2013 and 25/9/2013 by making following interim arrangement till the final disposal of the case. The point number 1, my lord. The petitioner number 2 to 10 are directed to report themselves respective workplace and discharge their allotted duties. They shall work under the guidelines, supervision and direction agency employed by the state government. The respective Panchayat Development Officer is directed to permit petition number 2 to 10 discharge their allotted duties. The concerned functionary shall disburse the salary petition number 2 to 10 the period of which they work. Liberty also reserved for the petition number 2 to 10 to take part from regular recruitment process initiated for the filling of the newly sanctioned post. Initially, my lord, is not a sanctioned post. They are working. This arrangement shall be without prejudice a rival contention being raised by the parties. This petition is subject to outcome of the petition.
Yes.
This order itself indicates that, my lord, they are not working in the sanctioned post.
Where does it indicate?
Please.
The court has permitted them to report back to work.
Please. No, termination, my lord, 1/8/2022, my lord, we are terminated because, my lord, they are appointed under the Marega scheme. Thereafter, my lord, based on interim order, my lord, they are continuing. Now they will give application.
Even after the so-called outsourcing, the method being adopted by the respondents to outsource my employment. So I did not accept to their terms and conditions that even though I've been working regularly with the respective Gram Panchayat, I said I will not work. I'll continue to work under the respective Gram Panchayat. I cannot be asked to work under the outsource agency. I continue to work. I also produce all my attendance sheets here, which is dated 2/8/2015. I have produced my attendance sheets of having worked in respective Gram Panchayat, which has been approved, signed by the respective PDOs.
ಆಯ್ತು, what
not
happened?
along with me, Your Lordship,
Please
along with other employees also for that matter. In the interim, Your Lordship, an order was also passed. That is 10/9/2014 by the government, which is Annexure AV. Annexure AV, which I have filed along with my IA number 3 of 2016.
Actually, AB ಅಂತ ನೋಡಿ IA 3 of 2016.
Page number 21.
What happened after Annexure B? What happened after Annexure B?
That's what, in fact, we were all appointed, Your Lordship. As per that, we were all appointed. That's what I have produced my appointment orders also. Between the year 2011 to 2009 to 2011, whatever the appointment I have received, I have produced this appointment order.
What is Annexure C? Annexure C ಏನಿದು? What does it say?
It's again referring about Sarkar Sutole dated 9/3/2007. 56, Your Lordship.
ಕೊಡ್ರಿ ಅದನ್ನ IA 3 ಕೊಡ್ರಿ. Yes.
The government proposed also these posts, Your Lordship, which were held with petitioners. As per the government order dated 5/6/2009, that's what they say, Your Lordship. This is what I have produced as Annexure C. This order was challenged by the Union Lodge by writ petition number 8588
Yes.
of 2010. This honorable court had also passed an interim order restraining the respondents from outsourcing the jobs which were being done by the data entry operators. That was also stayed, Your Lordship, as per the writ petition number
Yes.
8588. It was also stayed. Later on, in fact, as I have produced it, I was appointed in the regular post with respect to Gram Panchayat as per the appointment order which I have already produced it. When the matter was pending here, and a government had also passed an order dated 10/9/2014, how exactly these class of employees has to be regularized, how they have to be appointed, which is Annexure AV.
Yes.
A clarification was also issued, Your Lordship, by another government clarification, which is dated 25/10/2014, and earlier, and 17/12/2014, and also 2/11/2015. I think I have not produced 25/10/2014, but I have produced 17/12/2014 and 2/11/2014 clarification produced here,
Yes.
which is Annexure AW,
Yes.
along with my IA number 3 of 2016.
Yes. ನೀವೆಲ್ಲ ಯಾವ ರೆಡಿ ಆಗಿ ಬರ್ತೀರಾ?
Now,
When
I
will you
just-
come completely ready?
I'll prepare a brief synopsis, Your Lordship. I'll prepare a brief synopsis and submit it. Can we have it on Wednesday, Your Lordships?
Joint counsel for the petition seeks time. List as a last chance on Wednesday.
Wednesday.
Article 41, Nagarajappa and associates.
Yeah, Nagarajappa and associates.
Petitioner. Okay, day after
Took
tomorrow.
time
my lord.
saying that you'll argue. You asked for a
Okay.
passover saying that you'll argue. Please argue.
In it, my lord, but
What are the facts?
my lord, here, my lord, the applicant, my lord, is an assistant development officer, my lord. She has been appointed as an assistant development officer on 4/5/1998, my lord. My lord, later on, my lord, the juniors to the petitioners, my lord. Annexure A, my lord, is a probationary period, my lord. The petitioner has completed a probationary period, my lord. On 23/7/2001, my lord, she has completed a probationary period.
Yes.
Based on that, my lord, she has been promoted on 30/9/2006, my lord. She has been promoted as a development officer, my lord.
Yes.
There, my lord, the juniors to the petitioners, my lord, that is respondent number 4 to 9, my lord, has been placed above the petitioner, my lord. Lord, at that time, my lord, based on that, my lord, a pay fixation has been given, my lord, on 25/10/2006, my lord.
What is the date of entry into service of all these respondents?
That is, my lord, it's at Annexure J, my lord.
Annexure J.
Date of service, my lord, page 40. The respondent number 4, my lord, that serial number 5. Shown at serial number 5. HD Chennarasegowda. ಸೇವೆಗೆ ಸೇರಿದ ದಿನಾಂಕ, my lord, 11/5/1998. And respondent number 5, that at serial number 11, my lord. KN Jayamma. Service at appointed at on 27/5/1998. Serial number 12, my lord. H Prakash, 6/5/1998. 13, YR Bhakta Kuchela, 6/5/1998. K Manjunath, 13/5/1998. SN Bansi, 15/5/1998. The petitioner, my lord, serial number 16. N Sujata, 4/5/1998. Serial
Whether-
number 5, my lord, the fourth respondent, joining date is also, joining date is 11/5/1998. But the petitioner joining date is 4/5/1998.
Whether they were all recruited in the same notification or what?
They were all recruited in the same notification.
Same notification.
Please.
Illi the notification.
I have not produced it. The promotion, my lord, to the post of development officer from the assistant development officer is a purely a promotional cadre, my lord. Filling up the post is purely a promotional cadre, my lord. My lord, moreover, my lord, the juniors to the petitioners, my lord, has been placed above. my
E
lord.
ಓದು. Annexure E ಓದು.
Please. Is the objection submitted by the
ಓದು, ಓದು.
petition?
Please read the objections.
Please, madam. ವಿಷಯ ಡಿ ದೇವರಾಜ್ ಅರಸು ಹಿಂದುಳಿದ ವರ್ಗಗಳ ಅಭಿವೃದ್ಧಿ ನಿಗಮ ವಿವಿಧ ಅಧಿಕಾರಿ ಸಿಬ್ಬಂದಿ ವರ್ಗದ ದಿನಾಂಕ 1/1/2010 ಹಾಗೂ ದಿನಾಂಕ 1/1/2002 ತಾತ್ಕಾಲಿಕ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಯನ್ನು ಹೊರಡಿಸುವ ಕುರಿತು. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಯ ಬಗ್ಗೆ ಈ ಕೆಳಕಂಡಂತೆ ಆಕ್ಷೇಪಣೆಗಳನ್ನು ಸಲ್ಲಿಸಲಾಗಿದೆ. ಪಟ್ಟಿಯ ಕ್ರಮ ಸಂಖ್ಯೆ 1ರ ಅಭ್ಯರ್ಥಿಯು ಹಿರಿಯ ಬೆರಳುಚ್ಚುಗಾರರಿಂದ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ನೇರವಾಗಿ ಮುಂಬಡ್ತಿ ನೀಡಲಾಗಿದೆ. ಈ ರೀತಿ ಮುಂಬಡ್ತಿ ನೀಡಲು ನಿಯಮದ ಅನುಸಾರ ಸಹಾಯಕ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಹುದ್ದೆ ನೀಡಬೇಕಾಗಿತ್ತು. 2. ಪಟ್ಟಿಯ ಕ್ರಮ ಸಂಖ್ಯೆ 2ರ ಅಭ್ಯರ್ಥಿಯು ಕಿಯೋನಿಕ್ಸ್ ಸಂಸ್ಥೆಯಿಂದ ನಿಯೋಜನೆಯ ಮೇಲೆ ನಿಗಮಕ್ಕೆ ಬಂದಿದ್ದು ನಂತರ ನಿಗಮದಲ್ಲಿಯೇ ವಿಲೀನಗೊಂಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಪ್ರಥಮ ಆದ್ಯತೆಯಾಗಿ ನಿಗಮದ ನೌಕರರಿಗೆ ನೀಡಿ ನಂತರ ಅವರಿಗೆ ನೀಡಬೇಕಾಗಿರುತ್ತದೆ. ಪಟ್ಟಿಯ ಕ್ರಮ ಸಂಖ್ಯೆ 10ರಲ್ಲಿರುವ ಅಭ್ಯರ್ಥಿಯು ಅಮಾನತ್ತು ಹೊಂದಿರುವುದರಿಂದ ಅವರಿಗಿಂತ ಮೊದಲನೆಯ ಸ್ಥಾನ ನೀಡಬೇಕಾಗಿತ್ತು. ಈ ಎಲ್ಲ ಕಾರಣಗಳಿಂದ ನಿಗಮದ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋ ದಿನಾಂಕ 21/11/2021 ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಯಲ್ಲಿ ನನಗೆ ನ್ಯಾಯ ದೊರಕಿಸಿ ಕೊಡಬೇಕೆಂದು ಕೋರಿ.
ಎಲ್ಲಿ ಹೇಳಿದ್ರ ಇವರೆಲ್ಲ ನಮ್ಮ ಜೂನಿಯರ್ಸ್ ಅಂತ?
There, my lord, there has not been that has not been mentioned, my lord.
Then?
In the objections.
You not raised any objection to the provisional seniority list?
Later on, endorsement has been issued, my lord. So the said endorsement also, my lord, the
Is this a district-wise seniority? Is this a district-wise seniority?
Seeking for, to become a district manager.
Oh, correct. Whatever is mentioned at page number 40, is it a district-wise seniority or
Is the.
state-wise?
Is the probationary who have been made, from probation who have made, this thing, permanent. Page number 40, my lord.
See, Mr. Sujata Bengaluru Nagara. And this Chennai Goda is Mysuru.
Channarasegowda, madam.
Is this a district-wise seniority or a state-wise seniority?
But this is a corporation which has, in every district, there's a district manager, my lord. She is seeking for seniority among the district managers that I have, but if I'll just submit on the matter. The case before this court is, all of them are promoted in the same list. He's stating, I joined 4 days before, in the probationary period, I joined 4 days in the same list. That's the case. It's not that they're seniors, they're not seniors. They're all same. Her case is that when we give a date for probationary, some people join 1 week later. It's mentioned in the petition only. Your Honor may kindly take para 7, page number 7, my lord. Her case is that she joined a week before all of them, or some of them have joined 1 week later, 3 to 10 days later, 4 days later. Her case is that she is not their senior. And moreover, she joined as a development officer initially in 98. Subsequently, in 2006, she joined as an assistant development officer. She was made a development officer in 2006.
Yes.
She never objected to the seniority then. She is after, as per the same seniority in 2012, they have brought in district managers. That is what she is challenging. In the writ petition only, she is stating, I didn't object to the seniority list in 2006 because my colleagues told me not to object. At para number 3, based on the same seniority list, she was.
If you accepted the seniority list.
And my lord,
Taken a promotion on that ground. Can you
My lord,
twice,
it is
can you now take a objection to the seniority list that was prepared in
due to
2006?
misleading of my colleagues and all, my lord, I have not objected at that time, my
Can you
lord.
do it now
Let-
is what I am asking.
Please.
Can you do it after 7 years? After 2 rounds of promotion, you don't even object to that. Even in objections to the provisional seniority list, you don't even whisper. Don't even mention.
as on today, if I may just submit.
Yes, when will you argue?
My lord, Thursday.
Don't come to the court without reading the file.
Please, my lord,
Ah.
Thursday.
Illandre don't come to my court.
No, my lord.
Tell
Senior is
your
out of,
senior,
senior is out of state, my lord. For
let
that
him be
reason,
out
my
of
lord,
station,
I'm
mister, but
seeking
as
for-
a junior advocate, it is your responsibility to read the file.
Please,
Don't come and ask for a time just like that.
please.
Without reading the file, I will not allow you to ask for adjournment. And counsel for the petition seeks time. Since this petition is filed in the year 2013, as a last chance list on yavattu.
Thursday.
Yavattu could
Number 42, MK Girish.
MK Girish.
Appearing on behalf of the petitioner, my lord.
Yes.
My lord, this is the case of wrongful denial of promotion and seniority to the petitioner in question, my lord. My lord, as I reiterated earlier, my senior has met with a road accident and is currently undergoing treatment. And the
You
same
need
has
not tell
been,
the same thing again and again.
yes, my lord.
You know why
My
you have
lord,
passed it over?
yes, my lord, so that I could convey the brief facts of the case, my lord. So, my lord, the petitioner in question, he was appointed as a grade 1 Gram Panchayat secretary on the 31st of May 2003, my lord. And he became eligible for the promotion to the Panchayat Development Officer or a PDO since he had occupied such a role for more than 5 years, my lord. However, my lord, on the 15th of March 2010, while 36 other candidates were promoted, the petitioner was wrongfully denied promotion, citing pending disciplinary proceedings, despite none having existed at that time, my lord. 3 days later, my lord, the petitioner was suspended, but his suspension was revoked on the 28th of April 2010, and he was fully exonerated of any charges which were levied against him, my lord. My lord, meanwhile, in the April 2010, 90 PDOs were directly recruited, placing the petitioner, who has more eligibility since he was there for over 5 years, and he was only he was the only ST candidate over there, my lord, below them. Therefore, my lord, despite being cleared of all charges, the petitioner was
What
promoted
is
to a
ST
PDO.
candidate?
My lord,
Who is an ST candidate?
scheduled tribe candidate, my lord. He was the only one amongst them. So, my lord, despite being cleared of all the charges, the petitioner was promoted to the PDO only on the 30th of June 2012, my lord, after a 2-year delay, my lord. That's why, my lord, his representation seeking retrospective promotion from the 15th of March 2010 was rejected, and this is given in Annexure A, my lord, the order. And his seniority was also unfairly placed below the 90 directly recruited PDOs, my lord. And my lord, it is to be noticed that whoever was appointed above him, they had only 3 years of experience, my lord, despite the petitioner himself having 5 years of experience, my lord. Also, my lord, his objection once again was rejected on the 16th of February 2013, which is given in Annexure N, my lord. And therefore, my lord, the list regarding the same was released on the 3rd of January, where it showcases that the seniority of the petitioner is placed once again below the 90 candidates who are hired after him, my lord. Therefore, my lord, the petitioner was wrongfully denied promotion when he was eligible and later exonerated. Therefore, is legally entitled to a retrospective promotion from the 15th of March 2010, and there must be a correction to his seniority, my lord. That's why the petitioner has filed this petition, my lord.
Yes. So now you understood what is meaning of knowledge is power.
Yes, my lord.
Huh?
Yes, my lord.
Uh,
Of course, my lord.
Don't parrot and ask for an adjournment.
Yes, my lord. It's very important to peruse the facts.
Now you authoritatively you are arguing the matter
Yes, my lord.
because you know the facts. You read the file.
Yes, my lord.
So please keep up this habit of reading the file.
Yes, my lord.
Don't seek for an adjournment because it is convenient for you to do it.
Yes, my lord. Of course, my lord.
Yes, ready now? Not you are ready. You are also not ready. Very good.
Please grant 2 weeks time, my lord. My
No 2
senior
weeks,
will also-
madam. This is a 2013 matter. I will list it on Thursday. Please argue the matter. Yes, list on Thursday.
My lord, can you please list it on Friday, my lord?
Friday, yes.
Much obliged.
Friday, Monday. Yes.
Yes, ma'am.
Yes, Sharanjit Shetty. Nivena?
Please, my lord.
Sharanjit Shetty.
No, my lord.
Yaru?
AK was for AK.
Huh?
AK was something.
ಅದು next matter ಅಲ್ಲಪ್ಪ 41 ಅಲ್ಲಿ ಯಾರು
42, my lord. This is
My
the
lord,
matter.
this is 42.
42,
This is
my lord.
42.
Please,
Yes,
yes.
ma'am.
Number 43, KR.
Prasad Yavar. There is no representation before, though it is called twice in the day. This petition is filed in the 2014 as hence as a last chance list on
6th March.
Hmm.
Serial number 50,
Sridhar.
this reader.
For the petitioner.
Then last matter. ಇನ್ನೊಂದಿದೆಯಾ ಯಾವ್ದು?
Pro forma promotion was sought by the petitioner, my lords. This has seen 3 rounds of litigation. The petitioner was initially appointed in 1956, my lords, as a head clerk in the office of ARCS Chitradurga. And in 58, he got promoted as inspector. And in 1964, he was promoted as senior inspector of cooperative societies. In 67,
Is he still alive?
he's still alive, my lords. I verified that. In fact, last time it was listed. I took time on that basis, saying I'll verify. If my lords permit, I will also argue on next week. There's no difficulty. I'll just summarize the case and
If you're fully ready, I can hear you. If you're fully ready.
my lords, I will honestly say that I am never fully ready before my lords. I will make my best effort.
Facts ಬಗ್ಗೆ ಎಲ್ಲ ರೆಡಿ ಇದ್ರೆ ಆರ್ಗ್ಯೂ ಮಾಡಿ. If you're confident that you are ready, please argue. Otherwise, why should I waste your time, my time? Let me go back to the chamber, do some work.
My lords, facts I will clearly state, my lords. There's no difficulty because, and the actual dispute now, my lords, because of the statement of objections filed by the respondent, the fact of the seniority being in my favor is not disputed. The reason being given is, even if I were to be given the seniority, I will get lesser pay. Therefore, there is no point in making this order. Is the final stand which is taken by the state, which I have also communicated to my client, and the petitioner states I am not objecting to anything. Whatever is legally the consequence, I am prepared for that. Therefore, my lords, the specific thing was petitioner would seek the order. That is the. So 1967, my lords, the junior of the petitioner was promoted.
Yes.
That was challenged in WP number 1606 of 1967, and an order was obtained. That order is produced as Annexure B, my lords, at page 26. At the page 27 is the order, my lords. The petitioner's complaint in this case is that though he is numbered as serial number 23 in the final interstate seniority list dated 20th May 65 relating to the cooperative department, the second respondent, who is at number 60, has been promoted without his case having been considered for promotion. The state government in their counter affidavit state that the final interstate seniority list has since been quashed by this court, and they will review the promotions after the revised final list is published. The said defense, however, is no answer to the claim now made in view of the decision of the Supreme Court in G.S. Ramaswamy versus Inspector General of Police, 1966 Supreme Court, and decision of this court in Kathegowda's case. As the petitioner has since been promoted, it would, however, be sufficient to make a declaration that the petitioner is entitled to review of the promotions in the light of the principles stated in Kathegowda's case and to be given reliefs, including monetary benefits consequential upon such promotion. We make declaration accordingly. Now, the case of the petitioner is till date, this is not implemented. In between, my lord, subsequent to this, there was a representation given which was not acted upon, because of which a contempt was filed, CCC 39 of 1973, which, as a matter of record, my lords, there was a submission made that is produced at Annexure C, my lords. There was a submission made that the order is complied with and the contempt proceedings are closed.
Yes.
That is in 1973, my lords. That is at Annexure 3. In response to the representations in 1975 and 80 given by the petitioner for pro forma promotion on behalf of second party, it is intimated that the orders of the government in this regard are awaited. There is a communication by the government that because there is no notification of the promotion, the representations are given by the petitioner. It is stated that we are awaiting final orders, even after the contempt is closed. Then in 1990, the petitioner retires from service.
as a joint director of cooperative audit on 36/1990. On 15/2/1991, the first respondent, while reviewing the promotions to the cadre of assistant director of cooperative audit and department of cooperative audit, so and so for the period 1977 to 90, fixed the date of eligibility for promotion to the cadre of assistant director of cooperative audit. The date of eligibility of petitioner and Sri Bhagyawadi were determined as per which the petitioner's date of eligibility was fixed as 77 and Bhagyawadi was 78. Now this is done from 77 onwards, my lords. Whereas my case is 1967 itself, there was an issue. That report, my lords, that review of the promotion is produced as annexure H, where it is clearly I am at serial number 16 and he is at serial number 65. Then in 2003,
Yes.
in 2003, my lords, the assistant director of cooperative societies submits a report that the first respondent to the first respondent, wherein he observes that the petitioner had attained seniority prior to Mr. Bhagyawadi and that he has also become eligible for promotion prior to Mr. Bhagyawadi, and thereby recommends the government to direct the cooperative audit department to revise the petitioner's salary from date of eligibility. However, this is not done. Therefore, my lords, another specific instance where it is clearly recorded that order is not complied with. Then on 14/7/2004, the first respondent asked the petitioner to resubmit his representation after publication of the final seniority list, even though this honorable court in its order dated 8/6/1971 has observed that the publication of final seniority list is no answer to the claim of petitioner. The office of the second respondent then issues a letter to the principal secretary of first respondent, wherein it is stated that it had already opined that petitioner cannot be given pro forma promotion from the date on which actual promotion was given to Bhagyawadi. Therefore, government was requested to consider the said opinion. The first respondent gives an endorsement to the effect that the petitioner, having become joint director of cooperative audit department under 6(1) of the Karnataka Government Service Seniority Rules 57, the petitioner's representation could not be acted upon in law. That the petitioner, having been transferred to the cooperative audit department, he was not entitled to promotion in the cooperative societies department, and as such, the petitioner was not entitled to avail any benefits under the order of the High Court. Again, my lord, just one point here. The order is in 1967.
Yes.
Holding that I am entitled to the benefit. Now in 2010, because of a subsequent act, it is now attempted to deny me the benefit of that promotion. Then in 2013, the petitioner again files a writ petition 50000 of 2013, seeking inter-alia for a writ of mandamus to give pro forma promotion to the petitioner from the actual dates on which his junior V.S. Bhagyawadi reported for duty in the respective cadres. In 2013, the writ petition is disposed of, that is at annexure Z, my lords.
Yes.
There, my lords, at 111, that is the order, page 111, learned counsel for petitioner submits that the writ petition may be disposed of by directing respondent number 1 to consider his representation of 9/4/2012 expeditiously in accordance with law. I find no legal impediment to grant the prayer. Accordingly, R1 is directed to consider aforesaid representation of petitioner in accordance with law expeditiously and in any event within 3 months from the date of receipt of the copy of this order. Petitioner shall furnish a copy of the order, so and so, so and so. Now, this is not complied with. Then in 2014, another contempt is filed, 919 of 2014.
Yes.
On 13th August 2014, a submission is made relying on government leader submission that the order passed by this court in 50000 has been complied with by issuing an endorsement. This honorable court closed the contempt proceedings by holding that if the petitioner has aggrieved by the endorsement issued, he is at liberty to challenge the same in accordance with law. Then in 2015, on an application being filed by petitioner to recall the order closing contempt, this court refused to do so and reiterated that if petitioner is aggrieved by the endorsement, he is at liberty to challenge the same.
Yeah.
Against that endorsement now, my lords, therefore the petitioner is before this honorable court. Now in that endorsement at annexure A,
Yes.
it is clearly mentioned that the granting of this promotion is not going to be beneficial monetarily to the petitioner. That, my lords, is at in page 17, para 3, and again in page 18 in the first paragraph, very specifically mentioned. Then they also rely on the fact that in the contempt, it is specifically mentioned that the order is complied with. Therefore, question of considering representation does not arise and hence it is rejected.
Please read para 3.
ಅಲಾಟ್ಸ್. ಪೇಜ್ 17 ಪ್ಯಾರಾ 3. ಇದರಂತೆ ಈ ಕಚೇರಿ ಹಂತದಲ್ಲಿ ಈಗಾಗಲೇ ತಮ್ಮ ಅಪತಾಂತ್ರಿಕ ಅವಧಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪದೋನ್ನತಿ ವಾಸ್ತವ ದಿನಾಂಕ ಮತ್ತು ಅರ್ಹತಾ ದಿನಾಂಕಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ವಾಸ್ತವ ದಿನಾಂಕದಂತೆ ಅರ್ಹತಾ ದಿನಾಂಕವು ನಂತರದಲ್ಲಿ ಲಭ್ಯವಾಗಿದ್ದು ಈ ವೇತನ ನಿಗದಿಯಂತೆ ವೇತನದಲ್ಲಿ ಹೆಚ್ಚಳ ಉಂಟಾಗುವುದಿಲ್ಲ. ಅದರಂತೆ ವೇತನ ಪುನರ್ ನಿಗದಿಪಡಿಸಿದಲ್ಲಿ ಲಾಭದಾಯಕವಾಗಿರುವುದಿಲ್ಲ. So this is the reason which they give. ಶ್ರೀ VS ಬಾಗೇವಾಡಿ ಇವರ ಈ ಇಲಾಖೆಗೆ
ಬರುವಾಗಲೇ ಸಹಾಯಕ ನಿರ್ದೇಶಕರ ಹುದ್ದೆಗೆ ಅಭಿಮತ ಚಲಾಯಿಸಿ ಬಂದಿರುವುದರಿಂದ ಅವರಿಗೆ ಸಹಾಯಕ ನಿರ್ದೇಶಕರ ಹುದ್ದೆಗೆ ಅರ್ಹತಾ ದಿನಾಂಕವನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. ಬದಲಾಗಿ ಅಭಿಮತ ಎಂದು ನಮೂದಿಸಿದೆ ಹಾಗೂ ದಿನಾಂಕ 29/5/1978 ಅರ್ಹತಾ ದಿನಾಂಕ ಪಡೆದಿರುವ ಕ್ರಮ ಸಂಖ್ಯೆ 63ರ ಶ್ರೀ SS ಗೌಡರ್ ಹಾಗೂ ಕ್ರಮ ಸಂಖ್ಯೆ 65 ಶ್ರೀ BM ಶ್ರೀನಿವಾಸ್ ಇವರ ನಡುವೆ ಜ್ಯೇಷ್ಠತಾ ನಿಗದಿತಪಡಿಸಿದೆ. ಶ್ರೀ ಬಾಗೇವಾಡಿ ಅವರು ಉಪನಿರ್ದೇಶಕರ ವೃಂದದಲ್ಲಿ ಅರ್ಹತಾ ದಿನಾಂಕ ಪಡೆಯುವ ಮೊದಲೇ ನಿವೃತ್ತಿ ಹೊಂದಿರುವುದರಿಂದ ಇವರಿಗೆ ಉಪನಿರ್ದೇಶಕರ ವೃಂದದಲ್ಲಿ ಅರ್ಹತಾ ದಿನಾಂಕ ನೀಡಿರುವುದಿಲ್ಲ. ಮುಂದುವರೆದಂತೆ ಸಹಾಯಕ ಸಂಘದ ಲೆಕ್ಕ ಪರಿಶೋಧನಾ ಸಹಾಯಕ ನಿರ್ದೇಶಕರ ಹಾಗೂ ಉಪನಿರ್ದೇಶಕರ ವೃಂದಗಳಲ್ಲಿ ಪದೋನ್ನತಿಗೆ ಅರ್ಹತಾ ದಿನಾಂಕ ಪರಿಗಣಿಸಿ ತಮ್ಮ ವೇತನ ನಿಗದಿಪಡಿಸಲು ಕ್ರಮವಿಟ್ಟಿದ್ದಲ್ಲಿಯೂ ಇದು ಲಾಭದಾಯಕವಾಗಿರುವುದಿಲ್ಲ. ಸಹಕಾರ ಸಂಘದ ನಿರೀಕ್ಷಕರು ಮುಖ್ಯ ಗುಮಾಸ್ತರು ಸಹಾಯಕ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಹುದ್ದೆಯ ಅಂತಿಮ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಯ ವಿಲೋಕನದಲ್ಲಿ ತಮಗೆ ಸರಿಯಾದ ಜ್ಯೇಷ್ಠತೆ ಹಾಗೂ ಪದೋನ್ನತಿ ಅರ್ಹತಾ ದಿನಾಂಕವನ್ನು ನಿಗದಿಪಡಿಸಲು ಸಹಾಯಕ ಸಂಘದ ನಿರ್ಬಂಧಕರಿಂದ ಕ್ರಮವಹಿಸಲಾಗಿರುತ್ತದೆ. ಇದರಂತೆ ಅಂತಿಮ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಯು ವಿಲೋಕನದಲ್ಲಿ ತಮಗೆ ಶ್ರೀ ಬಾಗೇವಾಡಿಯವರಿಗಿಂತ ಮುಂಚೆ ಜ್ಯೇಷ್ಠತೆ ಮತ್ತು ಪದೋನ್ನತಿ ಅರ್ಹತಾ ದಿನಾಂಕ ಲಭ್ಯವಾಗಿರುತ್ತದೆ ಹಾಗೂ ಶ್ರೀ ಬಾಗೇವಾಡಿಯವರಿಗೆ ಅವರಿಗೆ ಲಭ್ಯವಾಗತಕ್ಕ ಜ್ಯೇಷ್ಠತೆ ಮತ್ತು ಪದೋನ್ನತಿ ಅರ್ಹತಾ ದಿನಾಂಕವನ್ನು ನಿಗದಿಪಡಿಸಲು ಕ್ರಮವಾಗಿರುತ್ತದೆ. ಶ್ರೀ ಬಾಗೇವಾಡಿಯವರಿಗೆ ನೀಡಲಾದ ಪದೋನ್ನತಿ ಅರ್ಹತಾ ದಿನಾಂಕದಂತೆ ತಮ್ಮ ವೇತನ ನಿಗದಿಪಡಿಸಲು ಕ್ರಮವಿಟ್ಟಿದ್ದಲ್ಲಿ ಲಾಭದಾಯಕವಾಗಿರುವುದಿಲ್ಲ.
What is the effort that you have made? ಲಾಭದಾಯಕವಾಗುವುದಿಲ್ಲ ಅಂತ ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ಹೇಳ್ತಿದ್ದೀರಾ?
My lords, actually he is adopted in cooperative audit department in the 1977, my lords. By that time the Bagewadi was already promoted, my lords. So they shifted to cooperative audit department. So by that time they separate that seniority list was taken, my lords, consideration.
Right,
but prior to that there is no why it is not been considered. There is no document, my lord. Kindly see 16, page number 16. It is clearly
60.
16, my lord. Same annexure. ಮೇಲ್ಕಂಡ ವಿಷಯ ಸಂಬಂಧಿಸಲು ಉಲ್ಲೇಖ ಒಂದು ಸರ್ಕಾರ ಪತ್ರದಲ್ಲಿ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ದಾಖಲಾಗಿರುವ ರಿಟ್ ಅರ್ಜಿ ಸೋನ್ಸೋ ದಿನಾಂಕ ಆದೇಶದ ಪ್ರತಿ ಇತರೆ ಕಡಕವನ್ನು ಪರಿಶೀಲಿಸಿ ಜರೂರಾಗಿ ಕ್ರಮ ಕೈಗೊಂಡ ಕ್ರಮದ ಮಾಹಿತಿ ನೀಡಲು ಕೋರಲಾಗಿದ್ದು ಅದರಂತೆ ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಸರ್ಕಾರಕ್ಕೆ ಮಾಹಿತಿ ನೀಡಲಾಗಿದೆ. ಉಲ್ಲೇಖ 3ರಲ್ಲಿ ಸರ್ಕಾರದ ಪತ್ರದಲ್ಲಿ ಈಗಾಗಲೇ ರಿಟ್ ಅರ್ಜಿ ಸೋನ್ಸೋ ದಿನಾಂಕ ಆದೇಶವನ್ನು ಅನುಷ್ಠಾನಗೊಳಿಸಿರುವುದಾಗಿ ಹಿಂಬರಹ ನೀಡಬೇಕೆಂದು ಈ ಕೆಳಗೆ ನಿರ್ದೇಶಿಸಿದ್ದೆ. ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ನೀಡಿರುವ ತೀರ್ಪಿನನ್ವಯ ಶ್ರೀ ವೆಂಕಟರತ್ನಯ್ಯ ಶೆಟ್ಟಿ ಜಂಟಿ ನಿರ್ದೇಶಕರು ಆದ ತಾವು ದಿನಾಂಕ 9/4/2012 ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಿರುವ ಮನವಿಯಲ್ಲಿ ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ ಕ್ರಮ ಕೈಗೊಳ್ಳಬೇಕಾಗಿರುತ್ತದೆ. ತಮ್ಮ ಮನವಿಯ ನಿಯಮಾನುಸಾರ ಕೆಳಕಂಡಿದೆ. ತಮ್ಮ ಮನವಿಯಲ್ಲಿ ಪದೋನ್ನತಿಯನ್ನು ಯಾವ ನಿಯಮಗಳಡಿ ಕೋರಿರುತ್ತೀರಿ ಎಂಬುದು ಸ್ಪಷ್ಟಪಡಿಸಿರುವುದಿಲ್ಲ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ತಮ್ಮ ಕೋರಿಕೆಯನ್ನು ಯಾವ ನಿರ್ದಿಷ್ಟ ನಿಯಮಗಳ ಅಡಿಯಲ್ಲಿ ಪರಿಶೀಲನೆ ಒಳಗೊಂಡು
Correct. Seniority rules ilva?
That separate rule is there, my lord.
Which is
that
the rule?
audit, he comes to audit department, my lord, cooperative audit department.
If these two people, please wait, if these two people have been recruited
Please.
and if there's a date of recruitment available with you,
Please, my lord.
then while considering seniority, it is the date of entry into service that matters. Date of entry into service that matters.
Please, my lord, but he is appointed first division clerk and the petitioner appointed second division clerk.
Petitioner was appointed second division clerk. I hope you get the facts right.
Please, my lord. I think vice versa.
What?
Please.
Then therefore, where should the petitioner be fixed then?
Was opted to cooperative audit department. He was promoted as a inspector.
Madam, let him go to whichever department he wants.
Please, ma'am.
If it is favorable to him to one department, he will go to that department.
Please.
See, there are many departments. There might be departmental seniority. In one department, there could be easy promotion. In the other department, the promotions might be less. So this man would have opted to the other department. He could have taken the other route. The question is, when this man is promoted, his seniority should be maintained.
And then they clearly
ಲಾಭದಾಯಕವಾಗುವುದಿಲ್ಲ ಅಂದ್ರೆ ಲೆಕ್ಕ ಮಾಡಿದೀರಾ? Have you prepared a chart as to if he is given seniority over and above the respondent number 2, what will be his chances of going to the next level? What will be his chances of getting a higher promotion, higher scale? What are those chances? Have you made an effort? ಲಾಭದಾಯಕವಾಗುವುದಿಲ್ಲ ಅಂತ ಸುಮ್ಮನೆ ಹೇಳಿದ್ರಿ. On what basis?
and even contempt proceeding has been dropped, my lord. That is
ನೀವು ಮಾಡಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ ಡ್ರಾಪ್ ಮಾಡಿದ್ದಾರೆ.
complaint.
Therefore, is before this court saying that you are not compliant. Yes.
My lords, kindly see page number 17. That is first para. sir.
ಓದಿ.
ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಸೇವಾ ನಿಯಮಗಳು 1988 ನಿಯಮ 2 ಸರ್ಕಾರಿ ನೌಕರ ಪೂರ್ವಾನ್ವಯ ಪದೋನ್ನತಿಯ ಬಗ್ಗೆ ತಿಳಿಯಪಡಿಸುತ್ತಿದ್ದು, ಈ ನಿಯಮಗಳಡಿ ಕ್ರಮ ಪರಿಶೀಲಿಸಲು ಯಾವ ಕಾರಣಗಳಿಂದಾಗಿ ಪದೋನ್ನತಿ ಹಕ್ಕನ್ನು ತಡೆ ಹಿಡಿಯಲಾಗಿದೆ ಪರಿಗಣಿಸಿರುವುದಿಲ್ಲ ಎಂಬ ಬಗ್ಗೆ ಸ್ಪಷ್ಟ ಕಾರಣ ಪರಿಶೀಲನೆಗೆ ಅಗತ್ಯವಿರುತ್ತದೆ. ಕಾರಣಗಳನ್ನು ಪರಿಶೀಲಿಸಿಕೊಂಡು ಇವು ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಸೇವಾ ನಿಯಮ 1978 ನಿಯಮ 2 ಅಡಿ ಬರುತ್ತಿದ್ದಲ್ಲಿ ಪೂರ್ವಾನ್ವಯ ಪದೋನ್ನತಿ ನೀಡಿರುವುದನ್ನು ಪರಿಶೀಲನೆಗೆ ಒಳಪಡಿಸಲು ಬರುತ್ತದೆ. ಆದರೆ ತಮ್ಮ ಮನವಿಯಲ್ಲಿ ಶ್ರೀ ಭಾಗ್ಯವಾಡಿ ಇವರಿಗೆ ಪದೋನ್ನತಿ ನೀಡುವ ಯಾವ ಕಾರಣಗಳಾಗಿ ನಿಮ್ಮ ಪದೋನ್ನತಿ ಹಕ್ಕನ್ನು ತಡೆ ಹಿಡಿಯಲಾಗಿದೆ?
ಇದೆಲ್ಲ ಮುಗಿದೋಯ್ತು. 67 ಮುಗಿದೋಯ್ತು ಇದೆಲ್ಲ. Everything is gone. You have to give effect to the order passed in WP number 1606. ಅವಾಗ ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಯಾವ ಕಾರಣಕ್ಕೆ ನಿಂತು ಹಿಡಿದಿದ್ಯಪ್ಪ ಅಂತ ಅವಾಗ ಹೇಳ್ಬೇಕಾಗಿತ್ತು ನೀವು. You kept quiet, you allowed water to flow. And this man has been filing litigations after litigations. ಏನ್ ಮಾಡ್ತೀರಿ? All that he wants is, I don't think he even need money. He wants his post to be restored, his seniority to be restored. Time-bound promotion barbodu. He might get time-bound promotion. Time-bound promotion, but he might go somewhere director agbodu. Who knows? So restore his promotion is what I am asking. What he is asking, sorry. And 2015 ಇಂದ ಪೆಂಡಿಂಗ್ ಇದೆ. ಏನು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಲಾ ಅಥವಾ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೋತೀರಾ ಏನ್ ಮಾಡ್ತೀರಾ?
Next week, my lord. Any instruction?
Learned counsel for the rest. Learned AGS seeks time as the last chance list on
10th March. Till 56.
Yogesh Naik, SN Murthy,
Challenging the inquiry proceedings, madam.
SN Murthy,
Petitioner dismissal,
Somshekhar ಅವರಾ?
please.
Mr. SN Murthy, dismissal
Please, my lord. The allegation is, my lord, he's claiming, my lord, to, he produced the, my lord, the manipulation bill has been claimed to the company, my lord, taken, my lord, reimbursement, claiming the reimbursement. My,
The charge sheet,
my respectful submission is, my lord. Charge, my lord,
where's the charge memo?
please, please. Lord, page, annexure D, my lord, page 23. A fraud made by the, my lord, petitioner ಅಂತ ಹೇಳ್ತಾರೆ. Regarding, my lord, I have,
Fraud made the my lord ಅಂತ ಹೇಳ್ಬೇಡ್ರಿ.
my lord, fraud made by the, my lord, petitioner in respect of, my lord.
ಅದಕ್ಕೆ
They have-
my lord ನ ಅವಾಗ ಉಪಯೋಗಿಸ್ಬಿಡಿ.
The regarding, my lord, the bill is produced in the, my lord, petitioner, say that that has been manipulated by the petitioner, and say that that is not issued by the, that showroom, my lord. Regarding petitioner, my lord, purchased this some shoes, my lord, from the company is concerned. My respectful submission is, my lord, that persons has not been examined. And also, my lord, the vigilance committee come to the, given some report. Based on that, my lord, the acceptance that, and the annexure, my lord, the cross examination, may I read? Page 55. The question, my lord, page 66.
You're the regional sales manager.
Please, please, my lord. Respondent, pharmaceutical company. The ground is, my lord, only point number 10, my lord. The para 10 of the merit petition, my lord. And 20 to 12, my lord.
For just 1,000 rupees.
Please, my lord. Four bills is there. They say that, my lord, the vigilance committee officer has been produced some documents, but they are accepted. But we have clearly denied, my lord. The petitioner had clearly denied that, my lord. I am not submitting that. On that regard, my lord, I have stated, my lord, page number 56, cross examination. Question 6, my lord. I say the handwritten bill marked as exhibit M4, comma, I have neither signed nor given any endorsement. The amount claimed through the expense report June 2011 marked as exhibit M1 is totally different than the amount mentioned in the alleged bill submitted by you. Hence, the bill produced by you was not submitted by me.
ಇದು ಯಾರು ಕ್ವಶನ್ ಕೇಳೋರು?
Regarding, my lord, the question, cross examine ಮಾಡಿದ್ದು ವಿಜಿಲೆನ್ಸ್ ಆಫೀಸರ್ MV ದೇಶ್ಮುಖ್ ಅಂತ, ಅದು ಥ್ರೂ ದಿ ಕಂಪನಿ ನಾವೇ ಮಾಡಿದ್ದು ಅದರಲ್ಲಿ. ಅವನೇ ಡೆಲಿಗೆಂಟ್ ಆಫೀಸರ್ ಇಸ್, my lord, as a next, my lord, the exhibit
Read the question again.
is, my lord.
This is a question put to the MW3.
Please, please.
No, I say that handwriting, this is a suggestion, not a question.
Please, next,
Say that handwriting bill marked as exhibit M4.
M4
I have neither signed nor given any endorsement.
endorsement. The
Amount
amount
claimed
claimed through the expense report of the June 2011 marked as the exhibit M1 is totally different than the amount mentioned in the alleged bill submitted by you. Hence, the bill produced by you was not submitted by me.
Yes, what is the answer?
Regarding, my lord, the exhibit M4 was handed over to me for investigation by management along with exhibit M3.
The management witness ಬೇರೆ ಯಾರಿದ್ದಾರೆ?
Please, my lord.
Who is the other management witness who was examined?
Please, my lord. The next, my lord. Next question 7, my lord. I say that when you submitted exhibit M3A, you knew that it was not my bill.
My role was only investigation authority. Andre ಅವ್ರಿಗೆ ಒಂದು investigation ಕಳಿಸಿದ್ದಾರೆ regarding that, my lord. My submission is whatever bill I submitted, my lord, that is not accepted by the management authority. And
Now this man's, he's the investigating officer.
please,
A bill was handed over to him.
please.
It was marked as Exhibit M4. He said only the bill was given to me, based upon which I started my investigation.
Please.
You put a question to the investigating officer saying that this is not the bill which I gave. How would he know?
So
So
regarding
ಯಾರಿಗೆ ಕೇಳ್ಬೇಕು ಪ್ರಶ್ನೆನಾ?
now ಕೇಳಬೇಕು.
ಯಾರಿಗೆ?
Please. Those who are, my lord, management is concerned, we have.
So therefore MW1 ಯಾರು, MW2 ಯಾರು, ಅವ್ರಿಗೆ ಏನ್ ಪ್ರಶ್ನೆ ಕೇಳಿದಿರಾ?
Please, my lord. MW1, my lord. Annexure, my lord.
MW1 is annexure, page 38.
38,
ಏನ್ ಕೇಳಿದಿರಾ?
28, my lord. 28, annexure F.
ಓದ್ ಏನ್ ಕೇಳಿ?
My name, Basuraju, designation as a manager, marketing. I have worked as working in the pharma marketing department to management's company. I have been worked as a field administration section, said department since October 1997. As manager, I will take entire field administration of pharma marketing consisting on field employees instructions, either their confirmation, their promotions, transfer resignations, settlement of the accounts after resignation, field employees remittance in the terms of salary, service benefits, expense report, providing all necessary administrative materials like statutory, visiting cards, detailing back analysis of the report in return from the field employees, maintaining the important records in employees, etc. I have been processed the expense report of the pharma field employee also. That is, my lord, he is given, my lord, witness to regarding given, my lord, in respect of the inquiries concern. My respectful submission is, as per my lord, ground number 10, my lord, clearly say that, my lord, whichever, my lord, the competent authorities, my lord, that showrooms persons, they are not been examined. ಅದನ್ನು ಕೇಳಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. Next, my lord.
The matter is very simple.
Please.
ಮೂರು ಬಿಲ್.
Please.
ಒಂದು 1261 ರೂಪಾಯಿ ಒಂದು, 1000 ರೂಪಾಯಿ ಒಂದು, 299 ರೂಪಾಯಿ ಒಂದು.
90 ರೂಪಾಯಿ.
ಮೂರು ಬಿಲ್ ರಿಯಂಬರ್ಸ್ಮೆಂಟ್ ಕ್ಲೈಮ್ ಮಾಡಿದ್ದೀರಾ?
Please.
ಮೂರು ಬಿಲ್ ಅಲ್ಲಿ 2 ಬಿಲ್ ಅವ್ರು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಒಂದು ಬಿಲ್ 1000 ರೂಪಾಯಿ ಬಿಲ್. That is doubted.
Please.
Inquiry is conducted. In the investigation, it is revealed that this bill is fraudulent. Proceedings are initiated against you. What is there to show that, number one, you did not file an application claiming reimbursement of this 1000 rupees?
Please.
Number one. Number two, what is there to show that this 1000 rupees bill that was given by you was in fact not given by you? Yerade.
That regard, my lord. Please. I have to next week, my lord.
ಇಷ್ಟೆಲ್ಲ ಓದಿ ಇಷ್ಟೇ ಇರೋದು.
ಅಲ್ಲಲ್ಲ, respect of my specific contention is, my lord, whatever bill I submitted, my lord, the given
ಕ್ವಶನ್ ಯಾರನ್ನ ಕೇಳಿದೀರಾ? ನಾನು ಕೊಟ್ಟಿದ್ದು 2 ಬಿಲ್ ಅಪ್ಪ. ನಾನು ಸಬ್ಮಿಟ್ ಮಾಡೋದು 2 ಬಿಲ್ಲು. ಇದು 3ನೇ ಬಿಲ್ ನಾನ್ ಮಾಡಿಲ್ಲ.
Please.
ಅಂತ ಯಾರನ್ನ ಕೇಳಿದೀರಾ ಅಂತ ಕೇಳಿದೆ.
Regarding, my lord, the management witness is.
ಯಾರನ್ನ ಕೇಳಿದೀರಾ?
Management witness, my lord, Basuraju, M. Basuraju.
ಎಲ್ಲಿ ಕೇಳಿದೀರಾ?
Kindly see, my lord.
You are reading the evidence, entire evidence.
Please. M. Basuraju ಅಂತ ಇದೆ ಅಲ್ಲಿ page 31.
Yes.
Cross examination ಶ್ರೀ BM Basuraju MW1. ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಇದೆ ಅದು.
1000 ರೂಪಾಯಿ ಬಿಲ್ ಎಲ್ಲಿ ಕೇಳಿದೀರಾ?
ಅದನ್ನ
ನಾಯಕ್.
Please.
1000 ರೂಪಾಯಿ ಬಿಲ್ ಬಗ್ಗೆ ಎಲ್ಲ ಕೇಳಿದೀರಾ?
That has been not, my lord, specifically.
ನೀವು ಫೈಲ್ ಓದಿಲ್ಲ, that has not been asked ಅಂತ ಹೇಳ್ಬಿಡಿ.
Not Deshmukh is, my lord.
Not read the file.
Regarding, my lord, Deshmukh, my lord, one of the vigilance officer, they have given a report to that inquiry. Page number, my lord, M3, annexure H, page number 52.
Please come to page 36. Question number 22 ಓದಿ.
Please.
21 and 22.
Can tell, son, please, can
can you tell me what the total amount written in the Bata bill furnished by the management at serial number 3 of the list of documents dated 23/7/2012? It is rupees 1,299 rupees. At the stage, this
Next question was,
Please.
page 38 ಓದಿ.
Please, no, 37, my lord. 37, my lord.
37 ಏನು ಇಲ್ಲ ಅಲ್ಲಿ.
Please, my lord, ಮೇಲ್ಗಡೆ,
ಓದು.
please. 38, my lord. Question number 1, you have stated that you are processing the voucher attached with the expense report, and you have verified all vouchers attached exhibit M2. Therefore, it is true that you have also verified the exhibit M4. What do you say? Yes, it's verified. The question number 2, my lord, you have stated earlier that you process the vouchers and release the payment if you fulfill other condition like date, amount, name, store, etc. Will you please inform in which store name and address you have been processed in the payment of exhibit M4? Both address is mentioned at exhibit M4. The kindly state how you can justify the statement approving the vouchers, both address which is stated two different places. Usually when the address change, the printed bill is being rubber stamped with new address. Accordingly, bill has been considered. I say that your statement given now is totally false and baseless because any voucher cannot be
ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ
asked for.
ಯೋಗೇಶ್.
Please.
Learn counsel for the petitioner seeks time. Learn counsel for the respondent is absent. ಯಾವತ್ತು ಬೇಕು?
Next.
ತಗೊಳ್ಳಿ, ಯಾವತ್ತು ಬೇಕು ಡೇಟ್? You should make the argument interesting. ಏನೋ ಸ್ವಲ್ಪ ಮಾಡ್ರಿ, ನಮಗೂ ಡಲ್ ಆಗುತ್ತೆ, ನಿದ್ದೆ ಬರುತ್ತೆ. ಬಂತಾ? ಈ ಬುಧವಾರ. Next ಬುಧವಾರ. 12th and 13th ರಜಾ ಇದೆ.
ಅಪ್ಡೇಷನ್ ಎಲ್ಲ ಈ ಕಂಪ್ಯೂಟರ್ ಆದ್ಮೇಲೆ ಅವರು ಮಾಡ್ತಾರೆ ಸರ್, ಕೈನಲ್ಲಿ ಮಾಡ್ತಾರೆ ಸರ್. ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ ಅಂದ್ರೆ ಇವಾಗ ನೋಡೋದು ಹೆಂಗ್ ಸಿಗುತ್ತೆ ಇವಾಗ